Good morning and welcome all. The time now is 3 minutes past 10 a.m. We do apologise for the late start. I would like to formally open the specific issue hearing 6 for the Mooir Vannin offshore wind farm project. Just before we introduce ourselves, just a few housekeeping matters. Can everyone in the room hear me at the back? And are we live streaming and recording? Okay, thank you. Can I just request everyone present in the room to turn their devices and phones to silent? Toilets are to my right through the double doors, and there are no planned fire drills today. So in the event of an alarm, please leave the building by the nearest fire exit and collect in the car park. On to panel introductions. I'm Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act 2016, or MEMA for short, to chair the panel of examiners for this application. I confirm that I've made a conflict of interest declaration as part of my appointment, and I'm a chartered member of the Royal Town Planning Institute, which means that I'm bound by their code of professional conduct. My declarations of interest and that of my panel colleagues were discussed at specific issue hearing 4, public meeting 2 held on the 11th of May, and specific issue hearing 5 held yesterday. Anyone who wishes to do so may review the published recording for those events. I will hand over to my fellow panel members to introduce themselves. Ms. Fernandez.
Morning, everybody. Nice to see you again today. My name is Frances Fernandez, and I'm a panel member pursuant to Section 27 of MEMA. I confirm that I've made a conflict of interest declaration as part of my appointment, and I am a fellow of the Royal Town Planning Institute, which means I'm bound by their code of professional conduct, which frames my conduct in this examination. Thank you.
Good morning. I'm Amanda Pownell. I'm a panel member appointed pursuant to Section 27 of MEMA. I can confirm that I have made a conflict of interest declaration as part of my appointment. I'm also a chartered member of the RTPI, which means I am bound by the professional code of conduct in the same manner as it does to other panel members, and frames my conduct for this examination.
Good morning, everybody. My name is Mr. Smith. I am a panel member appointed again pursuant to Section 27 of MEMA, and I too confirm that I made a conflict of interest declaration as part of my appointment, and am also a chartered member of the Royal Town Planning Institute, and am bound by its code of professional conduct in the same manner as it binds my colleagues. It frames my conduct in this examination.
Also present are members of the Cabinet Office case team, notably Mr. Tom Randall, who provides procedural support throughout the examination process. Audiovisual service is provided by Energy Media Limited. I will just say a few words about the format of this hearing, the use of personal information, and the general conduct of proceedings before I hand over to Ms. Pownell to lead the rest of the topics. Today's meeting is being undertaken in a hybrid way. Some of you are present with us at the venue, and some of you are joining us virtually through Microsoft Teams. Some of you have chosen to watch the live stream. Additionally, a recording of today's meeting will be made available on the MEMA website as soon as practicable after the meeting has finished. With this in mind, please ensure that you speak clearly into a microphone, stating your name and the organisation you're representing, if relevant, each time before you speak. If you are not at a table with a microphone, then there are roving microphones, and please wait for one of them to be brought to you before you start speaking. Just a few words now about personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything you do say will be included in the published recording. Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulations 2018. Further information relating to data protection can be found in the Cabinet Office's privacy notice, This was included in our Regulation 32 letter of 6th of February. If you have any questions on this matter, please contact Mr. Randall. Just a few words about the statutory framework of the hearing. Under Section 31 of MEMA and Regulation 31 and 34 of the Marine Infrastructure Consenting Process Regulations 2024, the examining body can hold specific issue hearings if we think that a certain matter needs to be explored and principal stakeholders need an opportunity to state their case. The examination under MEMA is an inquisitorial process, and if it is for the examining body to lead the questioning in order to test the evidence before us. For the purpose of this hearing, we will not allow cross-questioning between parties. So if parties consider that further points need to be explored, they should indicate this to the examining body, and we will decide whether those matters should be pursued. While we will pursue some of your questions at this hearing today, some might be explored later through written responses from the applicant. Today's hearing is Specific Issue Hearing 6 on environmental matters and will be led by Ms. Pownell. I will now hand over to her.
Good morning, everybody. So this hearing builds on the issues discussed at Specific Issues Hearing 2. It looks at the matters that were not fully discussed or resolved at that hearing, and it brings together the outstanding issues from the hearing and the resulting written questions and further information provided at deadline 1, 2 and 3. I really want to thank everybody for providing information at those deadlines. It's a lot of information. I know the deadlines are quite tight, so we're very grateful, and it's all been read. Agenda item 1 is seeking a broad overview of progress made on the topic under uniquely Manx, which I think really spans the EIA and the topics in it. It's partly on the agenda because the statement of common ground was a little thin between DEFRA and the applicant in terms of content. So it was a little hard to determine at what stage the negotiations and discussions are. So I thought it would be good to look at a broad overview of where things are at. So I hope that that's okay. So if an issue's been resolved, then we can understand it's been resolved and then move forward with the other issues that remain unresolved. So it's a difficult topic because it spans all of the topics within the EIA and they're all interlinked. So I thought we'd start with a broad overview, and where those topics are discussed in greater detail throughout the agenda, then we can look at those in more depth. But it helps to have sort of a good helicopter view. Agenda item 2 is the protected sites assessment. Can I just
check? That first item would be agenda item 3, so this...
Oh, I'm sorry, I've got the numbers wrong.
Apologies, is agenda item 4.
Okay. Thank you very much. The next agenda item is the protected sites assessment, and it's a new agenda item because now we've been through the legislation, policy, all the more detailed issues. It's good to have a look at what the PSA has actually done and concluded. It brings together all the other topics. So for that item, while some topics will probably be better served by written questions, it all knits together to give an overall view. So I hope you'll bear with me as we sort of churn through the infrastructure that support that assessment. For context on that, the examining body published a Regulation 31 letter on the 8th of May, which states that to all principal stakeholders that the XB has made a non-material change request for the applicant, and the examination will go forward on that basis. So that means for everybody that the southern alignment will now not be the topic of a consideration for the examination. I think that's important in respect to some species. The geology and geomorphology in marine water is also a new hearing agenda item. And there are some technical nitty-gritty details on methodology, but principally because a lot of the sediment outcomes affect benthic ecology and fish ecology. So it's really important that that assessment is robust in terms of the underlying premise for those other two topic areas. The other topic areas follow the general principles of the agenda. So we have benthic ecology looking at the key issues, but I think the baseline issues are still important for DEFRA on that, the baseline survey. And then in that respect of what has and hasn't been surveyed, the mitigation and monitoring plan in place. For fish ecology, I think is the herring mitigation plan. That's mainly, as far as I can make out from the SOCG, a topic of discussion still. And on ornithology, the foraging distances, how things have been assessed in terms of magnitude and sensitivity, and also bats. I put bats back on the agenda because I wasn't sure how much progress had been made on that topic. The last one, which we really do need to get to, is marine mammals, and because of the new results, or the updated Level B harassment assessment results, which appear to put more marine nature reserves within the impact area of marine mammals, I think it's really important that we get to that, and I gave it a long space at the end. So I'm going to do my best with the agenda. There's a lot to get through, and so I will try and pile things into written questions where we get to technical detail, but it would be really good to get to the end of today with some overarching principles, premises agreed across the table, or at least the train in place for the work that needs to be done to get them agreed. So I hope everyone's comfortable with that. If I move on to introductions, if I go through the various people at the table, starting with the applicant and then with the government organisations, and then we'll turn to the floor, to the people that have registered that would like to speak, and we'll look at which items you want to speak to. Is that all right with everybody? Yeah? So if I turn to the applicant, if they'd like to introduce themselves and tell us who's present.
Yes, thank you, Madam. My name is Amy Sterling. I'm a partner at Pinsent Masons, and I'll be representing the applicant today. I'm joined by various colleagues in the room and online, who I will introduce just briefly. On my left is Mr. Ryan McManus, who's the Offshore EIA lead at Gobi Consultants, and Mr. McManus, I expect, will be doing most of the speaking today. And then further to his left are Miss Hannah Towner-Voter and Dr. Julian Carolan representing the applicant. Online, we have Miss Simone Pfeiffer of APEM, who's our fish ecology expert, and we also have a Mr. Freddie Leith from APEM.
Sorry, could you just, the people online's name, sorry? If you could just
Miss Simone Pfeiffer.
Simone Pfeiffer, yeah.
Is from APEM, and she's for fish ecology expert.
Okay.
And also Mr. Freddie Leith from APEM, who's our ornithology expert.
Freddie Leith, he's the ornithology.
Yes.
And then Mr. McManus will cover all the other topics. Perfect.
Yes, that's correct.
Thank you so much. Okay. If I could just turn to the government organisations then, please, starting with the gentleman on the end of the table, if that's all right.
Peter Duncan, representing DEFA. I'm the Senior Marine Environment Officer at DEFA.
Thank you so much. Mr. Mill?
Yep, Ken Milne, representing DEFA. I will be joined by various colleagues, technical experts throughout the day as well.
Okay.
I'll introduce as we go along.
Okay, thank you so much. And the colleague on your right?
Mr. Garden's got his hand up on.
Oh, sorry, Mr. Gard's online. I'm so sorry.
Good
Are you there?
morning. So I am. Hopefully you can hear me.
I can now, yes.
Great.
Hi, Mr.
Thank
Gardner.
you. Yeah, good morning. So Robert Garden on behalf of the Department of Infrastructure. And with you in the room today, you've got Emma Rowan, who is the Senior Infrastructure Policy Officer, and also Ian Brooks, who's the Legislation and Policy Manager. Thank you.
Thank you so much. Brilliant. Is there anyone else online then? That's everyone online from the government. Take it as a yes. So sorry. Carry back to the table then. Is there anyone else that's not been introduced? No. Okay. If we go to the floor then, please. I have a number of people that have registered to speak. So if you'd like to put your hand up, the microphone will come to you and you can introduce yourself if I just call off the list, if that's okay. So we've got David Beard from the Manx Fish Producers Association. Microphone, introduce him. If you just tell me which item you'd like to speak to, Mr. Beard, that'd be great.
Yeah, David Beard, Manx Fish Producers. I don't know which item I'd like to speak to at the moment.
Okay.
It's just how the discussion develops.
Perfect.
And if I'm needed at all. So.
Okay. If you just raise your hand when you'd like to speak then at an item, that'd be perfect.
Thank you.
I've got Kevin Wells from the Manx Bat Group. I take it's just ornithology. I appreciate.
Actually, it's not ornithology. Bats aren't part of ornithology.
I was just going to say that. I know your comment made in the invitation. Yes, I appreciate that. It seemed the best slot to fit it in,
Yeah.
but I appreciate they're not birds.
I'm here to represent the Bat Group and talk about the Statement of Common Ground.
Perfect. Okay. And Ben Collier? Is he present? No. Online? You online, Mr. Collier?
Yeah, good morning, Mar. Ben Colley, Northern Ireland Fishermen's Federation, and I would like to speak on agenda item 7.3 today, please.
Okay, thank you very much. Mr. David Bellamy? I think you'll probably want to speak to a number of generators, won't you?
Thank you, David Bellamy. We're largely here as Maxwell Law Trust to answer any questions that the panel may have today. But specifically, we want to raise just two new areas of information that have come since the last hearing.
Okay.
And that's, very briefly, the blue carbon report.
Yes, I saw that from Garth.
Yep, and the creation of 3 new shark and skate and ray important areas of international importance in the Irish Sea.
Okay.
Thank you.
Would you like to come to the table? Because I think you're probably principal part of most of the discussions.
Thank you.
Would that? Yeah. Okay. I've got Lara Howe from. Are you going to support your colleague? Yeah. Okay. And members of the public. I've got Dr. Ronnie Parr, who is online, maybe.
I am indeed. Good morning to you. Dr. Ronnie Parr from Mark Oil and Gas.
Okay.
I'd like to talk about new hazard, probably at the end of section 3, Manx-specific, Manx unique issues, if you don't mind.
So which agenda item is that? 3.
Agenda item 3, yes, okay. If you please.
And Alison Stafford? No. Ian Stafford? Sarah Wells? Zara Lewis? Patricia Newton? Is there anybody else that has registered to speak that I haven't called out? Okay. So if we move then to the first agenda item. Please do raise your hand if I miss and you'd like to speak to agenda items so that I'm aware. So if we move on to the first agenda item, which is the uniquely Manx approach to assessment. Is it all right if the applicant just gives a summary of progress? Would that be all right? Then we can take it from there.
Amy Sterling on behalf of the applicant. I'll give a brief summary and then
Okay.
if any further information is needed, Dr. Caroline can
Perfect.
provide information. I think just for context, the applicant wishes to repeat its distinction between what it referred to as uniquely Manx and what the term may be used now for an examination.
Okay.
The applicant coined the term uniquely Manx to identify certain areas in the preparation of its application that it considered were best practice for an Isle of Man application, such as, for example, combining commercial fisheries and fish ecology into a single EIA chapter, carrying out a more proportionate approach to EIA,
Yep.
carrying out a navigational risk assessment rather than an EIA approach to shipping and navigation, which was sort of broadly discussed. I'm not sure anyone disagrees with how the applicant
Agreed.
has coined and used that term. What the applicant has been clear that uniquely Manx is not is a deviation from the standard approach to EIA assessment. Okay. The applicant has taken the approach to EIA that is common on a topic by topic basis across the relevant industries, including, using UK practices as best practice. So the applicant's position isn't there isn't a uniquely Manx approach to the EIA within the assessment. Now, others may have the view that there should be, and I think those come into sort of later agenda items. But as a sort of general principle, the applicant's position is there is no uniquely Manx approach to EIA.
Understood, yes. I think you explained that last time. I think Dr. Caroline explained that last time. Okay. So if I could just summarise then, perhaps we're looking more from the perspective of testing the EIA to see how local species have been classified in terms of sensitivity, to see how the temporal and spatial scope has been placed, and to look at the outcomes. Is that a more reasonable assumption of where we're at?
Amy Sterling on behalf of the applicant, yes. And any more specific detail on that, I'll hand to Dr. Caroline.
That's perfect. So I think if I've got a broad summary of where I think we're at based on D1, D2, D3, written questions, as an overview, and some key actions that I'm hoping might help in terms of providing that broad overview. And so if I just start with that, I think I will ask you to comment, DEFA, after I've run through what I think is still on the table. It's a very simplistic, high-level summary, so please don't misunderstand. There are also details underneath that we need to look at. So, for mammals, the local assessment using local data and local characterization along the lines of a digital area survey, like a DAS survey, versus the more global approach. Categorization of mammals and the amended level B harassment and the zone of influence and how that changes depending on the basis of that harassment. And also the fact that that brings in, I think, for disturbance from piling, Douglas Bay, rhesus and bottlenose dolphins, Laxey Bay, bottlenose and mink whales, and Langness rhesus dolphins. So that's on the table. Fish, the categorization of receptors and allocation of the level of importance at a national level versus a local level and a regional assessment, primarily in the relation to the management of fish resources and how fishing is done in the Isle of Man within the Isle of Man scope, not international waters. Benthic, the use of local data such as Sea Search and the Manx Recording Partnership, which I think Manx Wildlife Trust have brought to the table, and the Bangor University M&R survey. The sensitivity for benthic receptors using only Marisa, with no adjustment for nudibranch, and the value of importance of manch species. For example, horse mussel, which is not classified under Marisa, which is a separate species. For birds, the cumulative assessment against the Isle of Man population, foraging distances and how they fill the gap. And this comes up quite a lot, the choice of where you've got two alternatives in terms of your significance outcomes. Sometimes the lesser one is chosen. Is that a reasonable broad overview of where we're at? If I go to the applicant, or perhaps DEFA first, is that a reasonable reasonable assumption?
Yeah, Ken Milne representing DEFA. I would say it's a reasonable summary of the place. I'd just sort of add to it, it's not the assessment per se that we've got an issue with, it's that method of the methodology, it's the definition of the terms of magnitude and sensitivity for a number of different receptors.
Okay, perfect. Applicant, is that a fair summary of where we're at?
Dr. Kieran, on behalf of the applicant, yeah, that's a fair summary. I think just in general, in an overview, our understanding of where we are is that most of all of the comments relate to the application of the DMRB assessment across the board and the definition of magnitude and sensitivity. Yes. Then from magnitude and sensitivity, there is the assertion that we're downplaying assessment outcomes.
That's correct.
So they are the kind of the three key areas. In trying to address that, we've started with physical processes. So we've just submitted a deadline 3. Yes. So we had a comparative methodology. Yes. So we started with physical process because it's really important because the outputs from that feed through to the benthic, to the fish, to all of the marine assessments. So we took that as a beginning point. We done the comparison with Morgan, Mona, Markham on our Wally Moor because those projects are all in the East Irish Sea and familiar sort of locations, receptors, same environment. So they're the most analogous ones to compare. We looked at definition of magnitude and sensitivity and how that varied across all of the projects. All of those projects applied the DMRB methodology. Yes, so the conclusion from the comparison with the magnitude and sensitivity was that there was some variation in magnitude and sensitivity, but that we were within a range that was the same, and that in most cases actually we were more conservative. We then looked at the assessment outcomes, and the assessment outcomes were broadly comparable. So again, what the conclusion from that was that irrespective of the definition of magnitude and sensitivity, and acknowledging that there was some variation within that, it didn't materially affect the assessment outcomes, and hence there was no evidence to support that we were downplaying assessment outcomes. So that's what was presented to DEFA. We got lost in the weeds a little bit because of the variation of magnitude and sensitivity. I think our position is with DEFA at the end of that meeting, and though it hasn't been confirmed in writing, is to agree to disagree, so that even though that we agree that there is variations in magnitude and sensitivity, that they don't materially change the assessment outcomes, and that we're speaking about non-significant effects. So what we were to do then was to work through those assessments on pathways, where the pathway assessment outcome was used to inform impact assessments on fish and benthic. So there was some variation on some
Yeah.
occasions. We determined that the impact magnitude was negligible, while other offshore wind farms doing comparable assessments concluded that the magnitude was low. Our point was that irrespective of being negligible or low, the assessment outcome would still be non-significant. But we've taken an action. We've got a paper. I'm just reviewing it in between today, and we hope to get that. We have a meeting with DEFA on Friday. So hopefully our position is that we can confirm with DEFA that irrespective of those changes, that there is changes, because they're user-defined changes, that it's not material to the assessment outcomes. And if we can agree that, then hopefully that then closes the door on that, and we can move forward then into the benthic consideration, the fisheries consideration, and hopefully close that out.
So what you're explaining is that you're you're discussing magnitude and sensitivity and magnitude and your approach, and you're coming to an agreement with DEFA, or hopefully an agreement on what that actually is, or an agreement to agree to disagree.
An agreement to agree to disagree.
Yes, well, okay. So it'll be interesting to see your note that you're writing and DEFA's response in that respect. I did have one suggestion. Sensitivity and the application of sensitivity is a theme throughout, and we're going to touch on the PSA and elevated sensitivity for protected species. Would it be a reasonable suggestion to go through the assessment and have a simple table on how sensitivity has been applied to each of the protected species? Is that something DEFA would welcome, or is that... I don't want to cause abortive work, so... I think maybe make a decision later on in the programme, because I think it will become apparent why I'm asking the question when we come to the PSA. Would that be all right? Okay.
Yeah.
And the other question I had was where magnitude has been, where the assessment of significance, as I said, has chosen the lesser rather than the higher, those match, grading. Is it possible to just have a simple table showing where those choices have been made across the assessment, so that DEFA's comfortable with the choice that you've made and why it's been made? I think birds was one of the ones, wasn't it? And minke whale. Minke whale was chosen slight, where there was an option for a moderate significance.
Dr. Karen, on behalf of the applicant, yeah, we'd be happy to do that.
Is that all right?
Yeah.
Just to make it clear where that decision's been made, because that's something you've referred to, Mr. Mill.
Ken Mill, representing DEFA, yeah, that'd be a good suggestion.
Okay. So in terms of a table explaining sensitivity, could we hold that thought? And if I don't remember, please do someone remind me at the end of the day whether that's useful or not, depending on how we work through things. So I think that's the first action, is to have a simple table which explains how the decision's been made, the judgment's been made on the difference. Okay, perfect. So if we move to the PSA, if that's all right, Protected Species Assessment, unless... If I have a hand.
Can you just wait for the microphone to come to you, sir, please?
Yes, my name is James Keggin. I believe my colleague Ronnie Power in Aberdeen was...
Could I just ask if you registered to speak at the hearing?
No, my colleague Ronnie Power has.
Oh, okay.
And he asked to talk in this section, please.
Please go ahead.
Thank you, Ms. Parnell. Thanks, Jim, for that. I'd like to take this opportunity to speak to you in the next couple of minutes about a very significant and unrecognised risk. This specifically is pile driving above a shallow gas accumulation. It is a situation that is unique in both Manx and UK geology. Just a little bit about me.
Mr. Parr, could I just stop you there?
Sorry?
Could I stop you there? This isn't relevant to this agenda today. If you have a particular point to make relevant to this agenda, which is environment.
It is a environmental risk, which would either go in Section 5 under Geology or
I understand.
Section 3.
So just to stop you there, you've raised the risk, and there's been a written question response to that. If you want to introduce something...
There was a response, but it was inaccurate. It was insufficient. And frankly speaking, Ørsted still have not fully understood the nature of this risk. So you can either park it and say that it has been addressed,
no,
or I'm trying to explain to you what the risk is.
I think the issue that we face at present is that there is a set of subject matters on this agenda that we need to work through and make sure that they are addressed properly. That is not to in any way suggest that the matter that you are raising should not be a consideration. The question is simply now or later. I think one of the dimensions of this that we need to resolve is that we did receive submissions in specific issue hearing 4 in relation to oil and gas considerations, and there was an agenda item there where it could have proceeded. I'm conscious of the fact that sometimes the arrangements are not fully transparent to maybe people who aren't used to these types of proceedings. But what I'm going to suggest we do is that we deliberate on this. We will then resolve a written question, and we will provide a mechanism whereby this can come in.
I would actually appreciate... Sorry,
Mr. Parr. We're aware of the submission that you've made and that you'd requested a 40-minute slot to make a presentation. So we're aware of that. However, given the agenda and the hearing notifications that we've sent out, the case officer, I believe, did inform you that there was not going to be an opportunity to do that.
Indeed.
And therefore, what I'm going to suggest that given you are a principal stakeholder, the best means of putting your submission in is going to be a written submission. Now, because you're registered at the hearing, we can allow you to make a hearing submission, so you don't have to wait all the way till deadline 4. However, what I can confirm is that this hearing, unfortunately, is not going to be the place for you to state your case today.
I had a 2-minute submission, and to be quite honest, we would have completed it by now. But if that's your view, so be it.
Thank you, Mr. Parr. Are you satisfied with that, Ms. Palmer? Okay, thank you.
Thank you, Mr. Parr. So if we move on to the protected species, we did ask the applicant to respond to DEFRA's 2 points they'd made as written submissions. Would you mind if I move to the policy and legislation first? Because I think those points feed into the conversation we're going to have after. Would that be all right with you? Is that okay? Yeah. So I'm going to move on to legislation and policy which supports this PSA assessment. And I appreciate that the removal of the southern alignment removes the direct conflict of the southern cable. But now we have the results of the level B harassment assessment for the mammals and also the sediment issues for benthic. So I think it's worth testing the PSA in some depth. So if we go to legislation, it's worth noting that DEFRA in their extension response, D101042, so that all marine mammals are equally protected under the Wildlife Act 1990 wherever they occur in the Manx Territorial Sea. This is largely due to the fairly comprehensive protections for this group under the Wildlife Act. And they state in their consultation response, PCR 177590, that on marine mammals, despite there being no significant effects identified in the EIA, it's an offence to kill, injure or disturb cetaceans under Schedule 5 of the Wildlife Act. The applicant will agree appropriate mitigation measures through processes outlined in the UNMS to reduce significance to neutral. So I just want to explore this a little bit so we're really clear on the basis which we're moving forwards. So Section 33 of the Wildlife Act 1990 states that Section 33 is inserted, MEMA states that Section 33 is inserted into MEMA, into the Wildlife Act, and it states that controlled marine area, nothing in this Act, the Wildlife Act, applies to the carrying out of controlled marine activities or associated marine activities in the controlled marine area within the meaning of MEMA, subject to any contrary provision. Section 9.4 of MEMA separately provides that carrying out controlled marine activities or associated marine activities in the controlled marine area in accordance with the marine infrastructure consent does not require permission, consent or approval under any of the consenting regimes. And then section 9.5 ties it all together, which says provides that consenting regimes includes the Wildlife Act. So whilst the Wildlife Act designates the sites and the species to be protected under the regulations 13.3b paragraph 4 of Schedule 4 of the regulations, the applicant is required to consider the impact on them with particular attention to species and habitats protected under Manx law and provide a report at 9a for protected sites under the Wildlife Act. So we've got this Wildlife Act, its relationship to MEMA, and what the regulations require the applicant to do. So the question is, given section 33A, does the Wildlife Act apply to the construction and operation of Mooir Vannin and the principles of neutral or marine nature reserves, for example, harm to protected species during construction? And that's key to the consideration of the PSA. So I'll ask DEFRA first, their view on this, and then I'll turn to the applicant.
Ken Milne, representing DEFRA. Yeah, we accept that MEMA disapplies the Wildlife Act.
Okay.
We just encourage that it's best practice that the Wildlife Act is considered and, if possible, some requirements put into the MIC so that we have those protections for those particular species and habitats.
The principle is the Wildlife Act disapplied.
Yeah.
Is disapplied. So MEMA is supposed to be a robust one-stop shop for everything. I don't think we're at the stage where, or I'm not under the impression we're at a stage where we can start amending the principles of MEMA through the MIC. So if there are further considerations you want to give to that point, then I suspect that's a written submission. But let me pass to the applicant for their interpretation.
Amy Sterling on behalf of the applicant. Yes, we understood this had been settled at the last hearing. We agree that the Wildlife Act doesn't apply in the context of MEMA. However, the Wildlife Act and the protections afforded to particular species and particular sites have informed the EIA, particularly, for example,
Yes.
value associated with any particular receptor. So that's where I think it still remains relevant. Of course, if they have any specific suggestions about specific mitigations they would like to see for specific species, then that can be considered and, if necessary and appropriate, incorporated into a management plan, which is secured under a requirement of the
what we're
MIC.
testing now.
Exactly.
Yeah. So the point I'm making is that during the construction and operation of Mooir Vannin, the Wildlife Act doesn't apply to the protection of the species in those activities. It comes back to my thorough investigation of the EIA and therefore the focus on the management plans within that EIA to ensure mitigation. And I want to be really clear about that point across the table. Does DEFRA understand the point I'm making?
Yeah, Ken Milne, representing DEFRA. Yes, we understand that point. We accept that MEMA disapplies the Wildlife Act. We understand that.
Okay.
It's the precautionary approach. It's making sure, as you said, the sensitivities and magnitude in the EIA is appropriate.
That's a different point to actually incorporating things in the MIC to support the Wildlife Act. So it's very important that we make that. So I will reiterate again that the outcomes of the EIA and the mitigation in place through the plans is taking place of the protection in the Wildlife Act in this instance. So it's very important that those are robust. DEFRA, did you want to say anything else?
If I may, there was quite a lot of discussion about this application of various primary legislation when MEMA came in, the regulations. As I understood it, and colleagues also, the one-stop shop is the important point there. The disapplication of the Wildlife Act meant that the MIC acted as a broad consent under all of those legislations, but the fundamental principle that the protections were still preserved was still recognised. And so any process or input that DEFRA would have in the application of the Wildlife Act under normal circumstances would be exactly the same as they would be for MEMA and the MIC. And so there is in effect, no difference between whether you apply the same protections through the MIC or whether we applied it through the Wildlife Act.
I understand, but the protections are placed in the management plans. That's
yes,
the vehicle.
that would be the mechanism by which the protections are secured.
So I'm just taking this opportunity to re-emphasise the importance of the management plans and any articles in the MIC, because those are the support.
Absolutely.
Okay, if we move on from this point, if that's all right with everybody, is that okay, Mr. Mill? Yes. Okay. So there was one further point I wanted to make, and that's whether it applies in the mean high water space. And that's in relevance to the MEMA and how how the space is applied. And the DOI have stated that the department does consider MEMA can extend to some offshore elements where these are fundamentally linked to an onshore development and do not extend significantly onshore. So I'm just ensuring the principles accepted that the water space, the mean high space between the low and the high, is also included in this.
Amy Sterling on behalf of the applicant. Yes, that's correct. MEMA extends 250 metres landwards of mean high water. The works that are sought to be authorised under the MIC are the controlled marine activities, which is the generating assets, the submarine cables, and the associated marine activities, which are the landfall works. The Section 9.4 of MEMA says carrying out the controlled marine activities or associated marine activities doesn't require any consent under the consenting regimes. And so given the controlled marine area extends to 150 metres landward, that this application applies within the entirety of that geographical extent.
That's perfect. And also the regulations, Section 7 of MEMA, partly outside. So it includes that, it scopes it in partly outside. Okay, is DEFRA comfortable with that?
Peter Duncan, DEFRA. I would make one comment. I noted that the extension is defined as mean high water spring, whereas, for example, the marine protected areas, the MNRs, actually extend to highest astronomical tide. It probably doesn't make a difference, because if you take it 250 metres inshore, then
I think the point's made. That's thank you very much for that. Noted.
Yeah, and
Mr.
Ken
Milne?
Milne from DEFRA. Just to reiterate, yeah, we understand that everything, it's a one-stop consenting process, and that everything within the order for the MIC is covered within that area.
Okay, perfect. So if we move on then, I'll turn to policy. And I'm sorry, go ahead.
David for Manx Wildlife Trust. We've got a genuine question, if we may, briefly on this topic. While we understand and recognise that MEMA disapplies the Manx Wildlife Act in Manx territorial waters, our question extends to British and Irish waters, where it's also an offence to kill, injure or disturb marine mammals. So our question is really, if this development goes ahead and is disturbing mammals outside of Manx waters, what is the consenting regime within the United Kingdom and the Republic of Ireland in that regard?
So the MMO and the JNCC have been part of this process. They've provided responses to written questions, and I believe their written questions table the subject of an EPS licence, and that rests with the applicant and the UK authorities to work through. Is that right, applicant?
Amy Sterling on behalf of the applicant. Yes, we've exchanged various submissions on EPS licensing, particularly with the MMO. The applicant's position is that UK legislation doesn't apply to works carried out within Manx waters. It's sort of irrefutable. If you read the legislation, they apply to the UK marine area, which doesn't include the Isle of Man territorial sea, and they operate to authorise works carried out within that area. So our position is the EPS licensing regime doesn't apply. Of course, we are working with the JNCC to resolve any concerns they have in relation to the protection of species and any mitigations or management that might need to take place. But the licensing regime doesn't apply outside of the UK waters.
But that process and decision is outside this examination. So I'm just covering for your point that it is being discussed, but not as part of this examination. Thank you. So moving on to policy 4, and the responses from the Cabinet Office, D1132 and DEFRA D1133. As I mentioned yesterday, they say different things. So the Cabinet Office says, my interpretation is that the intention of Policy 4 was to protect any such reserves from onshore development proposals that would have an offshore impact and affect those particularly sensitive areas. Whereas DEFRA say, the principles of the plan may be relevant in the absence of equivalent marine policies as they reflect the thinking and intent in relation to development detecting protected species. DEFRA consider where adverse effects are identified, then Policy 4 should be considered. So I don't want to spend too much time on this, but I'd be grateful if DEFRA and the Cabinet Office could have a think about this, and if they're able to reach a combined note, that's great. If not, then we'll have to take this for consideration. Is that a question for DEFRA? I think the Cabinet Office aren't here today, so.
Ken Milne, representing DEFRA. Obviously, I can't speak on behalf of the Cabinet Office, but yes, we will take that away and discuss with them.
So I think it's a second action then for you to take that away and consider it. Okay.
Amy Sterling, sorry, on behalf of the applicant, if I can just make a comment there. The applicant accepts that environmental policy 4 is relevant to the application, or certainly is capable of being relevant and important to the application.
Thank you.
It's covered in our planning support statement. Obviously, we discussed quite a lot of this yesterday and it's on the agenda for tomorrow, but the applicant is going to do a sort of full sweep of its planning support statement to set out in more detail its suggestions as to the hierarchy of plans that apply in the terrestrial and marine environment, including accordance tables, so that position remains.
The next point is that DEFRA, in their response, R1-1544, it's DEFRA in the Cabinet Office. Thank you. So in their response, R1-1544, DEFRA considered that adverse impact has a wider interpretation than significant impacts and relates to any measurable negative impact. Where these are identified, the applicant must take all practical steps to avoid, mitigate or compensate these impacts to the lowest possible level in accordance with the biodiversity strategy. So, taking into consideration what we've reached on the Wildlife Act and that there are no habitat regulations in force here, I'd just like to ask DEFRA if they consider any measurable negative impact will be captured by an EIA as likely significant effects, or whether they consider Policy 4 requires the applicants to carry out a different assessment.
Ken Milne, representing DEFRA. If we are satisfied with the sensitivities and magnitudes, going back to the initial point, then the EIA should capture it.
Perfect, okay. So we've already covered that point at the beginning. That's excellent, and it's part of your discussions. The last point I wanted to make, I'm sorry to labour this, but it's important as a founding for what we're doing next. We talked about paragraph 786 last time, if you remember, which precedes Policy 4. And the applicant saw that the bullets were mutually exclusive, if you remember. I just wanted to ask DEFRA if they agree that they're mutually exclusive or whether the "and" is important, and I'll read them. The proposed development will not compromise the conservation objectives of the site or unacceptably harm its conservation value and integrity. So the bullet, and the second one is there's a proven public interest where safety or exceptional social or economic considerations outweigh the ecological importance, and the need for development cannot be met in other less ecologically damaging locations or by reasonable alternative means. So I'll turn to the applicant first.
Amy Sterling, on behalf of the applicant. Apologies, madam, I wasn't quite clear on what the question was.
It's whether the "and" is relevant in this respect. I think at the last hearing you implied that they were all mutually exclusive, these bullets, or whether they come as one continuous, applies all. Shall we leave that point? If the applicant would like to have a think about it and respond.
Amy Sterling, on behalf of the applicant. Yes, sorry, I'm just trying to read the paragraph on the hoof. If I can come back to you on that.
I'm just establishing some feedback. I'm just establishing principles here. Is that okay? Perfect. If I just leave that point with you, if you could just respond, and DEFRA could respond also, about whether paragraph 7.86 of the strategic plan, the bullets in there are mutually exclusive or to be treated as one package and continuous. It's an important point. You'll see why I'm making it. Oh, sorry, it's a deadline for action. Sorry. So that's section 3, is it now? 3. I just want to make sure that I'm keeping the numbers of actions so that we know at the end. So onto objectives. The habitat regulations, given its relevant and important in this context, assess the integrity of a site against specific conservation objectives. And the whole process centres around those objectives. For example, on Liverpool Bay, SPA, it includes the extent, quality and availability of supporting marine habitats. It's very specific about the feeding, the nesting and the roosting, and the impact of the development on that. So 2016 plan says, under paragraph 786, the development will not compromise any conservation objectives of the site or unacceptably harm its conservation value. DEFRA submitted 2 documents under written questions 15.4. I just wanted to ask whether you think those are to be taken as objectives, or whether you have alternative objectives that might be used, or whether actually in this circumstance there are no objectives that are applicable for each marine nature reserve.
Peter Duncan, DEFRA. I think we submitted them on the basis that they were the objectives.
Okay. Could I then ask, rather than labour the point, the applicant and DEFRA to look at the documents that DEFRA have submitted under that written question and reach a conclusion whether they are suitable objectives for assessment of each marine nature reserve? I think it's the nature reserves we're primarily talking about here. Is that action 4? Yeah.
Amy Sterling.
I think as part of your SOCG discussions, if you come up with your revised statement of common ground.
Amy Sterling on behalf of the applicant. I can pass to Mr McManus, who I think has some initial observations on the suitability, if you'd like to take them.
Oh, that's
now.
Perfect, thank you.
But otherwise, I just wanted to check a point you said, where you said that the habitat regulations have been agreed to be relevant to this, or important to this examination. I don't believe that's a discussion that we've had, and I'm not sure it is a point that we would agree with, that the habitat regulations are relevant. The context in EIA is relevant because Isle of Man is subject to the ESPO Convention and has its own EIA regime in. It's not subject to, and never has been part of the EU or the Habitats Directive. So I would suggest that it's not relevant and important in the same way that the lessons learned from the UK and EIA are. And I would be wary of just in simple terms of paragraph 786 of Isle of Man Strategic Plan, incorporating wholesale a legislative regime on HRA that doesn't exist here in any form.
That's not what I'm suggesting. I'm suggesting that the way the objectives are addressed within the context of a habitat regulation assessment stresses the importance of them for testing impacts in marine nature reserves in the Isle of Man. I'm trying to explain the importance of the objectives, what they look like and how they work. Yeah. I think the relevance and importance of the HRA regulations within this process, I understand what you're saying, and the examining body will consider that. Thank you.
Amy Sully on behalf of the applicant. Okay, noted. I'll pass to Mr McManus.
Yes. Thank you.
Ryan McManus on behalf of the applicant. So, yes, I think it would just be useful if I just summarise the history of this topic and kind of where we've got to. So from an early stage in the Vannin pre-application, right from the scoping stage and the establishment of the evidence plan process, we recognised that we were going to have to do something, for want of a better term, unique in the Isle of Man, because the designations under the Manx legislation do differ quite a bit, as you've noted, in terms of the conservation objectives. So in the UK, for special areas of conservation, special protection areas, marine conservation zones in England and Wales, and marine protected areas in Scotland, those sites do tend to have features that are the primary purpose of their designation, and conservation objectives typically to restore or maintain favourable conservation status for those features. Those don't exist for the Isle of Man marine nature reserves, which is acknowledged in the high-level conservation objectives that DEFRA have submitted. And just so you're aware as well, those high-level conservation objectives that DEFRA submitted in the examination were provided to us through the Protected Sites Assessment tag process as well. So we were aware of those in the pre-application consultation. It was a point of discussion in developing the Protected Sites Assessment.
So you chose in the assessment the function of marine nature reserves as a whole for the assessment, didn't you? Is that right?
Exactly, yeah. I mean, it took a features-based approach, because in the guidance documents for the marine nature... sorry. Thank you. In the guidance documents for the marine nature reserves, it does include designation features, and it's acknowledged in the guidance that those aren't. It's not intended to be an exhaustive list of all the features, but nevertheless it does provide a kind of a framework for why the site was designated. So we took a features-based approach to ensure all of the features on that list for each MNR were assessed in the EIA, and then the PSA essentially signposts where those assessments are contained in the EIA and draws it all together to consider whether there's an effect on the site overall. And there's no, unlike in the UK, there's no prescribed guidance for how a marine nature reserve assessment should be done, and that was really why we set up the technical advisory group specific to that topic, so that we could do it through consultation.
Thank you, that's really helpful. Could I just so I'm clear, you used functions, but that functions is used the same function for all the protected sites? Marine nature reserve, sorry, for each marine nature reserve, use the same functions?
Brian McManus for the applicant. So essentially what it does is use the outcomes of the EIA. So it assesses whether there is a potential for a significant effect on the feature.
It's not the process, I'm just asking about the actual conservation objective. You use the functions in the process for testing everything against.
What the function of the marine nature reserves, by reading the guidance, is essentially to conserve and protect marine biodiversity in the Isle of Man.
No, I understand. But the point I'm making is that in comparison to, just for reference, the process in the UK, the conservation objectives are quite specific for that specific site. So they give you targets and objectives and measures for that site. So for benthic ecology, if it's a designated feature, then it will give you specific, well, not measures exactly, but the objectives for benthic ecology. But in this case, the marine nature reserve functions for all the marine nature reserves have been taken as the test against the impacts.
Ryan was for the applicant, yeah.
Yeah, okay, I'm just trying to establish the principles. Okay, and so now you're going to have the continued discussion with DEFRA as to whether there is anything else, given the submission they've made. I appreciate you've already had it, but they've made the submission again. You're going to have a discussion about whether there is anything else other than the functions that could be used that's more detailed, I think is probably the word I'd use. Or are we at the position where there are no objectives?
I think we're happy to pick it up under the Statement of Common Ground process, but from our perspective, the protected sites assessment was consulted on quite extensively through the pre-application consultation and has concluded.
I understand it's concluded. It's the objective of the examining body to test the application, so that's the process we're going through now, but I appreciate it. I just wanted to confirm what the objectives are and to test whether there was nothing else that could have been used. Does that make sense? Perfect, okay. So if we just move on then, I'm sorry, go ahead.
If I could just make a point, and I think it's Peter Duncan, DEFRA. I think it's covered in our previous submission for this deadline, but I would correct that the designations for the marine nature reserves are not feature-based. They are spatially based. And so I recognise the challenge in doing it relative to the UK processes, but the marine nature reserves are not a sum of their features. So to add up the features which differ between them is...
We'll come to that point. I understand. That's the combination of the impacts. We'll come to that point. Okay. Thank you. I have a hand in the audience.
Thank you. I haven't registered to speak, Madam Chairman, but if I could just make this point briefly. Martin Perkins, I've a Garth resident since 1980, and I would wish to ask the appellant and DEFRA if, with all these regulations, the EIAs and all the rest of it, has any consideration been given to the atomic sludge that has been coming out of Sellafield? The Act obviously says to the protected mammals there should be no disturbance mechanically or whatever, but it doesn't cover the food chain that exists on the bottom of the sea and the plutonium-239 is very cumulative. And if these sediments are disturbed, we could possibly lead ourselves into a catastrophic disaster, because the Irish Sea gyre will pick up these sediments and spread them through the Irish Sea. So the question is, has any credence been given to that problem? Thank you, Madam Chairman.
Could I ask you, this is a very important point, could I ask you to make a written submission to the
Yes.
hearing? I think then we'll have the full scope of the issues that you're raising, and it can be given proper attention.
Thank you. By which date, Madam?
I think you can submit it at any time after the hearing.
Thank you very much.
Okay. If there are no questions, Ms. Sanning.
Ryan McManus for the applicant. So just to come back to the PSA point and respond to DEFA about the,
of course, I'm so sorry, I should have asked.
The spatial designation. You know, if it's the case that the marine nature reserves are a spatial designation only, then it's clear that the proposed development doesn't overlap with any of the marine nature reserves, and then so it doesn't impact that. And I think while that response is acknowledged, that there are features that are listed within the guidance documents for each nature reserve. That's why we took that approach.
I wonder if the point was being made that it's a space, it's an area that's been designated rather than a spatial designation. But okay, thank you very much for clarifying. We've got a couple of items to get through. I'd like to just... Is that okay? Yeah. I'd like to get through them before coffee. I'm going to try and focus the conversation, if that's all right, so that we do get through them, and then we can clarify anything through written questions and submissions, if that's all right with everybody. So the interrelated effects. So I think in written question 11567, the applicant says the application considers a range of effects on individual receptors and considers whether interrelated effects may impact a protected site as a whole. But we wanted to ask where that appears in the assessment. I think this is talking about multiple digging and bashing, different types of effects on the same resources. It's not in the PSA, is it? There is an interrelated effect. Sorry, an interrelated effects chapter. So where is that addressed?
Where is the interrelated effects chapter?
No. Where is the interrelated effects on the PSAs addressed?
Ryan McManus for the applicant. So the protected sites assessment itself it takes an interrelated effects approach, because it draws together the effects from each individual topic chapter, which are assessed alone, cumulatively, and interrelated. So it draws together the overall conclusions on each of the receptors.
So I just wanted to think this through. So if you look at tables 54 and 55 in the marine mammals, it lists each of the mammals and the effect on that mammal. Goes through all the different effects. But where does it assess the different effects on the mammals? Does that make sense?
Ryan McManus for the applicant. So this is about the interrelated effects chapter?
No, it's about whether the assessment of interrelated effects on the PSA, I'm so sorry, has happened and where that is. You say to include it in the PSA, it would be double counting. So you say that in your response, it would be double counting. The protected sites assessment collates the impacts on these features from the topic-specific ES chapters. And where there's a combination of effects, then it's reported in the assessment conclusions. So the consideration of interrelated effects is inherent within the PSA, hence the exclusion from the standalone PSA chapter. But I can't see that in the interrelated section either. So I'm just asking where that's reported.
Ryan McManus for the applicant. So the PSA draws together all conclusions of the EIA, including from the project alone, cumulatively, and interrelated. So inherent within the PSA is a consideration of the interrelated effects assessment within the chapter. So that table 8 in the interrelated effects assessment, which essentially concludes that there are no interrelated effects that are of greater significance than when considered in isolation, that assessment and that conclusion is then taken into account in the PSA.
So it's inherent in the assessments, what you're saying. I think DEFRA raised the point in their response that, for example, PTS by underwater noise on the UXO pile driving. Table 55 reports it separately. It's all assessed individually, which is the point I'm making, and that the PSAs are receptor-led, and that we're not clear about how the interrelated effects of multiple impacts are assessed. So it's something that DEFRA's raised. If I go to DEFRA to respond, whether they're comfortable with what has been done, or whether their point is suggesting something different needs to be done. Mr. Milne?
Ken Milne, representing DEFRA. I think it's because there's maybe a bit of confusion between the MDS and the EIA. They seem to state different things. Perhaps that's where the confusion comes in. So the cumulative effect, we're not sure if it's been covered adequately.
I'm sorry, was that again?
Sorry, I think
the cumulative effects we'll come on to in a minute, because I think cumulative is a separate thing. That's the project and other projects in EIA terms, which is what we're talking about here within this. So what I'm talking about is, you raised the issue about, excuse me, different types of construction activity and the impact of that on a resource receptor pathway for the resources and receptors. And I'm asking whether you're comfortable with the way it's been done, which is basically amalgamating all the individual effects into a combined effect and the conclusions. Sorry.
Ken Milne, representing DEFRA.
Would you like to come back on the point?
In principle, we're content with it, but if I could maybe come back and write and just to confirm that.
So as a hearing action, could you come back and expand on the point that you've made about interrelated effects? Why you think they haven't been assessed? If you don't think they've been assessed, how you think they should have been assessed? Yeah. That's a hearing action. Is that number 5?
Thank you.
Hearing action 5, are we? Yeah, okay. I've just been informed that Wi-Fi is not working particularly well. I didn't know that was an issue for the government departments. It is an issue. Is it fundamentally affecting your ability to work at the moment? Or?
Ken Milne, representing DEFRA. We'll carry on as best we can. It's just I'm not getting real-time information from other technical colleagues around about.
I understand.
So
okay.
I can, to my best abilities, I can answer your questions.
I understand. So I think if we proceed, we'll ask a question. There's a busy timetable anyway, and then you can respond in writing after the hearing. I think that's the best way to proceed. Otherwise, we'll. If you could respond to this point in writing, as I've just said, as the hearing action number 5. If you just hold on one moment, I'll find out whether we need to take a recess. We're going to carry on because we've got a lot to cover. I don't think it's worth taking a break now if everyone's here in the room, and if you need more support with the response or more information, Mr. Milne, then we'll just take it that they can take the answer offline. Okay, so if we move to source pathway receptor, if that's all right with everybody. So in written questions 1561 in the response from the applicant, you would say the PSA assesses the impacts on all designated sites where they have connectivity with mobile features, regardless of whether they are in the ZOI. But it appears that where there are areas that are not in the ZOI or in the zone of where they're not in the ZOI, that the nature reserve mammals have not been assessed. So while you say you've scoped and looked at that issue, all the areas that are not in the ZOI, that are marine nature reserves, are not included. So it's almost like a decision's been taken not to include, the source director pathway. Sorry, I thought maybe. So if I give an example, so subsea, so I'm just somewhere else. In the marine mammals chapter, 54, 55 tables show that there's a source protected a source pathway based on an overlap with the ZOI, but there is no overlap, it's been screened out. So could I just ask whether all mammals that have that mobile species have been assessed in terms of that source receptor pathway that are outside the ZOI? I think I've got an example here. So subsea noise from piling is close to but doesn't overlap many of the marine nature reserves on the east coast, excluding Laxey, which is screened in for disturbance from piling. But this means that for those sites, piling has been screened out for all species. For example, Douglas Bay, and I appreciate the southern line has been withdrawn, it's the principle that we're talking about here. Douglas Bay is designated for rhesus and bottlenose dolphins. It's 14.7 kilometres from the proposed development. Following the applicant's methodology, even if the ZOI does not overlap, and it doesn't, it should have been assessed. Does that make sense? Am I explaining it very clearly? Sorry, a lot of information there. Applicant, if you'd like to respond.
Ryan McManus for the applicant. So, yeah, I think there's kind of two parts to this. So,
okay.
Firstly, all of the marine nature reserves are screened in for all mobile features.
Okay.
Into the PSA. Those are assessed, I guess, in two ways. One is whether the zone of influence of the impact, so in this case noise, has a spatial overlap with the designation, which varies.
Theoretically, physical overlap, you mean?
Of the zone of influence. So
yes. Okay.
Noise extending from the proposed development area outside into adjacent marine nature reserves on the East Coast primarily.
That overlap, so I'm just going to be clear here.
So that's overlap.
Overlap the ZOI.
Overlap
so
of the ZOI with sites.
Okay.
So that's in one way that it's considered.
Yes, of course.
The other point is about connectivity, because marine mammals are mobile species.
That's the point I'm making.
So a site which is on the west coast of the Isle of Man, which has no overlap with the zone of influence, but is still designated for marine mammal features, those features are part of the wider population, which is assessed in the EIA. So it's assessed in kind of those two ways.
So you're saying the ones that are not in the ZOI, those mobile species are assessed as part of the EIA, but not as part of the PSA. Is that the principle we're going on here?
They're still assessed in the PSA. Yeah.
Are they? Okay. Okay. Could you clarify that for me then, please? Because it appears from the work that we've been reviewing that might not be the case, and I may have completely misunderstood. So are you able to take that away and clarify for me? Would that be all right?
Ryan McManus for the applicant. Yeah, we're happy to look into this. Yeah.
Thank you so much. Just to do a check.
Yeah.
Okay, perfect. So that's hearing action 6, I think, that the applicant will go away and confirm that mobile species that are a designating feature of a marine nature reserve are covered in the protected sites assessment. Okay. Does DEFA or Manx Wildlife Trust have a response to that? Anything else to add? DEFA? Would you like to take it away? Or?
Yeah, Ken Milne representing DEFA. Yeah, I think we'll have to take that one away as well.
Is that all right? So another hearing action that DEFA will also consider the point, because you've raised it in your consultation response. So DEFA will also investigate whether they're comfortable that mobile species have been assessed as part of the PSA where they're not in the marine nature reserve or the overlap of the reserve with the zone of influence.
Yeah, please.
Okay. So moving on to combined effects, if that's all right with everybody. I'd like to get through this before coffee, if that's okay. So combined effects is basically the assessment, as I understand it, and you've just explained, has gone through and looked at the effects in the individual EIA chapters, and then they've literally combined them, no analysis, but combined them to say if there's no impact or no significant impact on those species, then there's no impact on the MNR. It's just literally a logistical process rather than an analytical one. Is that fair? Okay. So there's two aspects to this. The methodology says that protected species will be given a high value, elevated sensitivity. So that's why I was going through this point at the beginning of the hearing. So the theory is then, in the absence of an alternative process, and I mentioned the habitat regulations process just as a comparator, because there is no habitat regulation process, the applicant has made the decision to give protected species an elevated status in the EIA assessment, so that then works through into the protected species assessment. That's the theory, isn't it? So this comes back to my question earlier in the hearing. Can the applicant do this simple table which explains how the protected species have been given this elevated status, which then emphasizes their importance and recalibrates theoretically the impact and the level of impact? And I'm just going to mention a couple. So sea trout is a feature of Santon Gorge and Port Soldrick. Is it ASSI, which is assigned regional importance and low sensitivity. No designating benthic species, and I appreciate the southern alignment's been withdrawn. It's the principle I'm looking at here. We're given elevated sensitivity. I think Beaumont's nudibranch was readjusted, wasn't it, subsequently? So I think that was, you reviewed that, I think, okay. And we'll come on to benthic later. I know that's not your area. Sand eel were assigned a regional importance, not a national. I think that's been changed now, hasn't it? Red-throated driver, herring gull, great black-backed gull, a medium sensitivity, but because the links are low, medium sensitivity because the links are designated as a low, but they are designating features. So I just like the applicant, which I've already made the request, to go through so that Manx Wildlife Trust and DEFRA are really comfortable with the elevated sensitivity for the purposes of the protected species assessment. Does that make sense to everybody? Is everybody comfortable with that? Okay. So let me move on to how it was done. So as a comparator, the HRA screens out pathways with no credible assessor, a receptor, assesses remaining for links with the objectives, which is why the objectives are so critical in this process. It looks at whether the identity, the integrity of the identity is affected, applies mitigation. And then if there's even one that fails that test, then you move into a different process of derogation, IROP, mitigation, compensation. So the principle of processing all the significant effects into one pot and deciding whether the impact on the PSA is significant or not, that's really not an appropriate term, but because it's not, but it is a process. So it does come back to being comfortable with sensitivity, magnitude, how the significance has been applied, how the sensitivity has been applied. Because the process the applicants provided relies on those definitions and terms to effectively make a success of the protected species assessment. Is that fair? And so then also alongside that, the objectives become critical because we don't have the HRA process. So the strength of this process lies in the elevated sensitivity and the objectives. Is everyone comfortable with my summary of where we're at and what's going on here? I see people nodding, not nodding, no comments. Okay, so I think we come to a point where it would be really helpful if the organisations around the table provide a response on my summary of the process and whether they think it's appropriate. Probably not the right word, but I would like their comments on my summary of the process. I think that's probably a better way of phrasing it. I think the applicant can respond if you like, but I think you're in agreement with the way I've summarised the process.
Amy Sterling, on behalf of the applicant, yes, I remain inherently uncomfortable with the HRA comparison, but I understand the point that you're making and that the sensitivity and magnitude for EIA are ultimately fundamental to the PSA. I would just repeat what Dr. Caroline was referring to earlier, is that essentially this shouldn't become an academic exercise, and that the examination process should be focused on, the likely significant effects, the key issues. And so, for example, if between the applicant and DEFA, one which is negligible and one which is low, but the outcome would remain the same for the purposes of the EIA assessment, is probably not a useful use of examination time, but I think we're on a good trajectory to resolve that and the agree scenario, so that would then flow through to the PSA.
Okay, I think the point's noted. I think the importance of the protected sites is inherent in the process, and so I think it's important to test how they've been assessed and whether there are the helpful tools to inform that assessment process or not is also a point that I'm working through, because you can only work with what you have in your toolbox, basically, and I think that we're talking about that. So I think, so a hearing action is for Manx Wildlife Trust and DEFRA and the applicant, if they choose, to comment on my summary of the process and their observations of A, how it has been undertaken by the applicant, and B, on the process itself. Given my work through of the role of the objectives that you have, and the absence of a legislative process because the Isle of Man has not signed up to the habitat regulations. I think that's very important to inform the examining body on how it's been done and where that lands us.
Amy Sterling on behalf of the applicant. I think it would be useful for the applicant for Deadline 4 to package up how we got here and how the methodology essentially for the PSA, the discussions that were taking place between the applicant and DEFA as to how the PSA should be carried out in the absence of any legislation or guidance. I guess it's not the case that the applicant just went and did a PSA of his own accord and made up a process. This was discussed extensively with consultees during the pre-application process.
I think that would be very helpful. And as I said, you can only work with the tools you have in your box. And I think the applicants made best endeavours to work with those tools. So any history on the process, any background would also be extremely important. That's very helpful, thank you. Is everyone clear on that?
Perhaps we could ask DEFA to summarise what the ask has been of them by Ms Pownall. And then we'll understand if there is clarity, because I'm not quite sure that there is clarity.
Ken Milne, representing DEFA. We'll obviously have clarity when we see the actual action we've got specifically to us, but it sounds like the sensitivities, and so on will be put into that table for us to have a look at, and to make sure that try to summarise this. The HRA, those key ones, are make sure they're captured and given consideration under the flows through from the sensitivities magnitude into the PSA analysis to make sure we are capturing as much as possible of. I'm sorry, I'm rambling a little bit here, but yeah.
I think what I'm saying is that. Yes, you can comment on please do comment on the table of sensitivity, how the elevated sensitivity has been applied and whether it's been applied to the right species and in the right way. So that's the first step. Whether you agree with the choices of moderate minor, moderate major in the table of assessment of significance. Whether you agree that the applicant has followed the process they said they would follow. Follow the process they have created as the applicant says, in the absence of legislative framework and policy. So whether you agree with the process they've created, and I think the applicants are going to provide the history of your discussions to support that, and whether you think they could have done anything else. Okay, and as part of that, to discuss conservation objectives and whether what you've provided in the 2 documents you provided at the deadline are possible of being used as conservation objectives or not. If they're not possible, it's not possible to use them, what you think should have been used as an alternative. We can set all this out in the hearing actions, it's not a problem. I'm sorry, I think.
DEFA, did you want to come back on that? There's quite a lot in that. And what I'm trying to understand is, are these areas of disagreement or are they not? And I guess that's what you're trying to seek confirmation of. But DEFA, has that helped?
Ken Mill representing DEFA. That's been exceptionally helpful. There's a lot of unpicking there to be done. I think it fundamentally comes back to those sensitivities and magnitude and being comfortable with what's in the assessment.
Agreed, yeah. Manx Wildlife Trust, are you comfortable? Is it clear what I'm explaining?
I think DEFA would just...
I'm so sorry.
That's quite all right. Peter Duncan, DEFA. I would make one point following through the discussion at the risk of repeating myself. I think, as we've discussed, the protected sites, the marine nature reserves, are spatial designations. They're not a combination of their designation features. As such, you commented about the elevated status of sensitivity. That should be applied to the site, however challenging that is, rather than the features. And in that respect, I'm not sure that we are at that point with the current PSA assessment.
If you could reflect that view in your response.
Indeed.
But also take note of the applicant. but also, in that response,
Amy Sterling on behalf of the applicant. Yeah, we're happy to... I think this is best picked up with DEFA through the Statement of Common Ground.
Agreed.
I would say that this is not the approach to the protected sites assessment that we believed that we had agreed with DEFA. We understand, and as the point was made by Mr McManus earlier, if it was an entirely spatial designation, then we don't overlap with any marine nature reserves, and then therefore the scope of the assessment would be presumably much smaller and be limited to only a zone of influence. It's not entirely clear what we'd be assessing in terms of, if there's no features, what specifically we would assess. So I think we're happy just to discuss this directly with DEFA.
Thank you. If everyone's comfortable, in the 1 minute before coffee, I will just...
Can we just go to Manx Wildlife Trust? I think you were asking them.
Have I already? Do you have a comment? So sorry.
David Bellamy for Manx Wildlife Trust. Thank you. We'll make this clear in our written response, but I think it's fair for both DEFA and the applicant to hear this so that they can comment if needed. But in terms of the objectives, one set of objectives for all marine nature reserves that we haven't yet discussed is contained within the biodiversity strategy. Objective 5 for habitats and species in there states, by 2025, all sites of critical importance for conservation of our biodiversity will be effectively protected and managed so that resident or migratory wildlife has adequate refuge to safeguard its future survival, recognising the challenge of climate change. So effectively what that is telling us is all marine nature reserves are to protect resident and migratory wildlife now and into the future. And very briefly, it specifically says, to achieve this, we will prevent the loss of priority habitats, significantly reduce habitat degradation and fragmentation, and where appropriate, restore key species, populations and priority habitats. So while that doesn't mention any specific MNRs, it gives the overarching raison d'etre for the designations of all sites.
Thank you. Thank you for that. If you could provide that to DEFA for the discussions on objectives with the applicant, that would be really helpful. Thank you. Moving on then, has anyone got any more points on that agenda item? If we go to the last one. So the HRA, to use a comparator, assesses the combined effect of the site and other projects, which in EI terms is cumulative, and you've taken the term as cumulative in your assessment. And the PSA says in 4111, step 2, protected sites assessment, would also include consideration of the project alone and other and cumulative impacts. But I can't find that assessment in the cumulative impacts assessment. Are you saying that that's inherent in the process as well, as interrelated?
Ryan McManus for the applicant. Yes, similar to the interrelated effects part of the question, the PSA collates the outcomes of the EIA from the impacts of the project alone, cumulatively, and interrelated into the protected sites assessment. The PSA is not a separate process. It's part of the EIA. The PSA chapter is part of the EIA. It's not a separate process. So it does consider all relevant impacts, whether they are from the project alone, interrelated or cumulative. And so that's really the point about not seeking to duplicate assessment, because those assessments are already done in the EIA. in the relevant topic-specific chapters of the EIA.
I understand.
The PSA essentially signposts and draws those together
But the EIA
in one.
Sorry, go ahead.
Sorry, so
the EIA chapters assess the impact in isolation. That's not with other projects. The EIA chapters, that's it for the project alone.
Right, as for the applicant, it assesses cumulative effects as well. In each specific chapter, there is a cumulative effects assessment section.
Yes, but is that included process-wise with the impacts on the site and then transported to the PSA?
Right, as for the applicant, yes, it is.
Okay.
It may not be exactly explicit, and perhaps we could have made that clearer, but that is the approach that's been taken.
I'd be really grateful just to tick that box if you could provide a note as a hearing action to explain. If you could explain with a worked example how that has been done, that'd be really helpful, because I couldn't see it. Thank you so much. I'll just turn to DEFRA, if that's all right. DEFRA, you raised this in your response to a written question, I think. So are you comfortable for the applicant to explain how they've done that?
Ken Mill represent DEFRA. Yeah, I'd be comfortable with the applicant come back and explain. Our issue was each of the EIA chapters, as you like said, it might give us a not significant, low impact, and maybe did look cumulatively, but the interrelated ones we didn't feel we'd been considered adequately. So the response would be useful to have.
Yeah, there's the issue around interrelated to cumulative, and then the EIA. So go ahead, Miss.
Amy Sterling on behalf of the applicant. We were just discussing amongst ourselves, Madam, and we suggest that the applicant prepares a PSA methodology note to set out really clearly the methodology that's been applied, and as you said, with some worked examples, including also the history of the discussions, how we got to where we are, and then a really clear signposting, because I do take the point it's not as clear as it could be as to how the EIA has informed the PSA.
That would be really helpful. It's currently quite a short chapter, and it takes a bit of cross-referencing to see where, and you can't go through your lines of input, no source pathway really to where you want to find information. So that'd be really helpful. Thank you. I think DEFRA would welcome that. So that's by the next deadline, if that's all right.
Could we actually have that as a post-hearing note? And the reason I'm suggesting that is I think it will also help your conversations in relation to the statement of common ground. So if you could explain the methodology as indeed you've just set out, I think that would just illuminate quite a few of the subsequent discussions.
Amy Sterling on behalf of the applicant, can you confirm what the deadline is for the post-hearing submissions? I'm not entirely clear. It was just to check the deadline for the post-hearing submissions.
Ms. Hyde, post-hearing note.
A hearing submission can be submitted during the submissions, and we will publish them as soon as the hearings are completed. So that will be within this week, essentially.
Amy Sterling on behalf of the applicant, we're all here in hearings this week, so I'm not sure that we'd be able to prepare it in tandem. Could we say end of next week? Would that be reasonable?
Sorry, what's that, Miss?
We've been asked to provide, we've offered to provide
I understand what it is.
Site assessment. That was
time
asked as a post-hearing submission, reflecting the fact that we're all in the hearings this week. It's not practicable, I guess, for us to prepare it within this week. We've suggested Friday next week as the deadline to prepare that note, and we'll share it with DEFRA at the same time to allow discussions to take place before deadline 4, which is 3 weeks
16th of June. I'm reluctant to create a further deadline within the examination timetable, so let's just take that away and we'll come back to you after the break.
Well, I think the answer there, pragmatically, is prepare the methodology and share it with DEFRA and then pop it in at deadline 4. But meantime, they'll have seen it. That would be the pragmatic answer to what I think you're trying to do. So I think let's just keep it simple.
No problem. Thanks.
That's perfect. Thank you. It's been quite a heavy-duty morning, but I hope we've got through some chunky stuff and we've come to some sort of agreement on our way forwards. So if we break for coffee now, back around 10:02, if that's okay. Thank you very much for all your contributions. If everyone's ready, shall we start the hearing? Yeah? Okay, sorry we're a little bit late. So the next agenda item is approach to assessment of geology, geomorphology and marine water. And as I explained at the outset, this is here because of mainly sediment and the impact of sediment on benthic ecology and fish ecology. So thank you to the applicant, which I think was referred to at the beginning of the hearing, for the document, G3.8, Comparative Review of Physical Processes, which rather helpfully preempted the hearing agenda item. So the document you provided, which was explained at the beginning, explained the use of DMRB and other projects. Therefore, raising the point about Hornsey and this project. The document you submitted didn't include Hornsey in the report. Is there a reason why? Because if you refer to DEFRA's little bar chart they put in their written question response, Hornsey has a much higher, I think it's magnitude, isn't it, application?
Dr. Kieran, on behalf of the applicant, we excluded Hornsey because it's in a different regional sea than what Mooir Vannin is. So we selected those projects that were spatially as close as possible to give a representative baseline characterisation and impact assessment. So we didn't think it appropriate to consider, it wasn't just Hornsey 4, we didn't think it appropriate to consider any of the Dogger Bank projects, which were the North Sea or East Anglia projects, or any projects in the Outer Thames. So we thought they were inappropriate for characterisation and comparative purposes. So we thought it more appropriate to compare those in the similar regional sea, and hence Morgan, Mona, Morecambe and or Wellymore.
I understand. It's just you make reference throughout the application as Hornsey being a bit of a benchmark for everything that you've done, and then DMRB. Maybe benchmark's not the right word.
We use Hornsey 4 because much of the EIA team on Mooir Vannin were also the EIA team on Hornsey 4. And Hornsey 4 was Ørsted's first approach, utilising a proportionate approach to EIA. So we pioneered some of our techniques and application methods, like the use of the impacts register, the commitments register, the developable area approach were first trialled on Hornsey 4, and hence those have been carried across. But our DMRB methodologies applied to Mooir Vannin is discrete and different to what it was on Hornsey 4. So it doesn't really bring value to compare those, because for the regional sea setting, that one was applicable to Hornsey. It was a much bigger project, much greater spatial scale in a bigger regional sea. So from from a magnitude sensitivity perspective, at different receptors, different environments. So for that reason, we have excluded it from the comparison.
It is, from the information I have and the information DEFRA submitted, quite different. I don't know if that's because of the location being different. I think if I just show the two visuals, just so we can tick this box, because DEFRA have raised it and they've specifically included a bar chart. I think you must have seen it in their written response. So if it's all right with DEFRA, I'll just show those two visuals, and then you can make a decision whether you're comfortable with what the applicant has submitted in terms of their report pre-hearing. So we could just see table 6 from the application, AP045, please. So in this table, I think the point that DEFRA are making is that, have I got the right table? Table 5, maybe, if you go scroll up.
Sorry, could you just clarify table 5 from which document is this?
Sorry, table 5, yes, that's right, yeah, sorry. I'm sorry, so from which document? It's your submission, APP045, so sorry. Okay. So if I just do a very short run through of Hornsey, and then I'll turn to DEFRA and ask them if they're comfortable, and then we can tick this off. So in table 5, the total lifetime of the proposed development for major, and Hornsey 4 is 20 years, so there's a cap on major. For moderate, it's the operation period. For Hornsey 4, it's 2 to 20 years. So they're very different timescales, significantly different. For Hornsey minor is the construction period, and minor for Hornsey, I'm sorry, that was yours. Hornsey is less than 2 years. For no change, it's, what's it say there? No observable impact, and for Hornsey, it's less than 2 years. So those categories are significantly different. If I just get DEFRA's bar chart up, please, if that's all right, from their written question response, Q117.6, magnitude and sensitivity D1133. DEFRA have done a comparative analysis. I'm not sure it's exacting, but I'm assuming they've submitted it because they believe it's important, where Mooir Vannin is significantly higher across the chart. I think if I turn to DEFRA, in light of what you submitted to the examination, and in light of the applicant's very helpful pre-hearing report, are you comfortable with how this has been applied? And then if you're comfortable, we'll cross it off the list. If not, then I think it's back to further discussions between the applicant and DEFRA.
Ken Milne, representing DEFRA. As we've submitted, we feel, and as we previously said, we feel each project is different, but we feel the Mooir Vannin seems to be a different standard compared to the other UK projects, different sort of level. And we don't think it's been adequately addressed. And I think it's something we'll have to raise with Ørsted through the Statement of Common Ground as we go forward. Because I feel, as you say in that table there, it's very different than Mooir Vannin compared to the other projects.
Does the applicant want to respond to that?
Dr. Carr, on behalf of the applicant, this was the purpose of doing the comparative methodology and setting out the definitions of magnitude and sensitivity and comparing them with all the projects. I think what's clear is that all projects use the DMRB approach, which is used because it's user defined to each particular project and each location, receptors and sensitivities. So that's why there's variation in the definition for magnitude and variation in sensitivity. Irrespective of those changes, then we would challenge the assertion that the significant difference results in any change to the assessment outcomes, and we've demonstrated that through the comparative note, that irrespective of if magnitude is defined as high for 30 years, 20 years, 10 years, that doesn't change the assessment outcome. So the assessment outcome in all cases remains as non-significant. So I think our view is that, yeah, there is difference in the definition of magnitude and sensitivity, but it doesn't materially influence the assessment outcomes. And we asked DEFRA if we could agree to disagree, that there was no materiality, that if there was any resulting impact that we were downplaying, that they felt that we should be mitigating or monitoring, that to come forth with that information, and that hasn't been forthcoming. So we stand by that. There is changes in magnitude and sensitivity, but the assessment outcomes remain unchanged and insignificant in all cases.
Okay.
Same as Hornsey 4, irrespective of whether the assessment outcome or the magnitude definition is higher or lower, the assessment outcome on all of these projects for physical process is non-significant, no likely significant effect across the board for all of these projects. So
okay, I understand. So I'll turn to DEFRA then. Are you comfortable with that? Would you perhaps like the report to be updated to include Hornsey 4? Or are you comfortable with the decision they've...
Ken Milne, representing DEFRA. I think the report should be updated with Hornsey 4. That was the last project that Ørsted developed. And this is an area that we are still ongoing discussions with Ørsted, the applicant. And we have a meeting on some of these physical ones later this week to further discuss it.
Okay. So is that a hearing action to update the report and then continue? I'm assuming it's quite simple to update the report with Hornsey 4.
It's just more work that reaffirms. I mean, at what point do DEFRA and do the examining body draw a line under the submission of continued evidence that shows that this is a non-significant effect, so we can go and compare every offshore wind farm, and we can work from now to the end of examination to confirm and reaffirm no likely significant effect.
I think the point was because you've explained Hornsey 4 as an example throughout the EIA. I think my colleague wants to respond to the point. That's okay.
I think I just want to turn to DEFRA. Even if the report was updated to include Hornsey 4. The point that the applicant has made is that there would not be a change in the conclusion on the assessment, and there would not be a change in mitigation, and there would not be a change in monitoring. I'm interested to understand if you agree with that point. If the answer to that question is yes, you do agree with that point, then I would like to understand the rationale behind you wanting the inclusion of Hornsey 4.
Ken Milne, representing DEFA. We do agree that the output is likely to be the same, but it would just be for consistency. It seems that we're picking Hornsey 4 for some aspects, but not being consistent throughout the whole report, the whole EIA. It would just give us that level of consistency. And sorry, I'll pass it to my colleague.
Yeah, sorry, it's Richard Armitage on behalf of DEFA. In general, with respect to physical processes, yes, there probably wouldn't be a significant change to the overall assessment. However, many of the physical and geological process things are pathways, which then go into various other sections, such as fish ecology, marine mammals, and so on. So, keeping them as all negligible when we believe that they should be higher than that could possibly have a significant effect on other processes. With regards to the paper that's been prepared, we only got it a couple of days before the hearing started, so we haven't fully addressed it. We did have a draft version, which we fundamentally disagreed with large parts of that document. Having a quick look through, some of the same errors still seem to be there in the current document. So, but the other point is that on what has been assessed at the moment, in physical processes, yes, there probably isn't a significant effect, but as you've got further down, we don't believe that concurrent and consecutive effects have been assessed properly. And when you then apply those to those same criteria of magnitude and significance, they could possibly be significant. So I don't think we can instantly rule out any possible change.
It seems to me that that testing is essential to confirm whether or not the conclusion of the assessment, and indeed then the proposed mitigation, monitoring, etc., would change. And so then it seems to the examining body that it would be essential for that test to happen in the way that DEFA are requesting, even if it is to just satisfy parties and indeed the examining body that conclusions and proposed mitigations don't change.
Happy to include it. They'll just reaffirm the position as all of the evidence that the applicant has brought to date that is not significant. So, you know, we're happy to include Hornsey 4. We don't use Hornsey 4 as a comparison across the board with everything. We don't. It's just simply the last project that we worked on. Our stakeholders typically go to Hornsey 4, look at it, and then they compare that we're given Mooir, Vannin, everything that we give to Hornsey 4, and I can understand that approach, but it's not we're not copying and pasting the Hornsey 4 EIA methodology to Mooir, Vannin, but happy to update the note. I think there's a conflation on additional issues being brought by DEFA that in terms of concurrent and simultaneous, and it's starting to confuse and conflate a number of issues, which I think would be helpful if the examining body could just minimise and we could take one issue at a time, and it would allow us to progress, because we've been having these discussions with DEFA since the beginning of examination, since well before the beginning of examination, and they continue to persist.
So can we make a decision on how to move this forward then? So are you comfortable with updating the note to include Hornsey 4 by the next deadline? Okay. And then any other disagreements, you'll proceed through with the statement of common ground. There's a couple of other methodology points I'm going to pick up on, so perhaps we could just conclude how you progress them more as a group, because otherwise we're going to be using up time. Would that be all right if I just touch on the other points I want to raise to do with methodology?
Ken Milne, representing DEFA. Yeah, that's fine.
So the next one's on coastal versus estuarine SCC, milligrams per litre. DEFA have raised, I think quite a few times, that the chapter from APP 046 defines the baseline nearshore sediment concentration as 10 milligrams per litre, and that this is an inner estuary and tidal river conditions. The tidal river is not the same as the coastal estuary, as it's more turbulent, and so sediment is more concentrated and higher than the coastal setting. So the question is, I think, from DEFA, the basis for definition of the SSC baseline at the nearshore, and using that comparator. It's a question for the applicant. Sorry.
Amy Sterling on behalf of the applicant. Apologies, madam, I wasn't quite clear what the question is. Is the question, do we stand by our use of that figure within the nearshore environment?
Yes.
Yes, okay, thanks. I'll just confirm with my colleagues. Thanks.
Dr. Kieran on behalf of the applicant. Yeah, we stand by the values that we have used in characterising the baseline environment. I recognise that they're maybe quite low when compared to some other estuarine conditions. There is no real estuarine conditions along the east coast of the Isle of Man that you could compare. So we're happy to elevate that. We're happy to lower it down. It fundamentally won't change the assessment outcomes. Okay. So it's like...
So that's the first one. If I just run through the comments that DEFRA have made. So the first one was the estuarine versus river. Estuarine versus coastal. The second is suspended sediment and magnitude of change, which I think what the DEFRA representative was just talking about earlier. So in the report, APP 045, the baseline for suspended sediment in the offshore environment is 2 milligrams per litre, and any change ranges up to 5,000 milligrams per litre, and it's assessed as very slight in response to question 1. Well, it doesn't appear to be very slight, and I think DEFRA's raising the issue that that magnitude and that comparator is not very slight, and that it would seem that it would move into the next class up in terms of impact. So that's the second point. If I just run through it, would that be all right if I just summarise? I think that's right, isn't it, DEFRA? That's the point you've raised?
Ken Milne representing DEFRA, yeah, that's one of the points we raised.
Okay.
Yeah.
The next one is distance. And so paragraph 8624 of APP 045 describes an impact affecting an area of 10 kilometres as highly localised. And in other areas, it's 300 metres as highly localised. So distance is a second one, third one. And then time. So the time of which concentration is elevated seems to vary with 4 hours as a short period, 8547, and 2 hours as a short period in 9547. So grouping those points together, it's clear DEFRA has issues with how magnitude's been applied and their reference to not using Hornsey 4 in your paper. And then they have issues with coastal versus estuarine and how you apply that, with distance, with time, and with distance, time, sediment concentration, magnitude. So scooping that up in a pot, because we can't go through all that detail today, we've been down a rabbit hole. How does DEFRA want to proceed with this? I mean, we need to have a focused discussion on this as some kind of agreement, because as you were saying, some of it underpins issues for other chapters. So is this, I mean, clearly it's part of the statement of common ground discussion, but we can't have it drifting on for the next 2 months. Has the applicant got a proposal in terms of how you sit down and discuss these specific issues around defining the assessment?
Dr. Kieran, on behalf of the applicant, I thought that we had agreed to disagree, because this doesn't change it's so lost in the weeds that we just need to lift our heads up and look at the bigger picture of whether this, in terms of a proportionate EIA, this is likely to result in a likely significant effect. And I think there's broad agreement with ourselves and DEFRA that it's not likely to result in likely significant effect. So we can discuss this until the cows come home, but nothing changes. So we're not proposing anything more than the addition of the Hornsey 4.
Then the decision for DEFRA is to agree that although you're uncomfortable with what's been applied, as it doesn't affect the outcome, you can proceed on that basis.
Richard Armitage on behalf of DEFRA. For the specific, again, I know they've asked not to sort of conflate things, but for the specific one of, say, a single drilling location being assessed.
I'm sorry, I missed that. Could you say it again, please? Sorry.
For the specific assessment, say, of a single drilling location for sediment plumes, it doesn't affect the overall magnitude of that, because it is still over a short duration and so on. However, And I know it's been requested that we don't conflate issues, but then if there is actually an assessment of the 8 drilling locations that they say they're going to do all at the same time, or, you know, if you take deposition of sediments, the 3,500 hopper loads that are going to be deposited through the project, then it will impact those if you don't have a proper definition of what is localised or, you know, so for example, at the moment, an 8-kilometre plume is described as localised. When 8 locations are done together and that extends to, say, maybe 160 kilometres, is that still localised? So that's the problem. It's not going to change what has been assessed, but like I said before, we still have concerns that consecutive and concurrent events have not been assessed.
No, so consecutive and current is another agenda item. That's a different thing. These are we're going to discuss that in a minute, and I agree that there are issues that we need to unpick with consecutive and concurrent. I think what we're talking about here is the basis for the assessment.
Yeah, Richard Armitage on behalf of DEFRA. But if we accept that everything is highly localised no matter what distance, then when we come to do those assessments, then they'll all come out as not significant again. That's the point. You know, you can't decide, yeah, okay, you can describe everything as very slight change and, you know, highly localised. That's fine for what has been assessed at the moment, but if you take that same criteria and apply it to things that we believe should have been assessed, then it will be relevant.
Mr. Armitage, can you just, because what I'm hearing from Dr. Carolyn is that he's saying that there's general agreement between parties that the conclusion, mitigation and monitoring is okay, but it seems to me from what you're saying is that with that testing, potentially those conclusions will change.
For what has been assessed at the moment, yes, there probably will not be a significant change. However, we believe there are things that haven't been assessed that should have been assessed. And that's the point, not that what has been done is going to significantly change.
Is the main issue here definition of highly localised, so where things are rather than the duration and magnitude?
I would say it's all of them. It's all of them, because if concurrent or consecutive activities are assessed, then duration comes into it for consecutive activities. Magnitude will come into it for concurrent activities, if, for example, plumes coalesce or whatever.
So I think it sounds to me like it's not agreed. Are you saying it was agreed in the evidence-led process, all this?
I'm not. So what I meant in terms of what was agreed was at the last meeting that we had when we discussed the comparative note and the definitions of magnitude and sensitivity and the assessment outcomes. Yeah. It was agreed verbally that we would agree to disagree because it had no material influence on the EIA. So these discussions, whether it's 2 minutes or 5 minutes, whether it's 5 kilometres, 3 kilometres, whether it's the same as Hornsey 4, it's different to Hornsey 4, or immaterial to the conclusions of the EIA.
Can we hold this conversation then? Because we're going to move on to the issues that you're talking about that were not assessed, and then we'll work back and see whether any of the issues that we're talking about now impact that. Would that be all right?
That would be okay, but I would just like to pick up something Mr. Armitage said. Mr. Armitage said, he said that his issue wasn't around with what had been assessed, was not his issue. So therefore, this is not an issue, the magnitude sensitivity. What his issue was around the things that were not assessed.
Yes, that's what we're moving on to.
But then, therefore, the discussion around the magnitude and sensitivity of what is assessed is not an issue, which he's just said.
I understand the point you're making.
Yeah.
Okay, so if we move on to the next topic, and we agree to assess it, I'm not saying that we will, but we will look at it, then you have to come back to the definitions. Are you comfortable with that, DEFRA? Okay. So the two issues that we added to the agenda are, firstly, the combined effects, and I think that's what DEFRA's talking about, isn't it? Where a number of activities operate at the same time within the MDS. Given that it's such a huge project with such a large red line boundary, I think DEFRA are concerned that if you have a number of activities in the same location, that will have overriding impacts. And at the moment, each assessment explains the impacts as short-term, sequential, and highly localised. That comes down to my question about whether highly localised definition matters. And this would assume that one activity finishes before another starts, and they would not be in the same location. And I think it's a reasonable response from DEFRA, and it's also been raised by me subsequent sections for fish ecology and benthic ecology, because that obviously makes a difference. If the fish are moving to a location A and you're, moving around. So this wasn't assessed in the application, is that right? Or is it assessed in some location that I didn't quite misunderstand?
Ryan McManus for the applicant. The concurrent and consecutive activities are assessed in the EIA. I think before getting into that, if I can just explain kind of how the sediment plume modelling has been used. And
because that's fundamental to the sediment. Yes,
that would be helpful. Okay, so what we've modelled is essentially several different construction techniques. So that includes seabed preparation using dredging, drilling at foundations, cable installation using jetting tools. That's been modelled at a number of representative locations throughout the project area, so a couple in the array and a couple in the export cable route as well, to kind of reflect the different localised hydrodynamic conditions across the site. And that's really used to build a picture of how we expect sediment, the sediments that are suspended, to behave. So it's kind of a representative simulation that's based on the maximum design scenario, but it doesn't assess the total of the construction activity. When you think about how the project would be constructed, it's consecutive foundation locations within the array, and with cables it's a continuous moving construction tool that's moving along the seabed. So where there is potential for overlap of sediment plumes generated from those activities, they're not generated in the same place. They're discrete locations, which are separated, in the case of foundations, by several hundreds of meters. And when you take the outputs of the model that kind of predict that the vast majority of sediment deposition falls to the seabed within the relatively local environment, within the immediate footprint of the works, and within a couple of 100 meters of that work, there is limited potential for additive effects and consecutive effects of those activities, because they're both spatially separate and temporally separate as well, because they're not occurring at the same time. It's a sequence.
I understand that, but have you simulated multiple activities in the same location at the same time, or are you saying you don't need to do that because that will never occur? And also that although it's sequential, sediment takes time to settle. It's not like you can move in location A and it's compartmentalised from location B, or doing activities that are maybe, I don't know how it works in terms of distance, but 500 metres apart, both doing activities and the sediment going in different directions. Do you understand? So I don't have a understanding of whether that kind of interaction has been assessed, and I suspect that's what DEFRA's saying. So we've got no confidence that for marine life there will be no impact on sediment settling. And the next topic is about how it erodes quickly, because you could be going across the sea floor and it takes a long time to erode, and that does affect the benthic organisms in the benthic layers. So how can I be confident that you've addressed that? Does that make sense?
Just before you answer that question, can you, sorry, not before, while you're answering that question, can you also take into account the construction sequence that you've just described to us, which basically underpins your assertion that you don't need to do that kind of assessment? Is that secured anywhere in any of the management plans, control documents, or the MIC? Because if it is, then that is the start of the confidence that Ms. Pownell is seeking.
Ryan McManus for the applicant. So I'll take the first part of the question. The second part of the question from you, Mr. High, I'll hand over to colleagues. So the way the modelling has been set up is to look at the dispersion of sediments over a 12-hour period. So that aligns with basically essentially a 12-hour tidal cycle. In all cases, the results show that there is settlement to baseline conditions within that 12-hour period. For
one activity, I'm so sorry.
Yeah.
For one piling,
an activity.
Okay.
Well, not for a pile. That would be for, say, a dredge. Deposit
so
of
one
dredge
activity
material.
is
It varies by activity, because activities that occur close to the seabed, from cable installation, for example, because the point of release is lower in the water column, that material would settle out much more quickly. So for that scenario, the sediment settles out within 4 hours of that model. For the maximum design, which would be deposit of dredge material from a trailer suction hopper dredger, for example, which is released close to the surface of the water column, even in that case, which is the maximum design scenario, it settles within that 12-hour tidal cycle.
But that's for one what you described, one trenching activity. But what happens when you're doing a trenching activity next to a piling, next to something else?
Those activities, for the applicant, those activities would be temporarily isolated
that's
from
your
one
response.
another.
Temporary, short term, and no, that's the response you put through all the chapters. But I think what we're saying is we don't have confidence that that's the case, because because of the MDS, because of the way the whole thing's set up, the consent set up, you could pile, trench dredge, something else in the same location within the same area, and you've not modelled the plume activity as a result of that, and also the speed of erosion of the sediment. Could I just cross to DEFA, because it's becoming a conversation between the two of us. So DEFA, could you just contribute to the discussion what it is you're not comfortable with, whether I'm explaining it correctly, and what it is you think you need to be comfortable, because we need to work this through quite quickly now, because we've got lunch soon. So.
Richard Armitage on behalf of DEFA. I think.
Could you speak into the microphone?
Sorry,
I can't quite
Richard
hear you.
Armitage on behalf of DEFA. I think you've summarised it quite well. One specific example that's worth mentioning.
Is your microphone on? I can't quite hear you, sorry.
Yeah.
Mr. Armitage, can I just suggest... Sorry, we just want to have one conversation. No, it's fine. Would you mind terribly starting again?
Okay. It's Richard Armitage on behalf of DEFA. I think the summary was fairly well put, but I think one specific example that's worth bearing in mind, or illustrates the issue well, is that in the EIA, the applicant says that they will drill, or want to drill, up to 8 locations at once. Now, the only assessment is of a single drilling location. Now, if you do 8 locations at once, the plume currently modelled is 8 kilometres by about 3 kilometres. Now, if you are drilling 8 locations, presumably those plumes, depending on where the locations are, will either coalesce and therefore give greater suspended sediment concentrations, or will cover a much larger area than the 8 by 3 from a single location. Therefore, the impact needs to be assessed in that manner.
I understand. So what we're saying is that although we understand and the applicants modelled the plume for isolated activity, we need to understand the credible sequences and distances between them to understand why they won't overlap. And that's the issue that I think DEFA and the panel would like to understand, but also, as my colleague has just explained, how it's secured or explained in the management plans that situation will not occur. And I think this comes back to your uncomfortableness with distance, highly localised. I think perhaps the magnitude may be resolved, but those issues. It is clear that you haven't modelled that. Is that right? Am I understanding that correctly?
Brian McManus for the applicant. So, I mean, that specific scenario isn't modelled, because we've modelled 4 representative locations for different construction activities. I think what is also worth bearing in mind here is that where simultaneous activities could occur, the sediment plumes from those activities would be aligned to the tidal stream. So you've got sediments from two locations moving in the same direction, so they don't necessarily overlap, and there's limited space, there's limited potential for those plumes to overlap and become additive.
But I think what we're saying is we don't know that because we don't have any evidence to support that.
And I'll pass to Dr. Carolyn to discuss the consecutive sequencing activities point.
I think, are we not reaching a point, though, where we need to move it forwards? Sorry, Dr. Carroll, if you'd like to continue with your explanation, but if you make it brief, if that's all right.
Just very briefly in relation to the sequencing activities, and I understand DEFRA's concern, and just to provide some further information on what Ryan has been saying, in the project description, in figure 18, which gives the indicative construction programme, it sets out the sequencing of the offshore works. So, and these have all been modelled individually within the physical processes technical report and informed the assessment. So we would have the cable installation works, so the excavation of the cable trenches would occur first, so they would be over a spatial area. Once that activity had ceased and that was done, then we would be moving on to foundation installations, so it would be seabed preparation for the foundation. So that would happen at discrete locations. Then we'd move on to the next location. Then we'd come back to the scar protection. So there's a lot of time in between all of these, and it's set out, the sequence is set out. So we have a 1-year construction program. So it's a roving program. And the space between all activities is significant. When we have set out in PDR 009, which sets out, we've tried to address this on, to demonstrate to DEFRA and other stakeholders the permanent and temporary disturbance of the seabed associated with all construction activities associated with the whole programme, and that is in PDR 009, which is really useful. So that shows the proportion of the seabed that is disturbed by the permanent and by the temporary works, so that's all activities. And it equates, I think, till about 5% of the seabed.
I understand. Thank you so much. I think you've all explained exactly what you've done and the implications of that. I think there's a number of issues here. I know we're heading off to the next section. So I think it sounds like definitely confidence that there are credible sequences with distances between them. And if there aren't, to understand how they will overlap and the implications of that. And I think my colleague was referring to establishing some kind of parameters within the consent so that everything doesn't all happen at once. Is that about the summary of where we're at?
I think that's right. And I just want to add a couple of things in here. There are certain assumptions that DEFRA has referred to in the EIA, and the way that you're describing the way things will happen seems to be quite different to the assumptions that DEFRA have picked up in the EIA and the way you're describing them. So that's one thing that we probably just need clarity on. But more importantly, I don't think my question got answered, is that some of those assumptions that you're relying on in terms of to make the assertion that you don't need this modeled, I just need clarity on how and where that is secured. And if it is not, then I think you need to just take that away and give us that comfort that it will be.
Amy Sterling, on behalf of the applicant, the points are all well made and understood. Well, I think it's a point that we need to reflect on and identify where, as you said, the assumptions set out in the project description aren't reflected in the MIC, for example. I'm not saying they necessarily should be, but I think we need to reflect on that and, where appropriate, ensure the maximum design scenario that's been assessed isn't capable of being exceeded. Or update the assessment for an alternative scenario.
I think my colleague wants to come in here, if that's all right.
Yeah, I think that's helpful. Yeah. I think the other aspect which maybe would assist DEFRA is if there's some sort of monitoring, how would they know that that was happening? So I think we can build that into that. Maybe it's a control document. I don't know quite how you would do it, but certainly something to secure that sequentiality that you referred to, Dr. Kernan.
So there's a couple of issues here then, 3 I think main ones, is the parameters of assessment, which DEFRA have explained they're not comfortable with in this scenario. How we explain, or how there's confidence for us that this scenario will not be an issue, and then how the activities are anchored through the consent, which I think we've just been discussing. So is it possible to run models from nodal points along the northern alignment, because that's principally what we're talking about here, using concurrent and combined activities, and to see where that takes us. I'm floating that question. I'm not asking for it, because I think it's DEFRA's place to say exactly what they think would need them to make them comfortable, but within a reasonable context. We can't revisit the entire activities that went up to the EIA. All we're looking at here is to test what the consent will deliver, and that you are comfortable that it will be acceptable. Does that make sense? So it's light touch for confirmation here, not a whole big rework of everything. But is what I've suggested appropriate?
Richard Armitage on behalf of DEFRA. Yeah, I would say that's appropriate. I know there's been talk about modelling. We're reasonably happy with what has been modelled. It's just then the combination of things, so it doesn't necessarily need a remodelling of everything and modelling every possible scenario. That would just be unreasonable.
Can you agree as a matter of priority what that modelling looks like? I don't really want to go down the whole of describing the modelling and the detail of the modelling. Is that...
Amy Sterling on behalf of the applicant. I think the applicant's position is there would be no need to rerun further modelling, because the modelling is just one part of the assessment process. But the applicant's happy to discuss this with DEFRA, also going to reflect on the maximum design scenario and what hasn't and hasn't been assessed, and whether any new assessment needs to be carried out, or whether any further design parameters need to be secured.
Perfect. So can you discuss that as a part of your SOCG process, and then go back to the definition, the parameters of assessment, which DEFRA have explained in terms of distance and time? If I could just... Are you comfortable with that? Yeah? Dr. Cowan? Not comfortable?
I'm not really comfortable, because I think we've been discussing this with DEFRA from January, and we're not materially anywhere further forward. So I'm really not comfortable. We go away and it's more work on us to prove the negative. That's what it is. It's just, more work on magnitude, more work on sensitivity, more work on disproving that this is not a likely significant effect. And I think that's the part I feel uncomfortable with. Happy to do it under your instruction, but I don't think it's moving anything forward.
Dr. Carolyn, I think for this specific point, for this very specific point, I think the examining body itself is unable to see how the assessment in the EIA is, or at least the narrative that you've just given us, how we can have confidence that that is how things will happen. So we are, our level of discomfort is because we're not convinced that the effects are going to be worse than they have been assessed in the EIA. So I completely agree with what Ms. Sterling has just said, is that you possibly need to do one or the other, either further modelling, or secure things through control documents or the MIC, but possibly not both. But I think this is definitely a key area that needs to be progressed. And exactly as you've said, I think there's a whole range of issues with DEFRA, but on this specific point, I think we've got quite a clear way forward.
Happy to look at the MDS and to secure through the documents. That I'm in total agreement. That gets us forward.
Okay.
I mean, the rehashing of magnitude and sensitivity and reassessment doesn't get us any forward. That's the bit, just to clarify.
Okay.
Yeah.
That point is noted. Thank you.
Okay. Just before we close this topic out, we're looking at the timeframes for erosion, which I think weren't part of the assessment, like the interrelated we've just discussed. So I think Mona and Morgan did provide some work on this. They looked at quantified seabed mobility rates and how this related to the relative distribution of sediment, and how much the seabed was moving under natural conditions and how quickly trenches would backfill. I know DEFRA have raised this, and it seems a reasonable point, particularly for benthic ecology, how quickly the sediment erodes that you're creating. Is this something that DEFRA want to raise now and ask the applicant?
Richard Armitage on behalf of DEFRA. I believe we've raised these specific issues in our written submissions, that there certainly seems to be a lack of clarity over the removal of sediments, because it is variously described as a month or number of months, or in some places semi-permanent. The answers that we've had so far don't really clarify that. But
so
again,
I think there was no assessment undertaken of the rate at which the redeposited sediment due to construction would erode. Have you taken that into consideration in your assessment of mainly benthic and fish, isn't it, fish ecology?
Ryan McManus for the applicant. So just to be clear, we're talking about sediment which has deposited on the seabed and how quickly that would be dispersed by wave and tidal currents to return to background conditions.
It can affect fish habitat and spawning grounds.
Yeah. So, I mean, yeah, you're correct in saying that we haven't done a quantitative assessment of sediment mobility rates in the area, but we're happy to look at that in more detail. Okay. We have provided an assessment of that descriptively.
Perfect.
in terms of how quickly you'd expect that to erode in descriptive terms, sort of in the order of whether it's days, weeks, months, etc. Okay. But not precise quantitative criteria.
If you could look at what Mona did, I think they did it quantitatively also, and then perhaps provide some further information at the next deadline, if DEFRA's comfortable with that. Okay. Is everyone happy before we move on to the next topic? Any more questions? Anyone? No. So we're a little behind, but if we move on to benthic ecology, I'm hoping we can get through this before lunch. I think there's been a lot of discussion around benthic ecology and the receptors. I think removing the southern alignment helps a lot in terms of the direct impact on the benthic ecology. I think if I just summarise the issues that the Wildlife Trust and DEFRA have raised through the last month since the hearing and through their submissions, it's around the regional scale of assessment and not doing it at a local scale, and that doing that doesn't take into consideration the wide distribution of these receptors and their value as probably isolated receptors like nudibranch within the bigger biotope. So I think that's an issue. And it's been debated a lot, I think, throughout the discussions, alongside the value of importance of the species. I think there was a issue with nudibranch and how it was classified and categorised, and how they're treated as high-value receptors amongst all the other receptors. That comes back to the PSA and the assessment that we were talking about earlier. So we've worked through a lot of that. So the first thing on the agenda is the characterisation of the benthic subtidal ecology baseline. And I think some new information has been introduced. So if I just run through, I think, what the issues are. The applicant submitted their benthic subtidal intertidal survey, so thank you very much for that. That was D1070, I think, Deadland 1. And that addressed some of the detail that was missing in some of the submissions previously. I think issues that have been raised by DEFRA and the Manx Wildlife Trust, DEFRA D1033 and Manx Wildlife Trust D1041, the residual concern that there could be species that I've just been explaining in the biotope that are important, but that might have been missed because of the level of survey. So Burmann's nudibranch, seagrass, bedrock is a big proportion of the intertidal space and the issues that presents and the species there. And Manx Wildlife Trust submitted on D1 the depth sampling and contaminants. And they also highlighted, I think, significant issues around brittle star beds. So if we move to the first question, and that's within the context of the sea search data, the two additional pieces of information that Manx Wildlife Trust have submitted. So that's the two sea search diver surveys. One was before submission and one was after, 2022-2025. So question one then is, can DEFRA and Manx Wildlife Trust explain their key concerns in a succinct way with the surveys and what they still feel is missing? So I think if we ask DEFRA first, if that's all right.
Peter Duncan on behalf of DEFRA. I think what we're trying to get to with environmental impact assessment is categorising the impact, and the impact is defined as a change to baseline. As such, the baseline needs to be properly characterised in order to understand the impact. When we look at, and the survey report was useful in defining where we are at the moment, but it raised additional questions as well as looking at the survey sites in relation to the corridor and the array area. And DEFA fundamentally don't feel that there is sufficient resolution across those areas to provide a baseline that's sufficient then to derive an impact assessment from.
Okay, and Manx Wildlife Trust?
I would just sort of confirm what Peter Duncan has just said at DEFA, that it's not adequate enough to characterise the survey. And obviously we've raised from the beginning the fact that the most up-to-date sea search data hadn't been used, even though we had offered that to the applicant. And I appreciate the brittle star beds at Harrisdrake were done after the submission, but it just then confirms that fact that there's the potential for other things to have been missed. Yes.
Would the applicant like to respond?
Ryan McManus for the applicant. If I can kind of take those two things one by one, so I'll take the DEFA point first. So just to summarise where we are in terms of discussions with DEFA about the adequacy of the baseline characterisation for benthic ecology. So we're in continuing discussions with DEFA over the adequacy of that baseline characterisation. It was discussed in brief at the physical processes workshop that we talked about just now, but we haven't had a detailed follow up on this topic specifically, though we do plan to do that before deadline 4. I think just to sort of summarise DEFA's concern is that we haven't characterised the baseline environment from a benthic ecology perspective adequately, and that includes that they don't agree it's been characterised adequately for the purposes of EIA. And to be clear, the applicant does believe that the baseline environment has been characterised appropriately and adequately for the purposes of EIA. The EIA has been carried out by a competent, qualified benthic ecologist, and it's important to note that the purpose of establishing the baseline environment for EIA is to identify the likely habitats and species that are likely to be present in the study area and therefore likely to be affected by the proposed development, so that they can be assessed and any mitigation measures can be identified and secured in the consent. The benthic survey alone is just one part of the baseline characterisation. It's quite an important part because it provides site-specific recent information about what the habitats are on the seabed and what species are living there. But it's not the total of the baseline characterisation. It uses other desk-based sources, pre-existing information, previous historical surveys, and consultation as well. With DEFA and the Manx Wildlife Trust on what species and features of conservation importance are likely to be present, and that's all carried through to the assessment. That there's a couple of comments that have been made about specific features, such as we didn't identify any horse mussel reefs in our benthic surveys. We didn't identify any merle beds, and yet those features have still been assessed, and we've still predicted potentially significant effects on those features and secured mitigation for them, because we know that although they weren't identified in the survey, they are still likely to be present in the study area. So there's kind of two parts to it. One is is the baseline characterisation suitable for the EIA? We believe absolutely it is, and it's in line with standard best practice that's been applied on other projects. Perhaps the second point comes to whether the survey would be adequate for identifying the precise mitigation measures that are required in the pre-construction phase. And for that, we acknowledge that it's not, and that was not the intention of the survey, which is why we've secured follow-up pre-construction surveys once we get into the detailed design phase to survey the precise locations and cable routes to identify whether those features are within there and whether any siting around them needs to be applied through the biogenic geodynamic reef mitigation plan.
Okay, thank you. That's a really helpful summary. So we'll move on to the mitigation plan in a minute. That's the next agenda item. So given that it's not possible to undertake these surveys now as part of the examination or in the middle of the examination, it seems to come down to the definition of the surveys you'll take pre-construction and how comprehensive and detailed those are and when they're carried out. And I think it's an issue for DEFRA and Manx Wildlife Trust to work to set out what those would look like and how they're secured as part of the management plans. So could I turn to DEFRA for comment on that, and then to Manx Wildlife Trust? I think that's the main way forward for this, to make sure that before work starts, people are comfortable that the right survey is in the right place at the right time. So if I go to DEFRA, please.
Peter Duncan, DEFRA. Yeah, I think that's the obvious approach to it. I would add a comment that we made. Given the current resolution, and we don't necessarily have an argument with how the survey was conducted. It's really about the resolution of it and the likelihood of picking up fine-scale habitats and species versus broad-scale habitats, which is what it's done. So given that and the survey report provided evidence that it was picking up potentially important areas, and we don't know the extent of them.
Yes, understand.
And so extent is important as well as presence. So that will be the feature of forthcoming surveys. I think, given the uncertainties, we've made the suggestion that the biogenic and geogenic reef management plan is not flexible or encompassing enough, and what we would like it to look like is a sensitive features plan, which gives us the scope to build that into whatever we may find when the high resolution surveys are conducted.
It's the next agenda item, the actual plan, the mitigation plan. Yes, that's absolutely right. You make a really good point. So if we just focus on the surveys for the present. So have you contributed comments, forgive me if I've missed this, to the draft outline plan that's already been submitted into the examination? And have you worked to shape the survey requirements in there? If I ask Manx Wildlife Trust, would that be all right, Manx Wildlife Trust?
David Bellamy from Manx Wildlife Trust. In terms of the surveys, one area where we haven't yet commented upon is because there's been new material information coming to light even since the last specific hearings. So DEFRA's Blue Carbon Report, which I know we'll cover in detail at 6E, but very, very briefly, it has completely changed the baseline characterisation of the area.
The report has, the blue...
Yes. So what DEFRA are finding based on their most recent survey is that in the northeast corner of the order limits area, there's a significant area of offshore circulatorial mud. However, in the EIA baseline characterisation assessment, it's classing the same area as being sand. And so I've got two maps in front of me showing two completely different things. And given that the DEFRA Blue Carbon Report has found that mud is the largest store of blue carbon, this is to quote, and plays a significant role in the Isle of Man's blue carbon budget, then this is a really significant area that I don't think we can skip over. And also, I've got a question in terms of MEMA. I'm not entirely sure whether or not, given some recent changes, whether MEMA is a consenting regime that overrides the Climate Change Act of 2021. I know the original iteration doesn't do that, but I think it may have been updated since. But of course, the Climate Change Act 2021 has got quite significant obligations about protecting our existing carbon stocks. Thank you. Oh, sorry, my colleague had a further point.
I will take the point about the Climate Change Act away, and we'll I think my colleague wants to step in actually on that response.
That is an important point to note. Now, our existing understanding is that there is a range of legislation that MEMA does exclude or disapply, but that the legislation that you refer to there is not amongst that. Now, if anybody disagrees with that view, I think it would be very important to surface that. But if I can just check in terms of a brief legal submission,
Amy Sterling, on behalf of the applicant, I wasn't aware of any suggestion that MEMA disapplied the Climate Change Act, so this was news to me. We're happy to check.
Yes, well, we currently understand that it doesn't, and that's the basis under which we will proceed.
So thank you for the information and the Blue Carbon report and more recent characterisation of the baseline. We still come back to the survey and how prescriptive and detailed the survey is. This has to be a conversation between Manx Wildlife Trust and DEFRA, I think, defining the survey and what they think would be acceptable. And then an agreement with the applicant on whether it's acceptable to them also. So can both organisations get their heads together on this fairly quickly, please?
I would potentially suggest that it's for the applicant to come up with a methodology that then DEFRA and ourselves would agree or disagree with.
David Bellamy for Manx Wildlife Trust. One perhaps very quick solution would be if DEFRA are able to share the GIS shapefiles of this area of mud with the applicant, then it would be possible very quickly for the applicant to overlay the order limits and the location of the proposed wind turbine generators and cabling with the newly discovered mud area, and then we could immediately see how much of a potential conflict that there is. It may be that this is all academic and that there's very insignificant impacts.
I'm nervous to suggest the applicant comes up with a methodology, although we can end up at that point, because the applicant will come up with a methodology which will not have the parameters in that you want, and you're all the bodies that have objected to what the applicant has now. So I'm sorry to put the onus on the NSCVs, but I think it is, even if it's just a schedule or some kind of requirements to be discussed, I think you do have to get together and decide what it is, because the applicant's proposal is already there in the outline mitigation plan. I'm so sorry, I know it's a bit of work for you all, but this comes back to the point, and I might have labelled it a little bit at the beginning of the hearing about how important the management plans are, because they are your tool for protection in lieu of the Wildlife Act, and also, as my colleague has rightly said, any articles in MEMA, so the MIC. So can I issue an instruction, the next deadline for the two organisations to set out a proposal, because as Ms Sterling said at the last hearing, we're at the peak of the examination now. We still do have some time to go, so there's time to work this through, but we really do need to start working through the detail. We can't just be arguing about what the baseline characterisation is anymore. So can you, by the next deadline, come up with your proposal for the pre-construction surveys for benthic ecology?
While you're looking at what the surveys need to include, and indeed the pre-construction survey plan, I think it might also be very helpful to look at requirement 25 in the draft MIC, and see whether that is adequate to secure the controls that are necessary for surveys such as this, and to ensure that the baseline that both parties require, DEFRA and Manx Wildlife Trust, are adequate. I think the point about the applicant coming up with a proposal, I do have some sympathy with that as well. And can I just request the applicant to think about comparative such management plans, and provide us with that assessment of whether you feel on what your own assessment is of the adequacy of the plan.
Amy Sterling, on behalf of the applicant, yes, just to confirm, there are two places where this pre-construction survey is secured. There's requirement 25 pre-construction surveys, reference to pre-construction survey plan, where this survey is one of the pre-construction surveys which is secured, but the survey is also secured through the outline biogenic and geogenic reef mitigation plan, which is document D1 102, and in that the applicant sets out high-level survey methodology for the survey that it proposes to undertake. So would welcome comments from DEFA and Manx Wildlife Trust, and we can consider whether or not like a higher level of resolution or any other matters, whether that would be feasible to include within that plan.
That's exactly what I'm suggesting, that they come back with you, because you've already submitted the plan, so they have to come back with you with some proposals. But I do empathise with the work that it's going to require on the behalf of the bodies. I just think it's an essential step now, otherwise we're going to go around in circles. So that's by deadline 4. Deadline 4. I'm reluctant to ask the applicant to reply by deadline 5 because it's such a close deadline. Do you think you could respond by deadline 5? Please, the applicant. Oh, so sorry. Sorry, the applicants agreed to respond by deadline 5, then we can really get it moving and anchor what the issues are. So if we move on then, sorry, my colleague, step in. So the next topic is the outline geogenic reef mitigation plan, which I know DEFA wants to expand to a broader plan. So if I just summarise, I think there's 2 areas that DEFA are uncomfortable with. One is the thresholds and criteria, and the second is the scope. If I've got it right, DEFA can comment on my summary. So DEFA feel there's a lack of agreed thresholds and criteria for determining biogenic and geogenic reef. It's currently against published criteria for reefs. In their response, they say they're concerned about interfaunal areas of high-density horse mussel, and that these may constitute a sensitive conservation habitat based on succession and recovery and higher biodiversity considerations. Also, scope, excuse me. They're concerned that the BGRMP is the only mechanism for mitigating impacts to sensitive benthic features, and it only covers things like marl beds, but not seagrass or anything of sensitivity not yet identified. I think that's what they're concerned about, which comes back to the characterisation survey. So what I'm trying to do is move it forwards and look at how we survey the area correctly or in agreement with everybody, and then how we manage the process going forwards to the plan. So am I right in the summary, DEFA? Is that your key concerns? Okay. So if I move to the applicant first, can the applicant briefly summarise the updates they've made to the plan and how they address the concerns I've just highlighted that have been raised by DEFA with respect to the lack of a detailed plan in PCR 177 and the absence of agreed thresholds for biogenic and geogenic reefs, which is D1062. So if you step in, applicant.
Ryan McManus for the applicant. Yes, so as you said, we've provided some updates to the outlined geogenic reef mitigation plan at deadline 1, and we continue to consult DEFA on those updates and plan on making further updates if necessary at subsequent deadlines. So just to summarise the updates that have been made, the first is to better define that pre-construction survey requirement. So within the outline plan, it now sets out in high-level terms what the geophysical surveys which would be conducted in the pre-construction phase would look like, how the data from that survey would then be interpreted by a benthic ecologist if they identified potential features that required further investigation, and if necessary, those features may then be followed up with further survey through drop-down video surveys, which is also now described within the outline plan. The second key update has been to provide further information on what the thresholds are for where mitigation is required and what established methodologies would be applied to determine whether a feature meets the threshold for requiring that further mitigation. And that's specifically in reference to established methodologies for defining marl bed habitat and horse mussel reef habitat and geogenic reef or stony reef features. And then finally, a more descriptive outline of the precise mitigation measures to be employed has now been included within the plan. So, that primarily focuses on the siting and routing.
Thank you. That's really helpful. Thank you. If I could just turn to DEFA to respond to that.
Peter Duncan, representing DEFA. DEFA responded on the basis of the adjustments to it, and I think it was useful to read that in the context of the survey report, which we hadn't seen before. And so while the outline plan says that agreement will be made about what defines a reef or any of the features, it appeared that the survey had already reached that conclusion and rejected it in the case of Modiolus, and so it wasn't then included in the impact assessment. So until we've agreed what counts as a feature, and we're not trying to rewrite the book, it's quite clear what a biogenic reef, horse mussel biogenic reef is, but what do you do with the bits that are potentially expansive and still...
So does this come back to your question 1682, where you're concerned... So how does the applicant mitigate for species that have not been characterised? So we've got Berman's nudibranch, timid burrowing anemone, ocean quahog. They weren't identified. I think your concern is that they won't be mitigated against going forwards if they are identified. Is that what you're saying?
Sure. So the issues of definitions and scope are interrelated. If you don't do a high resolution enough survey, you don't know what's there, and therefore you can't mitigate against them. And if we don't agree on what counts as mitigable, then they're not assessed. And in the case, I use the example of the infaunal horse mussels, that may or may not be a precursor to building a reef into the future, but if you ignore it as that potential, it's not dealt with.
Does Manx Wildlife Trust have any comment on this? No? Okay. So I think you suggested that the outline sensitive benthic fetus mitigation plan, specifically the D1, sorry, I'll rephrase that. You're proposing a broader plan. So you're proposing an, sorry, I'll say it again, outline sensitive benthic features mitigation plan, which you highlighted in your response D2062 as a solution. So it's introducing a broader spectrum rather than a specific reef mitigation plan. Have you discussed that with the applicant as part of your SOCG?
Peter Duncan on behalf of DEFA. No, we haven't. It was a proposal that came up during our...
So DEFA's suggesting that the plan's redefined to widen its reach, as it were, to ensure that species that are not identified in the characterisation are mitigated against if they are identified in your new surveys that you're going to be undertaking once you've agreed the methodology. So could I just pass that to the applicant, please?
Amy Sterling on behalf of the applicant. Yeah, we consider that sounds reasonable. We were just coming to the same conclusion.
Oh, brilliant. Okay. Well, that's perfect then. That's real progress. Excellent. Moving on then. As part of the discussion on what that looks like, are you able to clarify the benthic features that you're concerned about and that should be covered so that the plan covers all bases? Noting that we've accepted the change to remove the southern alignment, so that's no longer in play, although I'm not sure that makes a difference because you still have to cover the full scope of species. If you'd just like to respond to that, and perhaps the applicant, I think you can tie this up to your discussions on the plan, can't you? I don't think it's a big issue, actually.
Peter Duncan on behalf of DEFA. I'd be reticent to do that because until you know what's there, you're by defining all of the features. Yeah. And I think that's possibly where we got to this point in the first place. When we looked at it in the round, we said, well, what are likely features? And so we ended up with quite a narrow definition. Yeah. I think now that we are where we are, and if we do a high resolution survey, we find what we find and we agree what's sensitive.
So that makes sense. So I think you just build that into your discussions with the applicant, if that's all right. So I think this all feeds into resubmission of the outline plan, doesn't it, really? So this is part of those same discussions. So if you could have those discussions, you're going to present your preferred methodology or some instruction on the methodology. You're going to tie that up in the manner... So I'll start again. People on the right are going to work on the methodology, which is going to go to the applicant for the next deadline. The applicant's going to comment on the methodology, so we're going to sort that out and lock that down. And then moving forwards, so as part of those discussions, can you also discuss the new idea for the plan and the broader reach. Does that make sense? Is everyone comfortable? Okay. So moving on, we've only got 5 minutes, but I do want to touch on, so if we could just have figure 7, volume 4, annex 1.1 up on the screen. Yes, if we could just look at this. Is the applicant ready? Oh, okay.
Amy Sterling on behalf of the applicant, so I was just discussing between us what we've said in terms of what the update to the plan would be. The applicant's intention would be to update the plan so that if, when we're carrying out this more detailed survey pre-construction, that survey identifies any benthic features which were not identified within the baseline characterisation, then there would be a process to discuss this with DEFRA, for example, and agree any necessary steps that need to be put in place.
That sounds perfect. Yes, brilliant. Is that okay with it? Is everyone okay? I'm sorry, I didn't realise you had some more to say. I'm so sorry about that. If we move on to the next item, is that all right? So the next item is it's about micrositing around the reef. And if you look at the plan on the screen, which is figure 7, volume 4A, annex 1.1, physical processes technical baseline, APP 076, showing the Grudel Bay inset. And I think DEFRA have raised a concern, and I'm not sure if Manx Wildlife Trust, but anyway, DEFRA raised a concern about the extent of bedrock. So if you look at the top left-hand corner for Grudel Bay, it's all brown, is that? Yes, which is bedrock. And I think DEFRA have raised the concern that micrositing is a solution to avoid species. I think that's what you're saying. But if it's all bedrock, how are you going to do that? Is that the basic principles, I think, of the issues you're raising? So, and also within the context of paragraph 1115, which says micrositing around relevant features wherever reasonably practical will not not resulting in a hazard for marine traffic. So I think, do you want to raise the issue, DEFRA, with the applicant to respond, or is the applicant better to? I think if the applicant presents the issue, if that's all right.
Ryan McManus for the applicant. So yeah, what this figure shows, which is from the physical processes baseline characterisation report, is the results of the geophysical survey that we undertook in 2024. And yeah, at Grudel Bay, you can clearly see there's quite extensive bedrock in the nearshore environment there. Just to clarify the assessment and the features that we're assessing against and proposing mitigation for, bedrock itself is not classified as reef without associated. There are other criteria there are very specific criteria that define what a reef is, and bedrock by itself does not necessarily constitute a reef environment. A reef is characterised primarily by relief and elevation from the surrounding seabed, and usually associated with a difference from the surrounding seabed in terms of its composition. So when we're talking about rocky reefs and stony reefs in the context of what we are proposing to site around, we're really talking about the environment further offshore, where there are potential reef features which come out of the more sandy environment. So yeah, bedrock itself isn't reef, so we wouldn't be proposing to microsite around it, and obviously you would. So it's not practicable in that area.
I understand. I thought that the sea search data that Manx Wildlife Trust had submitted implied that there could be reef in this area.
Right, for the applicant, yes, there is potential for rocky reef in this area. It's just that it doesn't equate to what is shown on that figure, which is just bedrock.
I'm not suggesting that the entire bedrock area is covered in something special, but I'm just asking for the mechanisms for micrositing around reef if it's discovered in the new survey method you're going to present, and whether that's actually practical. I mean, I don't know the extent, so if it covers an extraordinary amount of the rocky area, what's the backup plan, I think is what DEFRA's implying. Because the micrositing tool becomes slightly ineffective if there's nowhere to go, really. Do you want to take this away and think about it?
Ryan Mess for the applicant. So we have reviewed the sea search reports that Manx Wildlife Trust submitted, and yes, it does identify some stony reef features as well as some other biotopes. So brittle star habitat, brittle stars on mixed sediments and on bedrock, as well as some kelp biotopes in that area.
Yes, that's
so clearly it's a patchy mosaic of habitats rather than the evidence suggesting that the whole area is characterised fully by rocky reefs that would make it impracticable to avoid them at this stage.
But you haven't surveyed it, so we don't know. Is that the general conclusion?
Dr. Carroll, on behalf of the applicant, we haven't surveyed it yet, so as part of our pre-construction survey, we'll go in, we'll survey the whole area, geophysical, geotechnical survey. We'll do a drop-down video. We'll characterise that. That will go to our engineers, who will come up then with the first pass of what would be the cable route. We then will sit down with DEFA and others to route around sensitive features based on that newly acquired data. Then at the time, whenever they go to install, if there's other features that are present at the time, we will microsite around them at the time of installation. If upon acquisition of the data and review that it's not possible to get across reef, then we'll need to come up with an alternative method. But it would either be a HDD further off, so it would be a multiple HDD, or it would be an amendment to the consent.
Understood. That's where I was getting to. What's the backup plan, as I said earlier? So if the move is to HDD, I'm sure that's an expensive move, but it would be appropriate. That needs to be in the mitigation plan. So again, handing over to the colleagues on my right, that has to form part of the proposal that you're making, Manx Wildlife Trust included, to the applicant. Is that okay? Okay. So if we just move on to the last item, we are running 2 minutes late. So GARF commissioners very helpfully submitted the Manx Blue Carbon project report, and Manx Wildlife Trust have made reference to it in our discussion, so it clearly has some very important information. I'd be helpful for the applicant to give a view on where this sits within the context of Isle of Man policy and legislation, and then I'm going to hand over to DEFA on that, because I know it's their report. You first.
Amy Sterling, on behalf of the applicant, apologies, I have to take that away. We have considered how the Manx Blue Carbon report may influence the assessment or not, as our position is. I haven't reviewed its status in preparation for this hearing. Apologies.
So I know that blue carbon is a particular focus for Nature Scot, and several offshore wind farms in Scotland have submitted blue carbon assessments as part of their climate change assessment. So I think, given it's only just been submitted and it's a new report, could the applicant take a review of it and consider it and give their response on where it sits within this legislation policy context? That would be very helpful.
Amy Sterling, on behalf of the applicant, yes, more than happy to do that. Mr. McManus does have comments on the implications of the report for the assessment, if that would be
very helpful. That's my next question.
Okay, thank you.
Oh, sorry.
Ryan McManus for the applicant. So, yeah, we've taken initial review of the blue carbon report that was submitted by GARF commissioners. It's an initiative which is focused on optimising carbon storage within the Manx Territorial Sea through blue carbon habitats like seagrass, salt marsh, kelp, horse mussel reefs, and a number of others. I think it's at the initiative itself is at a relatively early stage, and that report makes several recommendations around what the next phases of that project will be, including developing strategies, integrating it in policy, those kinds of things. And a lot of the initial aims are around building awareness and capacity in government and policy. In terms of its implications for the benthic ecology assessment, we've undertaken a review, and it has no implications for the assessment of impacts to benthic features. From an assessment perspective, all of the features that are all of those habitats that are covered in the blue carbon report are identified and assessed as features of conservation importance within the benthic assessment.
Okay.
And it hasn't identified any significant residual effects on those. I think it's also worth bringing in the applicant's biodiversity strategy here as well, because I think a lot of the goals of the biodiversity strategy and the blue carbon report are aligned, and the biodiversity strategy the applicant has submitted as part of its application includes seagrass and merle in its worked example of how the applicant could deliver net positive impacts for biodiversity, for example. So I think the applicant would consider that the blue carbon project would and could align with the applicant's own intention to deliver net positive impacts.
So does that have any implications for your climate change assessment that you've already done?
Right, for the applicant. So I think, as you correctly said, the climate change assessment that was submitted with the application didn't include an assessment of blue carbon habitats.
So if you could just give a summary alongside how this sits within the legislative policy context, your views on the report, where that sits within your assessment, the relationship to the assessment, that would be great by deadline 4.
Amy Sterling on behalf of the applicant. Yes, happy to do that. It is a report authored by DEFA. They're here in the room, so it would be useful to hear their views. Thank you.
Last question of the morning then to DEFA, because it is your report. I'd like you to give a summary of your view on how this sits in relationship to policy and legislation, and also the assessment, particularly the climate change.
Ken Milne, representing DEFA. Before I go into the policy part, I'll probably just touch on the fact that this is a report based on a number of surveys around the island, but obviously it wasn't extensive and cover all the island's territorial seas. And what we found, probably the main finding, was that it was the muds, especially in the western of the island, the West Irish Sea mud belt, that's the biggest carbon sequestration site for us on the island, far more so than seagrass and those other features, although they are very important. But it does set out very clear that this is a major important area for us, and we need to protect these carbon sites as much as possible.
So it reinforces the survey and the mitigation, that I think is what you're saying.
Indeed.
That's very helpful. I think on that note, it's been a busy morning, but I hope we've moved things forwards to some extent. I'd like to thank everybody for working so hard with us, and we'll break for lunch. We're a little bit late, so if you just make one moment in terms of return back at 2:30, that'd be fantastic. Fantastic. Thank you so much. So if we make a start then, is that all right with everybody? Is the applicant ready? Yeah, okay. Start with fish ecology. Am I close enough? If we start with fish ecology then. So, as with the last sections, perhaps, I know I've invited the applicant to give a summary. If I just go through the issues, you can update on where we're at. Would that be all right? Otherwise, we're going to get into a he says, she says. So if we start with the fish methodology position paper that you've submitted and the sand eel clarification notes, that's D1063, D1021. And from the SOCG, D1033 and D1041 with DEFRA and Manx Wildlife Trust, there's still issues regarding the sensitivity and magnitude of the assessment. I think that's fair. Is that an agreement? Everyone's still? Okay. So if we start with sensitivity, I think the issue here was around the sensitivity approach to local species and acknowledging that species are indicated as high where they're of local importance. And I think that the applicants corrected the status of sand eel, is that right? So they were classified as regional, and now you're recognising that they're of national importance as part of your work. And that's noted in the underwater noise sensitivity assessment that you've recognised that. So you've confirmed that they should be classified as national. So we're looking at the importance in relation to them and other species and the sensitivity that's applied. And I think I mentioned sea trout earlier and the level of sensitivity. So we've been through that cycle, as it were, and you're going to give a paper explaining sensitivity and what's been applied to it. So I think it's the same question. Can the applicant check through the chapter to ensure the species are assigned the correct level of sensitivity in the assessment, which works back to the first table that we were talking about, and advise if any changes are made and whether that affects the assessment outcomes? I just think it's a logical continuation of what we've been describing earlier. So then on to magnitude. I think DEFRA have residual... I'm sorry, I should go to DEFRA. Are you okay with that proposal to move it forwards? Okay. And Manx Wildlife Trust? Okay. So on magnitude, I think DEFRA still have remaining concerns about how fish species are addressed in terms of the Isle of Man waters as opposed to non-territorial waters. Is that right? And so I was going to put a question to the applicant. Can you respond to DEFRA's concerns in D10, 16, and provide an overview, I think that's what you're going to do in your paper, of how determination of sensitivity, including vulnerability and magnitude, takes account of the impacts on fish and shellfish resource in the Isle of Man waters, acknowledging there's a difference between the management of fish stocks, harvesting and movement of vessels between the UK and the Isle of Man waters. My thanks to the applicant, if that's all right.
Thank you, Ryan McManus, for the applicant. So, yeah, I guess just to give a summary of where the discussions have got to. We've as we discussed earlier this morning, we've held a workshop recently with DEFRA to discuss the DMRB approach to sensitivity and magnitude and using physical process as an example, but we do plan on holding follow-ups with DEFRA in the coming weeks, specific to benthic and fish ecology. Just in reference to the position paper that was submitted, the fish and shellfish methodology position paper, that was a copy of a document that was submitted through the evidence plan process in the pre-application phase.
Okay, that's very helpful.
Not a new document as such, and that formed the basis of a workshop during the tag process that was outputs of that meeting were then taken forward into the methodology that was applied in the the assessment chapter. So we did discuss the categories of value that you mentioned there. It's just to confirm that those updates were made in the application.
Right. Okay.
Through that tag process.
Thank you.
So we've also responded to DEFRA's comments in the public consultation response, and we intend to hold further workshops in the coming weeks and provide an update in deadline for through the Statement of Common Ground.
Thank you, that's really helpful. So we had DEFRA's concerns, you've had a workshop, the applicants just summarised the results of that workshop and the state of play. So given all that, and noting that significant adverse effects have been concluded for a whole range of different areas, different activities, is DEFRA comfortable with where we're at? Are there any more concerns about these two issues, so sensitivity and magnitude, or can we close that one out now?
Ken Milne, representing DEFRA. In principle, we're content with that, but we also have to go through those workshops and see the outcomes that come from it.
Sorry, could you say that again?
Sorry. We are, in principle, we are content with what's been proposed, but we've obviously got those workshops on those specific areas that we need to go through, work through, to see what comes out of it. Because so far, the workshop's only been on physical processes.
Oh, okay.
Yeah.
Yeah,
so is the applicant comfortable with that?
Yeah,
it would be quite good.
That's what I was saying, that those workshops are happening in the coming
No, I
weeks,
understand
so,
that,
yeah.
but I was hoping we could close that magnitude and sensitivity, so that apparently is not, that's not the case yet. Is that what we're saying?
Peter Duncan, DEFRA. No, I don't see that we can close it because we haven't seen the outcomes, and so the fundamental, I don't see that we can close it yet until we see what the outcomes are.
Outcomes of?
The assessment on the receptors.
Sorry, I'm really confused. Is there a new assessment being done?
Ryan McManus for the applicant.
Sorry, Ed.
No, there's not a new assessment that's being proposed. It's justification for how we've reached the sensitivity conclusions that we already have.
Okay,
and
right. The clarification.
Just to pick up a point as well about significant effects, that's only in relation to herring, not sand eel.
Okay, yes. No, yes. Okay, that's fine. So as long as everyone's comfortable, we'll move on then, if that's okay. So the next agenda item was the approach to assessment in relation to concurrent and consecutive impacts on fish receptors, and the applicant's response to D110 question 11022 on interrelated effects and in the fish and fisheries chapter. And here there's also an ongoing discussion between applicant and DEFRA regarding underwater noise impacts on sand eel. Do you want to give an update, perhaps the applicant and then DEFRA, on where we're at with that?
Ryan McManus for the applicant. So this is an update on where we're at in discussions on concurrent and sequential
and the underwater
effects.
Noise impacts on sand eel.
Yeah, okay. So Ryan McManus for the applicant. If I start with the sand eel point, because that was the first agenda point, sorry. So we submitted a sand eel clarification notice at deadline 1. In short, that basically provides additional justification for our sensitivity approach for sand eel. I can hand over to Ms. Pfeiffer, our fish ecologist, to talk through any specific technical questions you have on that.
Okay.
But essentially, it comes to the conclusion that despite sand eel having strong dependence on certain seabed sediment types during certain life stages, the effects of recoverable injury, TTS, and disturbance are still temporary and intermittent. And when you consider that together with the precautionary assumptions in the underwater noise modelling and the widespread distribution of sand eel within the Irish Sea, that is not expected to result in a significant population level effect. So I think that the area of disagreement is about what that means in an Isle of Man specific territorial waters
scenario
context, essentially. Yeah.
So sand eel were assessed as having medium sensitivity to the underwater noise generated during activities such as piling, with a maximum magnitude of cumulative impacts considered to be minor adverse, so no significant effect is what we're saying. So although they have medium sensitivity, they have as a quick recovery, but they have the ability to recover. Is that the issue here that we're talking about?
Ryan McManus for the applicant, yes, and that assessment of medium sensitivity is itself precautionary. And if I may, I'd like to hand over to Ms. Pfeiffer just to explain that a bit more. I mean, it is all set out within the clarification.
Yes, I understand. I've read it. Yeah,
a bit better.
Okay. Do you want to hand to your colleague to explain? Okay. Simone.
Ms. Pfeiffer, DEFRA on behalf of the applicant. As Mr. McManus said, we submitted the sand eel clarification note at deadline 1, which includes additional information on how we derived sensitivity and the assumptions that we made within the assessment. We also provided additional information on the distribution of suitable sand eel habitat, and also included information on pre- and post-construction sand eel monitoring other offshore wind farms in UK waters, to provide some context on the potential impacts on sand eel from both underwater noise and general offshore wind farm constructions. I think I'd like to emphasize 2 points here. So in relation to the sensitivity assessment, sand eel are part of group 1 fish, which means they are only sensitive to the particle motion element of sound, so they cannot perceive sound pressure levels. That means that they're also less vulnerable to physical impacts that are caused by sudden pressure changes, which are part of piling operations. So therefore, they are much less sensitive than, for example, herring. In addition to that, as Mr. McManus already pointed out, potential effects include, for example, changes in hearing sensitivities, as well as this behavioral changes. However, these effects will be temporary, and there is good evidence that indicates that changes in hearing sensitivity, for example, will resolve within a couple of weeks following the end of piling operations. So taking this information into account, we do feel that a medium sensitivity rating is precautionary for sand eel. And then in terms of the magnitude assessment, as Mr. McManus already pointed out, there are several precautions built into the underwater noise modeling itself. For example, the models are run based on the maximum hammer energies, and they also do not take into account the change in noise characteristics with distance. And we do know from more recent evidence that impulsive sounds does change with distance to become more similar to continuous noise, which is to which sand eel are much less sensitive. And then the third one relates to the actual threshold that we applied for sand eel for TTS, which is based on the 186 decibel threshold recommended by Popper. However, Popper itself provides evidence that for a species like sand eel, the threshold would be much higher. So we feel that taking this all together, we also provided a very precautionary assessment in terms of impact magnitude. So taking everything together, we do feel that our assessment for sand eel is highly precautionary, and therefore we maintain our position that there will be no significant effects at the population level.
Thank you. That was very helpful, Ms. Pfeiffer. Thank you. So I think as part of the clarification note, you refer to examples from Beatrice and Mooir East offshore wind farms, where post-consent monitoring has shown that the sand eel populations were not adversely affected following wind farm construction. So I think if I pass to DEFRA to see how comfortable they are with what you have both described and the comparison to other offshore wind farms and the ability of sand eel to recover, that would be really helpful. Thank you.
Peter Duncan, DEFRA. I think the issue is similar to others that we have been discussing. Principally relates to considering it at a population level versus the local level, and there are a lot of fairly high resolution issues that Ms. Pfeiffer just outlined, but they don't very well take account of proximity of a sand eel nursery and spawning ground so close to the shore, and its interaction with trophic considerations such as birds Or seasonal factors, and again it comes back to that there's no effect at the population level, which is regional at best, and so our concern remains that there's no acknowledgement of potential impacts, even precautionary. If that makes sense, it's the coarseness of the assessment level, and we remain concerned that it's not dealing with local and proximate.
Does Manx Wildlife Trust want to make a contribution? No. So the applicants work through the method that they've used. It's a similar method, I'm assuming, to other wind farms, and the conclusion is that the sand eel have the ability to recover. So I'm not quite sure. So are you saying that spawning has not been taken into consideration and that that's an issue, and that the Isle of Man context has not been taken into consideration? That's an issue. Are those the two main issues you're talking about? Because the fish themselves, it sounds like, recover quite quickly. I think they're like a swim bladder, so they're able to move along the seabed. Is that right? I'm assuming. But anyway, so could I just try and...
Sure. Peter Duncan, DEFRA. So I think it's an additive set of concerns. So temporary impacts, I may be wrong, but I believe in the document it talks about 2 to 10 years. You've got spawning and nursery considerations on top of that. So there's a cumulative set of considerations which provide a much more complex receptor than considering it at considering them at the really on a sound level at a regional scale.
So what's the function of sand eel in this assessment then? Are they the prey of the herring? Is that right? No. So I'm not quite sure. So the key issues are that globally, the sand eel, in terms of spawning, nurseries, the fish itself, is not that the global context of the fish is not taken into consideration in the assessment. Is that what you're saying?
Peter Duncan, DEFRA. I'd say it's the local consideration hasn't been taken into account.
So if I could hand that back to the applicant, then how have you addressed the local situation?
Ryan McManus for the applicant. So obviously the impact itself is occurring at a local scale within max territorial waters. We consider the population level assessment approach to be appropriate because they're a mobile receptor which move throughout the Irish Sea. There are habitats which are suitable for sand eel throughout the Irish Sea as well. It's not like this is the only place where they are found. They are part of a wider population, and there isn't any evidence to suggest that sand eel are a discrete population within local waters, and that they're pelagic spawners as well. So that means that they spawn in the water column. So their eggs and larvae drift with currents. So although they inhabit the seabed in sediments that are suitable, they're pelagic spawners. So there's connectivity within Irish Sea.
So we seem to be diametrically opposed. I'm not quite sure what else you need to have confidence in the assessment. Are you saying that the assessment's incomplete, that the magnitude sensitivity is incomplete? I'll hand over to, I think, Ms. Pfeiffer, who's got a response to that. If that's all right, Ms. Pfeiffer, I think you had your hand up.
Yes, Ms. Pfeiffer, on behalf of the applicant, maybe to clarify, so the sand eel eggs are deposited on the seabed. However, their larvae, they are pelagic, so there is an element of precaution that we built into the assessment by considering sand eel to be a stationary receptor within the underwater noise leveling to take account of the eggs being deposited on the seabed, and the eggs remain there for a while before the larvae emerge, and then they're drifted by currents. Might also I'd like to add to one point that was made. We do have published evidence about larval distributions within the Eastern Irish Sea, which we presented in the assessment and within the scientific clarification notes. And these data sources indicate that areas of higher spawning activity for sand eel are concentrated around Liverpool Bay to the southeast of the offshore array and the underwater noise impact area. We do have acknowledged that there is that sand eel are present and are likely to be spawning within the proposed development area, but based on publicly available evidence, higher spawning activity is concentrated outside the boundaries of the proposed development.
I'm still. Thank you very much, Ms. Pfeiffer. I'm not really sure what DEFRA's concerns are. I can't quite nail what the specific issue is, because you seem to be presenting a lot of issues in the round. And is it your concern that the impacts are on sand eels locally due to the proximity to the coast? Because ultimately the assessments assessed the sand eel population, the impact on the population, and from what I understand, that assessment's precautionary. Is that right? So can you nail specifically what the issue is so that the applicant can address it? I'm sorry if I'm not understanding it.
Peter Duncan on behalf of DEFRA. Yeah, I tried to summarise it before. Perhaps I'll try it from a different tack. The area in which local sand eels reproduce and inhabit, according to the, I think, sand eel clarification note, is up to nearly 40% affected for spawning grounds and 21% affected for nursery grounds. If we think of them as a food source for certain species of birds that are declining around the island, then that proximate source of food is relatively more important for those local birds. So whatever happens within Manx territorial waters is important to DEFA and the rest of the community versus what happens in the wider Irish Sea, which coincidentally is also under cumulative pressure from wind farm developments. So I think we need to think of that impacts on a local level and deal with them as well as we can. So for example, in relation to herring mitigation plans, there's acknowledgement of certain times of year where they're seasonally vulnerable. That sort of acknowledgement hasn't been...
Talk about that in a minute. That's a different issue. Yeah. So so the assessment, for want of being simplistic, is the assessment. It assesses the impact on the sand eel population. I think the applicants explained the methodology. The sand eel population is the sand eel population. It moves, and I think the spawning moves by the sounds of it from what Ms. Fife is saying. But so it's almost like you're saying the applicant should assess the sand eel population in a specific location, but it's a generic sand eel population across both territories. I'm so sorry if I'm not understanding. What is it you want them to do, I think is probably the best question.
Peter Duncan, DEFA. I think you're correct. If you remove those sand eels for a period of time during construction, what do the organisms that rely upon them do for food?
So the applicant, I'm so sorry to cut, but the applicant's saying they are mobile.
They're not that mobile, they're habitat specific as to where they live, breed, etc. So there are prime areas throughout the Irish Sea that are better or worse for sand.
I'm just trying to nail each nugget of what you want about. No, don't apologise. I'm just trying to nail each nugget so that we can actually.
So some of the habitat, I don't think there's, as the applicant mentioned, I don't think there are prime sand eel habitats affected, but there are subprime habitats affected within the array area, and therefore.
So you're saying they're not that mobile, and you're worried about that habitat because they're not that mobile?
Yes, essentially. They're habitat-specific species.
So the premise that the fish move and that they can move presumably away from all the noise that's harrying out is something that you disagree with. You think they're not that mobile and they won't move. Is that... I'm sorry, I'm trying to understand. I think I have to the applicant. Do you understand?
I'll clarify that a little bit, Peter Duncan, on behalf of DEFA. They're clearly a mobile species, but they have habitat specificity for certain parts of the life cycle.
Okay. And which is spawning.
So spawning. And
so they don't move in spawning?
No, and they do inhabit sand. They are a burrowing species.
I'm trying to help.
So they don't. No, sorry. I assume certain things, but I shouldn't. Perhaps.
No, of course.
They don't live everywhere. They live in particular areas, some of which is impacted by the development proposal, as acknowledged by the applicant. And so what we are trying to do is mitigate impacts upon the areas of sandy habitat within territorial sea. And at the moment, because it's assessed at the regional level, there's no mitigation required because there's no regional level impact, but there is a local impact.
So mitigate the impacts at the territorial sea level is your first. Okay. So, and as I explained, they go across both territories, that it's not quite the same as an M&R with a whale in it. So, and the second point, I think the second point is that they're not as mobile during specific periods of their breeding cycle. Okay, I'm going to hand that back to the applicant then.
Yeah, Ryan Moran's for the applicant. So there's obviously quite a lot to unpack in all of this. So one thing is the scale of the assessment. So I haven't got the exact numbers in front of me, but I assume that Mr. Duncan is correct in the proportion of the habitat which is affected. That's only one part of the assessment. That's the spatial extent of the impact, which is its magnitude or part of that magnitude. Although that is affected, that doesn't take into account the other part of the assessment, which is the sensitivity. And what we're saying is that the individuals and the habitats have relatively low sensitivity. We've assigned a medium sensitivity to sand eel for noise, for example, and that's a precautionary assessment. The outcome of the assessment in terms of its significance is a function of both the magnitude and the sensitivity. And that's what is not significant.
I'm still, we're diametrically opposed here in terms of an agreement, but I'm not. It seems to be a standardised method the applicant's chosen that isn't easily adaptable within the context that you are expressing concern. Is that correct?
For the applicant, as I said before, we would stand behind the population level assessment as being appropriate for this EIA and this type of development. We talked a bit this morning about looking at what the scale of the impact is specifically to Manx territorial waters, and we're going to come onto this in the marine mammals section as well, because I think this is a similar kind of issue that we have with DEFRA, is that we've considered everything at larger scale, which we consider appropriate, but then from an Isle of Man perspective, which has a smaller territorial sea within that region, what does it mean in kind of quantitative terms in terms of the area that is affected in the Isle of Man? I don't think it would be a case of updating the assessment to look at significance within the Manx territorial waters, but we could provide some further information to quantify the scale of the effect in Manx waters.
I think that's perfect, yes. Does that help?
Peter Duncan, DEFRA. I think it helps. I think the only thing I would add is that may reasonably lead to the idea of mitigation, as we've seen in the herring. It's the black and whiteness of the assessment process. It either needs mitigated or it doesn't. I guess where we are is that it would benefit from having some. And so the EIA is not the be-all and end-all of the impact. It's just part of a process. If we recognise that our puffins don't want to fly to Liverpool Bay to feed, and we want to have them locally, then it's not unreasonable to build in some kind of mitigation for the local habitat, sand eel habitat, I think.
If you're able to provide another clarification note to explain the context and the regional versus local using regional for Isle of Man, although it's national's been used in other continents, but that would be really helpful. At the moment, it's not a significant effect in the assessment, and what would need to happen for mitigation to be proposed would be a significant effect within the context of EIA. So I think the applicant perhaps could explain in their note what that means, what that looks like. I'm not saying that you would do it, but it's clearly a deep concern of DEFRA's that it's not being addressed. So I think that to go through the process and explain, to take the DEFRA through that process would be helpful.
Peter Duncan, DEFRA. It would be helpful. I query from an inquisitive point of view, is significance in an EIA the only rationale that you can apply mitigation? Could that not be agreed as a component of the MIC that acknowledges what I said before and includes...
This comes back to why I laboured at the beginning of the whole day policy 4, the interpretation of policy 4, and DEFRA's interpretation of policy 4, because no Wildlife Act puts us within the realms of EIA. And no Wildlife Act means the species are not protected against bashing and being knocked during construction. They are protected under MEMA and the MIC. That's why I was very careful to explain where we're at in terms of the legislative and policy environment here. So the applicants assessed it within an EIA context, and within an EIA context, unless there's a significant environmental effect that cannot be mitigated, then no mitigation is required. We can put some context around that. We're going to go on to bats at a later stage in the hearing. So there are variables to that. There is, beyond additional mitigation, which is the plans, you can have a further level of enhanced mitigation. So I think if we leave it with the applicant to do the note, if that's all right with you, is it possible to have a conversation before you prepare the note so that the note addresses the issues that DEFRA are raising, and we can get the note into the hearing in the document so we can go through that and see if there's anything else we can do to progress the issue?
Ryan, as for the applicant, just to clarify a few things here, I think what we're proposing to do is essentially provide further quantitative information, semi-quantitative information about the proportion of habitat which is affected within the territorial sea. What we're not proposing to do is update the assessment in terms of the magnitude and the significance of that effect. So we wouldn't be looking to redo the assessment or potentially introduce a new significant effect that requires mitigation, because we don't believe that is necessary, and we stand by the population level effect is the way to assess this.
That's not what we're talking about here, but we're looking at DEFRA's concerns and hoping that your note will understand those concerns, which is why I'm saying, could you have a conversation before you write the note, and that you will address those in a qualitative way in your note, and also talk about mitigation and how mitigation rests within this context. I'm just going to hand it to my colleague.
I think there's a few points that Mr. Duncan has just raised, which I would like to get responses to quite specifically. One is the point that you just raised right at the end, which is that within an EIA context, notwithstanding what Ms. Pownell has just explained, slightly aside from that, which is that this entire assessment sits within the EIA context, but whether a significant adverse effect is the only reason to propose mitigation. And I think it's just worth the applicant thinking about that as the local government body in this area, they consider the effect to be of a level where they feel that mitigation is justifiable. And I think I'm just wondering if there's a way to move this conversation forward. And so I would like, first of all, I'd like to get your response onto that point. And then the second point is that I think I just want to re-emphasize what Ms. Pownell has said about mitigation. And essentially what we're saying is that for you to think about with DEFRA what that mitigation would be, even if at this point it might be proposed only on a without prejudice basis.
Amy Sterling on behalf of the applicant. Just taking the first point first as to whether or not mitigation can only be secured for EIA, I think the question is to think about how the mitigation is secured within the planning process. The mitigation would be secured via requirement, which is effectively a planning condition. A planning condition can only be imposed if it's necessary and relevant for planning purposes. Our position is that the mitigation wouldn't be for any proper planning purpose. There is nothing in the application which suggests that mitigation is required for Sandhill. I would suggest the applicant has carried out a very detailed EIA and provided ample amounts of technical evidence as to why the population level scale is appropriate and why, for all the reasons Ms Pfeiffer explained, there is no likely significant effect. We don't have that level of evidence at all really provided from DEFRA. As I understand their position, they disagree with the population effect and think there should be a Manx population of Sandhill which are assessed but haven't provided any evidence to support that. So I would actually suggest it's for DEFRA to provide that evidence if indeed that is what they're suggesting.
That's what I was alluding to a few conversations ago, that if DEFRA feel very strongly about the issue, they need to be very specific about what the problem is and what they propose to do to resolve it. So I think in that conversation that you have before you write the notes, I'll say it again because I've asked a couple of times, if DEFRA could be very specific about what they think the issue is and what they think needs to be done to resolve it. I think there is this local versus regional, I use regional for Isle of Man, issue, and we're going to come on to it in mammals with your DAS surveys, not DAS surveys scenario. But with mammals, there are moderate impacts that are going to be mitigated. And so delving down how you can supplement the data to look at it at a local level has been driven by those impacts, which are now elevated with the level B assessment. In this scenario, the applicant's explaining a methodology it's used, that other wind farms have used, that Sandhill recover, and so they are explaining they don't have a suitable methodology for looking at what DEFRA want them to look at. So I think if DEFRA have a different methodology with different base data that the applicant could use, they can have that conversation. So maybe you put that in the paper. So what your issues are in the conversation you have. Actually, I'm sorry, I'm working through myself. So if you, DEFRA, could provide a summary of the issues you think still remain here and what you propose as a methodology to address, to look at them, and the applicant provide this note explaining the quantitative scenario around which you have explained the situation, terrible word, and how you've explained the mitigation, which I think the applicants just explained, which was where I was coming from in terms of the really rigid context within EIA, and that there can be enhanced mitigation, but the rigid context for mitigation is significant, which is why I will reiterate again, I was so careful taking you through, including DEFRA and the interest organisations, how this works and the rules we're bound by. So the action is for DEFRA to explain the issues they still have, any proposals they want to put forward with resolving those issues in terms of methodology or local data, and for the applicant to prepare a paper explaining what they've done, the quantitative issues and their approach to mitigation. I think, sorry. I think, yeah, I'm trying to work out the timing in my head. I think it would be, so my colleagues we've just been talking through the timescales. If you could, DEFRA, prepare the information that I've just explained. If you could prepare it as soon as possible, that would be extremely helpful. But I'll say deadline 4. I think if you could discuss it with the applicant as soon as possible as part of your SECG process, hopefully next week, and get the information across to the applicant by the end of next week. I'm not going to issue that deadline as a part of hearing action, but if you could do that, that would be really helpful, because then the applicant can then respond by deadline 5. Given the dates are so close together, then I think it's worth it that you putting the work in early, DEFRA, if that's okay. I'm working really hard to see how we can address your issues and how we can incorporate them into the process. But we have to take practical steps within the policy and legislative context that we're working. Are you comfortable with that? So you'll get your issues heard, you'll come up with a solution. The applicant will look at it very carefully and they will address it before they write their note and then finalise the note. Is that that all right?
Amy Stirling on behalf of the applicant. Yeah, that's all understood, Madam. I think one thing as well that Dr. Caroline suggested is that whilst we don't support mitigation for all the reasons we've set out, as a compromise position, we'll discuss with DEFRA whether monitoring, but to sort of plug evidence gaps, for example, might be useful.
That's very helpful. If you could discuss that with DEFRA before they submit their information to yourselves, DEFRA can incorporate that in their note that they're going to send to you. That's extremely helpful, and that's a very kind offer. I think that's worth DEFRA considering, because that might go some way to addressing the concerns that they're raising. Excuse me. Is everyone comfortable? Max Wildlife Trust? No hands. Okay. So if we move on to the herring mitigation plan, which is the next agenda item. So we note the submission of the herring mitigation plan. Thank you for that, applicant. D1144, a deadline 1, and the mitigation options it presents for the significant effects on herring, which I outlined in the earlier segment that you explained what herring only, so I apologize for that. But, so you've included updates to the mitigation plan, including, I think, proposed mitigation for reducing impacts on suspended sediment deposition on herring eggs, larvae and herring spawning habitat, and proposed mitigation for underwater noise. I think you've incorporated those in the plan. So is that the main updates, or would you like to expand? I did ask you to prepare in advance to expand on any further updates you think you are making or have made that I've missed out.
Ryan, for the applicants here, I can just summarise the updates that we've made to the outline.
Yeah, perfect, thank you.
At deadline 1. Key sections include the section on defining the peak herring spawning period, which is a worked example has been provided in Appendix A of the plan. I mean, I think actually before that, the main update to the plan is that now it brings together all of the impacts in relation to the impacts on herring, whereas previously we had this kind of split across two plans. So
it was a bit uncomfortable.
It was within the underwater noise management strategy and a herring mitigation plan.
I think everyone commented on that.
So we've that's I guess the main update is we've consolidated it as to be a herring specific plan. It includes more specific measures for mitigating the impacts, and so the two impact pathways where significant effects were predicted here are from as you pointed out, from deposition on eggs and larvae from construction activities, and underwater noise effects on adult herring in the from piling. Those are pretty much the updates.
So I'll turn to DEFRA. Have you got any comments on the mitigation plan? Anything you'd like it to include that it doesn't?
Ken Milne, representing DEFRA. Yeah, we're content with that just now.
Okay. I had one observation to make is I think it includes soft start at 3515. As I understand it, that's more of a design measure, a primary activity rather than a mitigation measure. I think, isn't it where you make a small noise, see what happens, then make a bigger noise and a bigger noise, that kind of... Could that be included as a basic protocol?
Yeah, Ryan, for the applicant, it does tend to be a standard construction procedure. I guess it has two purposes. One of that is because from an installation point of view, it's the first time you're striking the barn. You want to make sure it's going I'm not an engineer. You want to make sure the pile is going in straight and it's behaving as you expected it to, but also it can be applied that the length of the soft start can be adapted to be specific to mitigation for marine mammals. Understood. Primarily to ensure that mammals are excluded from your mitigation zone.
Can you include that as a standard measure rather than a mitigation measure, please?
Yes, I mean we believe it is already. We can make that clear if it's not.
Okay, thank you. Of course, go DEFA.
Ken Milne representing DEFA. Perhaps we could ask Mr. Colley from Northern Ireland Fisheries Federation if he wants to comment as well.
Yes, if you'd like to, he's very welcome to come to the table. He's online. Oh, he's online. He's not got a hand up though. Mr. Collier.
Thank you, Mark. Yeah, I have a few things to say about the plan based on what the applicants submitted at deadline 1. So I'd appreciate a few minutes of your time today, please.
Absolutely, go ahead.
So we previously stated the importance of herring to Northern Ireland, which is contained in document D1223. So I won't repeat that today. However, it is for these reasons that the plan is of particular importance. Documents APP 091, the Fish and Fisheries Baseline Report Part 1, and APP 050 have highlighted the presence of prime preferred and sub-prime preferred herring spawning habitat within the development footprint. Given that the preference of the applicant is to bury cables and confirmation within document APP 050 that within the OECC corridor in particular, but also the array footprint, damage and disturbance to the seabed will occur, we feel that herring spawning habitat needs to be included in Table 1 of the herring mitigation plan as a receptor. We feel that there's an obvious difference between herring that are engaged in spawning activities and the habitat in which they spawn. And this appears to have been lost in the application process to date. So we feel it's important that spawning habitat is brought back in to D1117 as a receptor. Section 3.4 of the plan suggests that ploughing, mechanical trenching and dredging are options for mitigating the effects of suspended sediment on spawning herring. The non-fisheries conservation considerations that have been issued by ICES on 30th of April of this year, less than 2 weeks ago, as part of the Irish Sea Herring TAC advice, advised that such activities should not be allowed on spawning habitats. So it's for this reason that the applicant should be asked to prove that ploughing, trenching, dredging, and other forms of substrate removal on spawning habitat are not detrimental to it. Nearly finished, Mom. So I will go on to seasonal restrictions as mitigation measures. So also in the plan, it sets out some seasonal restrictions to mitigate against the effects of noise and sedimentation on the early life stages of herring. This approach is underpinned by an understanding of the current behaviour characteristics of the Irish Sea herring stock. If I may, I would like to reference the Scottish Fishermen's Federation response to written questions 1. That was document D1232. The SFF advised the deadline 1 submissions that spawning herring were present on the east side of the Isle of Man during February 2026. And we concur with this advice and can also advise that a pelagic fishing vessel with links to both the Northern Irish Fleet and Scotland caught spawning herring during late winter and early spring of this year. And they've also provided some of these samples to the Agri-Food and Biosciences Institute for analysis. This vessel has also provided us with sonar imagery of herring aggregations collected in February of this year to the east of the Isle of Man, and would be happy to provide this for entry into the examination library. As the SFF have pointed out, there is a winter-spring component to the Irish Sea spawning stock of herring that hasn't been accounted for in the fish and fisheries baseline reports and corresponding EIA. AFBI can also confirm that herring are now present in the Irish Sea throughout the year. Given this new and up-to-date information, any seasonally restrictive mitigation measures contained within document D1117 should be rethought by the applicant. With this new information, there are reasonable grounds to infer that any calculations that are performed on historical data to determine the peak herring spawning period will lack the accuracy to effectively mitigate impacts FS1, 2, 3, 4, and 5, all of which were downgraded to slightly adverse in APP 050. It's also unclear how a one-year construction timetable fits into an autumn and spring spawning period without impacting the herring stock. Finally, we think it would be useful to see the applicant's response to the matters that the SFF have raised at written questions 1, deadline 1, as we couldn't find this in document D1010, applicant's response to the XB's first written questions. If we have missed this, please advise, and if we haven't, may we request a response to SFF's points along with our own at written question 2. Thank you.
So could you just clarify the last point? Sorry, what was it that you had not received or seen?
So when we reviewed document D1010, we couldn't find in the document the points that Scottish Fishermen's Federation had raised at written questions 1. So we were unable to see what the applicant's position was on that, specifically in relation to a winter-spring spawning herring stock being present.
Okay, so just to summarise, so the first point is about herring spawning habitat as a receptor.
Yeah.
The second one is about mechanical trenching and other such activities with spawning.
Yes, and how the proposed mitigation is going to be effective.
The third one is seasonal restrictions in relation to spawning.
Yeah.
Which is what I was going to come on. I was going to come on to that. Yeah. And the fourth one is a document at D1010 where the Scottish Fishermen's Federation raised an issue written question 1 and you can't see the response.
Yes.
Okay. There's an awful lot to unpack there for a hearing session. I'm hoping to make some progress with a little bit of time in the agenda at the end that I'd saved. So the applicant, you've got those 4 points. If you'd like to respond on each one, then I'll turn to DEFRA if it's okay.
Ryan McManus for the applicant. So the first one is in relation to direct impacts on herring spawning habitat from direct impacts. Okay. So
as a receptor in your schedule of D1.
Treating herring spawning habitat as a receptor within the IA in relation to direct impacts. So that is
just
considered.
To clarify that is what you're saying, isn't it, sir? The herring spawning should be a receptor.
It should be identified as a receptor within the herring mitigation plan.
Okay.
Ryan, for the applicant. So it is identified as a receptor within the EIA. So right. within under impact FSO2, which is direct damage and disturbance effects essentially within the footprint of the development. The herring spawning grounds are identified as a receptor within that assessment. based on the fact that the majority of the high-intensity spawning grounds are located outside of the footprint of the array, or there is some overlap in the cable corridor. The majority of the high-intensity spawning grounds are located outside of the footprint of development. So, on that basis, it was not identified as a potentially significant effect in the IA terms, and that's why it's not included in the herring mitigation plan. Whereas spawning herring as a receptor itself and eggs and larvae are, because that's what significant effects were identified in relation to deposition and noise.
Herring are not, but spawning habitats and larvae are sensitive receptors for mitigation.
They're all receptors which have been assessed.
No, in the EA, but for mitigation.
Yeah. For mitigation, it's only the herring, the spawning herring, and the eggs and larvae.
Yes, I've just. Okay.
Yeah.
Are you satisfied with that, Mr. Collier?
No.
Okay. I think no, if we go through the points one by one, if that's all right, so we can just. So the second point is mechanical trenching.
Yes. So mechanical trenching, ploughing, dredging have all been offered up as mitigation measures to reduce suspended sediment on spawning herring. I mean, our issue there is that it contravenes the advice provided by ICES that activities such as this should not occur on spawning habitats.
Which you very carefully explained. So if I just pass that to the applicant, thank you so much.
Amy Sterling on behalf of the applicant. We'll
Sorry, applicant.
Amy Sterling on behalf of the applicant. First request was it'd be useful for Mr. Collier to submit into examination the particular ICES guidance that he's referring to. But our understanding is that ICES guidance applies to is guidance for carrying out fishing operations within particular areas, not for the construction of an offshore wind farm, which would, of course, in our view, differ. But it would be useful to see the guidance that he's referring to, and we can respond to it.
I think Mr. Collier is nodding, so he'll do that. That's it. Thank you. Yeah. So did we get through the mechanical trenching? Have we?
Right, for the applicant, no, I was just going to come to that point next. So Ms. Collier has identified correctly that we've proposed a potential mitigation for deposition effects could be to limit the construction technologies for cable installation to technologies which result in lower amounts of resuspension of sediments and therefore deposition. So an option for that could be to use mechanical trenching tools, ploughing, as opposed to techniques that would result in larger volumes of sediment disturbance like dredging, for example.
Okay.
So that's to restrict how far and how to what thickness and to what concentration suspended sediments are distributed.
So you could have a discussion as part of the statement of common ground process with Mr. Collier about the sorts of activities you could include.
Right. Right, as for the applicant, we'll respond to this in writing. I think what we have in the outline herring mitigation plan at the moment is essentially what we're proposing, and so we wouldn't want to get into. We're happy to discuss it through the statement of common ground process, but I think what we've provided is pretty much as far as we can commit to at this stage.
Okay. If we go on to the seasonal restrictions then, which Mr. Collier's explained, I wanted to talk about seasonal restrictions as well, but if you answer Mr. Collier's question first, and then we'll move on to mine. Are you ready?
Ryan Mass for the applicant. Sorry, we're just having a discussion there. So this third point is the seasonal restriction and the data that we've used in the current iteration of the plan to define the peak herring spawning season that could potentially be used to define a seasonal restriction in the future. So essentially what we've provided in the appendix within the herring mitigation plan at this stage is a worked example of how the data would be used, the methodology that would be applied to define that peak spawning herring period. And of course, it's acknowledged that this data is collected annually by AFB, and more data becomes available year on year, and there's a significant amount of time between now and the point of construction, and there is some recognition that the peak spawning period may shift, and so as set out in the plan, our proposal is to revisit the most up-to-date data at the time and redefine the period for that potential seasonal restriction if necessary at the time of discharging the final plan.
Mr. Collier, did you catch that? Do you have a response for it?
Yeah, I did. I mean, it's only fair to acknowledge, I mean, it is difficult for the applicant. The applicant has to work with the best available data, and this is new information that's only been collected in February of this year by a pelagic vessel that was collaborating with AFB, so to speak. And it is off the back of what was caught in February that it's now become established that there's actually at least 2 spawning periods in the Irish Sea, an autumn spawning period and a late winter spring period. So that's quite different from what has been used to set out peak spawning and herring spawning behaviour timings in the EIA. So we just ask that new information is reviewed and taken account of. As I said, we are happy to provide the sonar information that the pelagic vessel collected. I spoke to the vessel owner this morning, and we can submit that to the examination library.
If you submit this information, I'm not quite sure what happens next. Is that something that will affect your decision on seasonal variations?
Ryan McManus for the applicant. So, I mean, I think we'd welcome the submission of that information. I think the mechanism that we have set out in the outline herring mitigation plan is always to revisit the definition of the peak spawning period with the most up-to-date available data at the time. And it's also important to recognise that this is 1 year, and the methodology that's set out looks at a time series over multiple years. And so, if this were to become a pattern in future years, then that would be factored into the final plan.
But are there the mechanisms in the plan to ensure the information and the issues that Mr. Collier is raising are actually acted upon? Are the mechanisms there in the mitigation plan, Mr. Collier, that you want to rely on to ensure the information that you're suggesting is taken into consideration?
I'm not sure it is, ma'am. I mean, we will meet with the applicant again on the 26th of May as part of our SOCG discussions. So we're happy to discuss this further with them. But I mean, the other point that I did raise when I was speaking was that, the applicant earlier on today advised that the construction period will be 1 year. If there is now 2 spawning periods in the year for herring, in the autumn and the spring, how is it conceivably possible to construct a wind farm and not impact that spawning stock of herring?
If we could get so we can nail some of this down. So, Mr. Collier, if you could submit after the hearing all the issues you're raising now, so they're in the examination, so we're all aware of them. You're having an SOCG session with the applicant, so you can discuss your point 1 about herring spawning and habitat, because the applicant's agreed you're going to have a conversation on that. You can discuss point 3 on seasonal restrictions. in your SOCG conversation, because the applicant will already have the note that you've submitted, hopefully before the 26th, so you can talk about it. On point 2, what you're talking about for mechanical trenching will be in your note, so it will be very clear to everybody the issue that you're raising. I suggest the applicant think about it, and you can talk about it in your SECG conversation. It will be for the panel to decide what we do with that if you reach a impasse in your conversations, whether we actually ask for it to be in the order anyway. So that deals with your 3 things. I'm not quite sure, I'm so sorry, on the last point, whether that's something that we've got that you haven't had access to, or that someone submitted that you haven't. The point where you've not seen a response, is that something that the panel needs to do, the caseworker needs to deal with, or your last point?
Yeah, I mean, we could well have missed that because it's a lengthy document to go through. Applicants' response to first written questions.
So which written question?
We would just like to see. Sorry.
What is it you don't have? I'm sorry. So D1010, was it a written question response that you don't have?
So Scottish Fishermen's Federation submitted a response to written questions 1 at deadline 1, which set out some of the points.
You don't have that. Okay. So we'll look into that.
We do have that. We do have the SFF's submission.
Okay.
What we can't see is an applicant's response.
Okay, right. Thank you very much. I'm so sorry. It took me a while to get there. I do apologise.
You're okay.
So we'll look into that. I think if the case officer looks into that, we'll get to the bottom of it.
Thank you.
He's saying that. Applicant, did you respond? I'm so sorry. I'm assuming that you had responded and we hadn't got it.
Yes, that's welcome. Amy Stelling on behalf of the applicant. We have responded. It's just perhaps not in the place, to be fair, that Mr. Collier may have looked. We've responded in the applicant's comments on responses to first written questions.
I see. Okay. Now we're getting to the bottom of it.
Yeah, which is document D2003, and table 20 is the applicant's comments on the Scottish Fishermen Federation response to written questions.
Thank you so much. I was struggling there for a while to work out what was going on, but brilliant. We've got there in the end. Perfect. Did you get the reference, Mr. Collier?
I did.
It'll be in the transcript, so you can read it from that. Okay. So I think we don't have solutions, but we have a way forward for the issues that you're raising, Mr. Collier. So thank you for that. Bring it to us. Is there anything else on this issue? I just had one more issue on herring I wanted to raise, and then we'll move on. We did have some time at the end of the day, so hopefully we've bitten into that and we'll still be on track. So, the last issue, and I'm not sure if this is partly covered what Mr. Collier's raising, so you'll have to correct me if it is, but the mitigation impacts for herring eggs and larvae on the deposition of suspended sediment, and how suspended sediment causes an impact on the habitat after construction. So it's where we were talking earlier about the erosion and the erosion rates. We touched on the fact that you haven't looked at the erosion rates, and we've been through that sort of cycle. So for the applicant, can you explain how the potential impact on herring spawning habitats be considered within the assessment, and whether the conclusions of large adverse effect on herring eggs and larvae from suspended sediment deposition takes account of the potential impact to the habitat from things like sound wave clearance, cabling, stuff like that? So are you able to respond to that one?
Ryan McManus for the applicant. So yes, the assessment does consider both the impacts to the spawning, the spawning herring themselves, the eggs and larvae, and the habitat. So the reason why we've not identified a significant effect on the habitat itself is because there's not predicted to be a long-term change to the sediment composition. The sediment that is disturbed is retained within the local system, so it remains coarse sand, mixed sand, within that zone of influence. So there's no change to the habitat. So long term, it's recoverable.
Long term, it's recoverable, but the sediment deposited during cable installation could affect the integrity of the habitats, or is you're saying it won't? Just for context, I believe that mud and fine silts are considered unsuitable because fine particles can smother eggs and blockade membranes and pores due to low oxygen exchange.
Dr. Kjorn on behalf of the applicant. So the herring spawning ground is typically coarser sediment. So the sediment deposition is typically finer. So upon deposition, it does appear to change the substrate type by the introduction of finer material.
Okay.
But the reason that is coarse in the first place is because the near bed tidal and current velocity is so high that it entrains all of the other fine material and winnows it away and leaves the coarser material on the seabed. Therefore, when the deposition of the finer material goes on to the coarse, over a short period of time, the near bed hydrodynamic processes winnow that smaller, that finer material away, so returning the sediment substrate back to its sort of pre-construction state, and that happens relatively quick. So that's why it's not a significant change in habitat or substrate type.
Okay, I think we've had a long session on fish ecology. I've noted what you've just explained. I suspect I might follow up with a written question so we can work it through. I think we've made good progress on fish ecology, so I think we're ready for a break. So we will follow that through. Just from Manx Wildlife Trust.
David Bellamy, Manx Wildlife Trust. Thank you, Ms. Powell. I'm very, very conscious of time. I just want to raise one final point that I mentioned earlier this morning. So rightly, there's been lots of discussion this afternoon on sand eel and herring. However, we wish to highlight that the Shark Specialist Group of the International Union for the Conservation of Nature have very recently recognised 3 important shark and ray areas within Manx territorial waters. One is wholly within Manx waters and 2 in part, and they are briefly the North East Atlantic Corridor, the North West Irish Sea and the Calf of Man to Orrisdale Head. Pleasingly, this recognition builds upon 13 years of local joint research by both DEFA and MWT into small sharks in Manx waters. And this recognition is only a few months old, and therefore sharks and rays have only had a very light analysis in the scoping, EPP and EIA process to date. So therefore, all 3 of the citation documents for these 3 sites have been sent to the examining body, DEFA, and the applicant this afternoon for consideration. Importantly, I hope in terms of the seasonality of breeding of sharks in Manx waters. And MWT raised this only now because the recognition is only a few months old, but also because all of the sites have been recognised as being of international importance for wildlife, and therefore under Manx policy, they receive a level of policy protection, as we've heard earlier this morning, under both Environment Policy 4 and also under our biodiversity strategy. As the Irish Sea has now been internationally recognised as being of global importance for 4 different shark species, including taupe, which we believe have a significant nursery ground in Manx waters, and also a species which is classified as critically endangered, which is globally the highest possible threat level under IUCN rankings. MWT therefore requests that this new material considerations be considered by the applicant, albeit at this late stage, as part of the examination process. Thank you.
I think the applicant had a response. I'll certainly ask you to submit the information that you're talking about to the hearing, but applicant, if you want to respond to that before we go to tea.
Amy Sterling on behalf of the applicant. We'll just confirm over the break with Manx Wildlife Trust exactly where that information was sent, because I don't believe anyone in this table has it. Oh, okay. So we will just, and if it was sent this afternoon, we'll of course review it and provide any comments at an appropriate
Perfect. Okay. Are you comfortable with that? So I wasn't sure if it had been sent or was being sent, so.
Just been sent within the last few minutes.
Oh, I see. Sorry. Okay. I'm advised it's a hearing submission, so if you could send it to the case officer, and then the case officer will send it there. Okay. So at 3:45, I think it's a 15-minute break, is it, Chair?
Excuse me, Chair. Can I just one point? Yeah.
So sorry.
Just one very quick one. Ken Milne, representing DEFA. It was just in regards to the herring mitigation plan. We have contacted AFBI and asked them to review it and comment on it, so they may submit something as well. Deadline 4. Thank you.
Yeah, Mr. Milne, I think that's sensible, and I think just given the conversations that we've had, and I wonder if you're still online, Mr. Collier, I wonder if the next step, alongside all the other actions, might be to provide a track change version of what you think should be in the mitigation plan.
I'm happy to take that back to the chief execs of the producer organisations and discuss that with them.
And as you're doing that, it might also be helpful to actually look at the draft consent, the marine infrastructure consent. Admittedly, most of what you've just said would be included in the mitigation plan itself and would be secured through that. But it might be helpful to just have a look at the draft MIC and see if there would be implications to any wordings in the MIC, especially the requirement which secures the draft, the outline herring mitigation plan, in terms of the triggers or any additional controls that might be necessary.
Not that, Mom. Thank you.
So that, I think, is an action for both NIFF as well as for DEFA. DEFA, I believe you stated that this was a different party that you've asked to comment on.
Yes, it was. Sorry, Ken Milne representing DEFA. It's AFBI in Northern Ireland, so to comment
Understood.
on the mitigation plan.
Thank you. All right, thank you.
Okay. We break for coffee for 15 minutes, please. Back at 5 past. So if we start up again, it's 4:07, 7 minutes past 4. So if we move on to ornithology. Applicant, do you have the right people? Who's remind me who's doing ornithology, so sorry.
Yeah, Amy Stirling on behalf of the applicant. Mr McManus will lead the ornithology section, but similar to the fish ecology, if he feels any technical detail needs to be passed to Mr Freddie Leith, who's online, Mr McManus will indicate when that is. Thank you.
Okay, thank you. Right, so we're going to look at the outstanding issues and go through what we think is remaining for birds. So the first one's the practicalities of defining reference populations based on foraging distance as an approach to assessment. I feel like we're revisiting some issues from the last hearing, so I don't really want to dwell on them too long. I'm hoping we can resolve them, put a tick in the box. If not, then it'll be a written question, I think. Otherwise, we're going to go around in circles. So I think for reference populations, DEFRA wanted to explore breeding season for foraging approach as an alternative to BDMPS. I think that's right, isn't it, DEFRA? Deadline 1, response 1R11211. So they're content with the standard approach that's been taken for cumulative assessment at the regional scale from an English perspective, and that assessment has also been undertaken to assess the likely effects of the project on the Isle of Man seabird population, but they have specific issues with the way the great black-backed gull has been treated, and raising a query on that, I think, is basically the essence of the issue. The applicant maintains the contribution of the proposed development to the cumulative effect remains very small, regardless of the reference population, and that assessment conclusion would therefore remain unchanged. That's D2003. Is that fair? Is that where we are? So, DEFRA, has there been any progress made on this issue? Is this something you still want to pursue, or are we closing this out today?
Ken Milne representing DEFRA. I think we can close this one out. We acknowledge that even as the cumulative impact on the great black-backed gull strike risk is small, we just ask that it be part of that cumulative effect. It should be recognised, but it's probably not going to be possible to consider.
Okay, excellent. I have trouble with the great black-backed gull also, so I appreciate your issues. So the second one is whether redefining the breeding season regional population will facilitate a cumulative assessment at a spatial scale, which is kind of similar to the first question, really, I think. So the applicant did not undertake a cumulative assessment for the total Isle of Man colony populations or any other representation of the Isle of Man seabird population. And I think, are we closing this issue out, DEFRA, or do you want to explore it a bit further in the hearing?
Ken Milne representing DEFRA. I think this follows on almost from the discussion earlier about sand eels.
Okay.
You know, it's about the foraging for the breeding birds, etc., and it's probably a statement of common ground, perhaps maybe the best approach. We'll have a continued dialogue with the applicant, but I don't think it's a major one to discuss today.
Okay. If I outline a couple of questions I had, and then perhaps we'll just leave it at that, and you can incorporate those into your statement of common ground conversations. But with the progressive aim to closing the issues out, as we've observed, we're at mid-peak of the application, so now I'm really driving forwards to review the mitigation plans, make sure the baseline surveys are the right ones, and cross off the issues for mitigation for magnitude and sensitivity. So I think the applicant feels that those conversations have gone round and round in circles, which has been commented on earlier, which is why I'm saying just tell us what the sensitivity is, tell us what the upper and lower limits of the magnitude are, and we can move it forward. So so I had some questions, I think they were the similar as the last hearing. So why was the cumulative assessment not undertaken? Can the applicant comment on whether defining the breeding season population based on foraging ranges is a pragmatic alternative to BDMPS, which is I think what we've discussed, and clarify how the size of the breeding season populations was obtained from the report, given its focus on non-breeding season populations? And then I think this refers to the other question. Can we confirm that cumulative assessment for the great black-backed gulls should be repeated using a foraging range approach? So I think it's all wrapped up in one bag. Is everyone happy with that? Yeah, excellent. DEFRA raised a couple of questions with the baseline intertidal ornithology data. I think it was mainly gaps, wasn't it? apparent lack of data in August and limited in April and May. Are DEFRA happy with the survey information now?
Ken Milne, representing DEFRA. Yeah, we welcome the intertidal data for Groudle, which we still need to fully review. And we also know there's a future assessment still to be provided by the applicant as well, which we assume will be the next deadline.
Does the applicant have a comment on that?
Ryan McManus for the applicant. So to clarify, so all the surveys have now completed.
Yes, we saw.
We've had all of the survey data that's been reviewed and provided an addendum at deadline 3, I think it was, or 2
yes,
or 3,
did,
I can't remember which one, that confirmed that that data had been reviewed and there was no change to the assessment outcome. The piece of information that hadn't yet been provided was the survey report for that final survey, which is being provided at deadline 4.
Okay, so I think at that point, DEFRA, it would be great if you could explain whether you have any gaps. I'm hoping that you don't, given that the applicants completed their exercise, but if you could indicate any gaps at deadline 5, that would be greatly appreciated. Again, we're coming to a point where new surveys or additional surveys is not really a realistic proposition in this process, so we will be leaning towards mitigation, management and monitoring. So we had a question about the precautionary principle, which was raised by DEFRA again. And I don't know if we can close this one out, DEFRA, or whether it's something that you still want to pursue as part of the Statement of Common Ground conversations. But it's to do with the applicant evidence-led approach versus the Natural England-led approach, which lead to slightly different results because one's very precautionary and one isn't. I think if we just put up table 55 AP 047, is that all right? Just so that we can look at the issue that's DEFRA are raising. So I think what DEFRA's saying is that if you look at the UK SNCB mortalities, it's 0.8, and the CGR is 0.994. So the difference is quite large in proportional terms. And whether DEFRA wants to do anything about that, whether they want the applicant to pursue the more precautionary approach or whether they're comfortable what the applicant has done. Is that something you're discussing as part of the SOCG, or is it something that you're quite comfortable with now?
Ken Milne, representing DEFRA. I think we will take that away and be part of the Statement of Common Ground.
Okay. The applicant's happy with that?
Ryan McManus for the applicant. I think just want to make clear that we've obviously presented and assessed both approaches where...
Yes, it says that. Yes, I understand that. Yeah. You've presented and assessed both, but you've taken forward the evidence-led approach, not the precautionary one.
Ryan McManus for the applicant, not in all cases, no, so they're both considered. So if I may, I'll hand over to Freddie Leith, who can explain this better, being the
if I just
expert on it.
Clarify then DEFRA's concern, if that's all right. I think it's, if I'm right, it's to do with the potential for a small but annual loss of kittiwake at Moorgold Cliffs. That's the issue that you're wrestling with in terms of this approach.
That's correct.
That's correct. Okay. So it's not the whole thing, I think is what DEFRA's saying. It's just kittiwakes in this particular location. So if your colleague would like to explain whether that's significant and whether it's possible to continue discussing it as part of the SOCG, that'd be good. Are they online? Do you want to? If you take down the thank you.
Hi there, Freddie Leith for the applicant. So I think we present both approaches in detail within this assessment. So we conclude based on both the SNCB parameters and based on the applicant's approach. They're both considered quantitatively and qualitatively. There's a lot of text presented in the Ornithology chapter around why we consider the applicant's approach to be more appropriate. So just to provide some context, the applicant's approach, which we present here for the collision risk modelling, is just based on presenting species-specific avoidance rates. So that's just changing one element of precaution that's built into the SNCB parameters. So the massive reduction in kittiwake collisions you're seeing is based on just us reducing or changing one element of the collision risk modelling assessment. There's a lot of other elements of precaution which are not built into that assessment, which we discuss in the report. So there's a lot of text around that which is already discussed and it's built into the conclusion, which is why we made a conclusion of not significant.
So just to summarise, you're comfortable with the conclusion of not significant being robust for kittiwakes, even though it's based on the evidence-led approach and not the precautionary approach?
Freddie Leith, for the applicant. I think we're confident in the conclusion of no significant based on all the information presented in the conclusion. We present information on why we consider the evidence-led approach to be more appropriate, and we present a lot of information on why even that approach is considered highly precautionary. So I think based on that, we are confident in the conclusion, yes.
Okay, so I think it's over to DEFRA as part of the SOCG discussions to understand whether you're comfortable with the conclusion for kittiwake and whether you agree with the not precautionary approach being used.
Ken Milne, representing DEFRA. I think we will be able to close this one out very quickly, but we'd just like to continue that through the statement of common grounds that's recorded.
So if you continue that, okay, fine. We all agree with that. Can we move on to the next one? Okay. So the last topic for ornithology is bats. I don't know if Manx Bat Group are here, patiently waiting all day. Would you like to come to the table? Thank you, sir, for coming and waiting. Good afternoon. If you'd like to introduce yourself, sir.
Yes, Kevin Wells, representing Manx Bat Group.
Could you just say your name a bit slower, sorry?
Kevin Wells.
Kevin Wells, thank you. So you have an SOCG with the applicant in progress. If I maybe summarise the issues that I think are on the table, and we can work through where the SOCG's got to, and take it from there. So, as I understand it, and we didn't test onshore bats at the last hearing, no surveys were carried out as part of the assessment. If I just summarise where I'm at and then we can work it forth. So no surveys were carried out, and the desk study records lists of bats at various locations as a desktop exercise, I think, within 2 kilometres. And so my question is whether that enables a robust baseline for assessment, and a conclusion there'd be no significant effects to bats, particularly within the context of their local importance, particularly at Grudel Bay. So that's my first issue. The second issue is, given that scenario, how comprehensive are the pre-construction surveys? And it's suggested in the documents that they're mitigation, but they're not really mitigation because there was no baseline bat survey conducted in the first place. So they're almost a base situation that needs to be mitigated against. And my third point is how prescriptive the mitigation proposals are. And I note that the report says that the MIC gives you the licence equivalent to relocate bat roosts if they are found. And once again, I draw you to the fact that there's no licence, it's not the Wildlife Act, that we are in the realms of the MIC. And again, the mitigation plan and any written information in the actual MIC are the main methods to procuring mitigation. So I think for onshore bats, those are the issues I see on the table. Are they still on the table? So if I hand over to the Manx Bat Group first and then pass to the applicant, would that be all right?
Kevin Wells, representing Manx Bat Group. My first concern is that our response to the initial consultation back in November was about the offshore wind farm. We have not mentioned the onshore wind farm. It was not mentioned in the last discussion. But this statement of common ground only talks about the onshore wind farm and that the offshore wind farm is not being considered at all, which seems very strange.
So I'm a bit confused. So there's no onshore wind farm?
The onshore part of the wind farm, when the cables come aground. That's what the statement of common ground was concentrating on.
So the statement of common ground is concentrating on what? Sorry.
The onshore part.
Onshore?
Yes. Whereas we in our consultation only discussed the offshore part of the wind farm itself, and that there was no surveys carried out for migrating bats. And we have several bits of evidence which we have provided some, and there is more that should be considered.
I understand. So I thought the statement of common ground was progressing offshore issues because that was what we discussed at the last hearing. The statement of ground can cover all BAT issues. That's the purpose of the statement of common ground. So please feel free to continue all BAT issues onshore and offshore as part of the statement of common ground process.
Okay, so reading the statement of common ground, section 1.3.12, the SOCG focuses on specific issues relating to the onshore impact assessment. And that's how it starts.
Are you reading a clause of the statement of common ground?
Yes.
Okay. So can the applicant confirm whether that's the case? And if it is the case, could the applicant amend that to include on and offshore?
Amy Sterling on behalf of the applicant. The words that are being read are not the words in front of me in document D1039, which is the statement of common ground between Mooir, Vannin Offshore Wind Farm and the Manx Bat Group. And in that document, at the first 1.1, it says the conclusions of the applicant's position is the conclusions of the EIA appropriately reflect the potential effects on offshore ecology interests, and proceeds to talk in that context. So I think maybe we need to align.
Okay, well, it's good that we're here. This is the purpose. This is the purpose of today, to work through the issues.
This is the document I downloaded from the agenda. So it says 1.3, 1.1.
For the agenda for today's hearing.
I clicked on the link.
Today's hearing is the topics that we're going to be discussing today.
But I say the document I downloaded was from the link within the within.
Oh, I see what you mean. It's linked to the agenda.
Yes. So I've downloaded it, and it's different to what the applicant is saying.
Amy Sterling on behalf of the applicant. I think we're talking different parts of the document. So I was referring to the paragraphs as they're set out in table 3 and the topics which are covered by the statement of common ground. I think the Manx Bat Group are referring to the introductory paragraphs, which I think actually, to be fair, are probably a bit confused, because 1311 talks about works numbers 1 to 5 and work number 6, which are all offshore works, and the onshore works. But then the subsequent paragraph does have a focus on onshore, but that's just one part of the overall statement of common ground, which does refer to offshore.
Could we reset then? Use today to reset. That's the purpose of the hearing, to get everyone around a table and to move things forward. So if we reset, could the applicant update the statement of common ground to apply to onshore and offshore? That would be great. And continue discussions with the Manx Bat Group on the issues around bats. So taking it back a step then, taking onshore first at Grudel Bay, because now the Southern Lights have been withdrawn, so we're just talking about Grudel Bay. I've outlined issues that I've seen, because it's the first time we've talked about this at hearing. I've outlined the issues as I see them. Would you like to give comment on those issues now, or do you want to go away and discuss the statement of them in the statement of common ground process?
Kevin Wells, representing Bat Group. You've mentioned that there are no bat surveys within that area. There are few bat surveys. It would be better to actually carry out surveys.
So
static bat detectors in the area for for a while. This is the season to be doing it.
I understand. So the point I'm making is that the applicant didn't carry out bat surveys as part of their environmental impact assessment. So now we're in a situation where, acknowledging that, that's the case, isn't it? Yeah, okay. Acknowledging that, we're now turning to mitigation and monitoring as part of the outline monitoring and mitigation plan. And we're looking at nailing what's in there about the surveys that need to be done. And we've been through the same loop, I think, with other surveys. So for the benthic ecology, I don't know if you were here for that session, we talked through in great detail about the survey, what DEFRA and the Manx Wildlife Trust were not comfortable with the survey, and there's conversations going forward about that. So is it helpful if you outline how you see a survey should be run pre-construction, the elements it should include, the timescales, the seasons, or whatever you think is appropriate, and you can submit that to the hearing after this hearing today, and then that can be discussed in your statement of common ground process. Is that okay with the applicant?
Yes.
Is that okay? So then, moving on in the same vein, it's what happens if you discover bats and what you do about that. So that's the mitigation element. So in that plan, I think it would be useful if you are familiar, and perhaps a meeting with yourselves and DEFRA might be appropriate. If you could enable that, DEFRA, that would be really helpful. But I'd ask you both to look at the process you would normally license, DEFA, for moving bat roosts. When you issue a license, which I think you must do, is that right? For any moving of bats roosts, you must do that. So your license terms that you use for that, could you both discuss that and set it out so that it can be discussed with the applicant in terms of mitigation for bats? I'll turn to the applicant now for their comment. I'm so sorry, I should have come to you earlier. Do go ahead.
Dr. Carroll, on behalf of the applicant, it's not our intention to move any bat roosts. Okay. I don't know if that is a mistake in something that we have written or if that's been mistakenly read somewhere. That's not our intention. There is no bat habitat within our order limits. There may be commuting and foraging hedgerow and habitat that's used. All like roosting and activity for bats will be outside of our order limits. So
I understand.
We're not planning on moving any roosts.
It is in your documents with a license for doing it, and I understand what you're saying. Yeah. I'm not a bat, I don't live near any bats. I don't have any guarantee without any baseline survey that there are no bat roosts. So I think to go through the licensing process and incorporate in the mitigation plan the steps the applicant would need to take if they did find bats, given that they say there's no bat roost, there's no harm, no foul. So I think, is that all right? That excuse me.
Is how do you know there are no bat roosts?
Well,
if you've not done any surveys, you cannot say.
That's my point. So that's why you're going to look through the details of the surveys that would need to be undertaken, the seasons, the timing, what they would look like for discussion. I'm not saying that that's definitive. And that you would discuss with DEFA what the licensing would look like. I actually think probably DEFA's responsibility to set out the licensing in the mitigation plan, and obviously actually the surveys. So actually I'm thinking this through on the spot. So I think DEFA, if you could take management of looking into what the management plan should have in terms of surveys, and then next steps mitigation for bats.
Yeah, Ken Milne representing DEFA, and just to be clear, it's not just the onshore part.
We're talking about onshore right now. Okay, yeah. And discuss it with Manx Manx Bird Group, and then provide that to the applicant by deadline 4. Would that be possible?
Certainly from DEFA perspective, yes, that would be possible.
And then you can pick that up in your SOCG process. Is that okay with the applicant?
Yeah, just to come back to Mr. Wales, he has much more bat knowledge than I have, and we're not aware of any bat roosts in fields. I don't know if bats roost in fields normally, but maybe Mr. Wales has some evidence of bats roosting within fields that he would care to share with us. To our knowledge, there's no bat roosts in the field around Groudle, so we are confident.
I understand that you feel there's no bats, but I think we're working on the premise that the precautionary principle as in EIA. So I think we have a plan, is that right? So in terms of onshore bats, we've covered the baseline surveys. If they're discovered, the mitigation. The next phase is the monitoring of bat activity and what the applicants put in at the moment and what DEFA and Manx Bat Group think would be appropriate. And that's a discussion, I think, to be had. Did the applicant want to comment on that?
Yeah, Dr. Keoghan, on behalf of the applicant, we're not proposing any bat monitoring.
Okay.
We're proposing to do some pre-construction bat surveys and then to adopt any construction methodologies and ensure there's appropriate mitigation to minimise disturbance to bat activity. We're not proposing, we don't foresee, we've done an assessment of bats, we've assessed bats as a receptor in the onshore ecology and the conclusion was no likely significant effect, so we're not proposing any additional mitigations beyond standard construction techniques, good practice, so there is no monitoring to be done in terms of onshore bats.
Okay, yeah. I understand. My nervousness is that you didn't do a baseline survey, so how can you conclude that you don't need any mitigation for removal of roosts or monitoring for anything that might exist after or during construction. I can see your precautionary measures inbuilt, so the digging and bashing and managing that so it doesn't disturb bats that might have been found. But I think monitoring is certainly a conversation for DEFRA to have with the Manx Bat Group, and something to actually discuss. I don't think we can cut that off today. I think it's a reasonable conversation to have, given that there's been no bat monitoring before you took the EIA.
So our approach to the bats was basically through the consultation, so through the EIA consultation from the scoping all the way through pre-application consultation and the evidence plan process through the technical advisory groups for onshore ecology. We requested bat records. There was quite limited bat records come back. So our approach was to adopt a precautionary approach, and we assumed presence of bats. So that's what informed the EIA. So assuming a presence, taking a precautionary approach, that assessment conclusion come out as non-significant. So through standard mitigation measures to minimise any disturbance, which we will verify upon pre-construction surveys. So if there's bat roosts or anything, the work will be developed in accordance to minimise any disturbance and ensure bat activity continues.
I understand.
For us, there is then no requirement to monitor bat activity beyond that. So that will be our position. So we don't understand why you would be then, what the requirement is.
Dr. Carolan, the requirement is the evidence that we've just heard in examination right now, which is that the assertion that there are, in fact, bat groups that would be disturbed. And we then require evidence to prove that there aren't, or to prove your point that you have the assessment or the assumption that you've made in your EIA. The fact that there was no record coming forward would have been fine, possibly, if we'd not heard from a principal stakeholder that, in fact, there is evidence to the contrary. So we've now agreed that, you know, we do need to understand that the survey needs to be taken, and if your assumptions are correct, as Ms. Pownell has said, then there's going to be no actions needed. But I don't think that with that as representation before us, we can leave this conversation here.
Dr. Carolan, on behalf of the applicant, there is no evidence before the examination of the presence or activities of bats at Groudle. So what we're saying is we will do a pre-construction survey to establish what we have determined as a precautionary approach, that their presence is there. Their presence or otherwise has not been determined or evidenced by Manx Wildlife Trust, DEFA or Manx Bat Group. So we're saying we'll go out and do the survey to confirm their presence. Should their presence be noted, then we will agree with them the appropriate mitigation measures to minimise disturbance. That we feel is sufficient. There is then no further requirement to monitor bat activity beyond the mitigation measures that minimise disturbance. That's our position.
Could I just come in there? I'll come to people. So I may have been dreaming at that point, but I thought that the assessment made reference to records of lesser horseshoe bats on the site. Was I dreaming?
Yeah, so through the evidence plan process, we got a number of records, but the records weren't sufficient for us to determine a population to do the assessment or to continue any survey. Yeah, so there were sporadic records, not of sufficient detail to determine that there was a requirement to do there was a requirement to do like a year's bat survey to inform the EIA.
If a desktop record identifies a protected species within the boundaries of your work, then logically bat surveys would be done to either confirm or exclude that species. And if your own application says that species has been seen through the records, I think we're going round in circles here. I think I'll hand over to the stakeholders who wanted to make comments, but I don't think it's unreasonable to look at pre-construction surveys, monitoring and mitigation. So if it's all right, Ms. Irving, if I hand to these people first and then come back to you, would that be all right? So who wants to go first? Okay.
David Bellamy from Manx Wildlife Trust. Again, I think this reflects that the situation on the ground is changing quite rapidly. So just last year, in a coastal location on the east coast, not far from Groudle, a coastal building was found to contain a roost of lesser horseshoe bats. Now, of course, that's a protected species on the Isle of Man. It's a biodiversity action plan species, but actually that one roost site represents the most northerly location for that species on the planet. So it starts to become of international significance in that regard. And we didn't know about that until last year because we'd never surveyed that area. So I think this reflects that an absence of records doesn't mean that a species is absent from an area, and that using the precautionary principle, we have to have as Ms. Pownell said, we've got to at least have a look in this area, and that recent development nearby does reflect that. Thank you.
Manx Bat Group.
Kevin Wells, Manx Bat Group. Yes, the comment that we've said there are roosts there, we haven't said they're actually in that particular area because we haven't surveyed that particular area.
I understand.
But, the precautionary principle states that you should
I understand.
Basically check first. So as long as there are pre-construction surveys carried out before any, even just getting the roads in.
Yeah, the applicant has said they'll do pre-construction surveys. Yeah,
that was fine. But it was just to mention that it was just when he's mentioned that we had already said there were roofs. We haven't said that. That's all I'm trying to say. Yeah.
So firstly, if Mr. Bradley could submit the information that you were just outlining to the hearing.
David Bellamy for NWT. I'll have to seek DEFRA's permission because that site's a confidential site for the protection of the species.
We don't want to get any bats.
But subject to their agreement, I'll be happy to.
If it's redacted, that's fine. So I think we just need to be clear. The applicant has said they will do pre-construction surveys for bats. I don't think that's in debate at all. So what I've asked is for DEFRA and the Manx Bat Group to comment on the plan to specify what they would want in the pre-construction surveys. I'm not saying that has to happen, I'm just saying that they provide their comment on what they would expect to see. So that's pre-construction. And then during construction, if bats are identified, I'm asking DEFRA to take the lead on what should be in the mitigation plan for dealing with the bats that have been identified. I think that's on DEFRA because it is a licence equivalent in this process. I'm sure you'll share it with the Manx Bat Group, but these conversations happen quite quickly because the programme's moving quite quickly. And the last thing is monitoring, which I think the applicant's reticent to discuss. However, I do think it's important, given the presence of the lesser horseshoe bat and the issues you're raising, the issue Manx Wildlife Trust are raising. So at the same, as a part of that process, can you look at monitoring and the mitigation plan in consultation with both organisations, I think? And can you provide that updated mitigation plan with your comments and proposals to the applicant by deadline 4? I think we have to move it forward like that because there's been so many issues on the table, and then the applicant can have a look at what everyone's saying, and then perhaps there'll be other meetings to follow that. Is that a reasonable approach for people?
Amy Sterling on behalf of the applicant.
Thank you.
Yes, I just think I would like to if we just go back to the very start, is just to be absolutely clear. In the applicant's EIA, we have assumed that bats are present. And I just want to make clear that we have taken a precautionary approach to assessment.
I know, yes.
In the absence of survey data, we've said bats are there, and we've assessed on that basis. Otherwise, I agree that it's now then looking at, okay, pre-construction survey, if it confirms that there are bats there, what are the appropriate mitigation measures? The applicant disputes it, and that those circumstances monitoring would be relevant. We, of course, can't prevent others suggesting otherwise.
I think that's agreed. I understand that. That was my concept. You have said in the actual assessment that you identified bats are present, or observed that bats would be present based on baseline work. So I think that's for onshore bats. If you move to offshore bats now, we've clarified this. Did you want to raise it? We've clarified the issue with the SOCG. So if you move to offshore, now the applicant's position is that there's no evidence to suggest bats, migratory bats exist. Therefore, you didn't do a survey, so therefore there's no mitigation required. Could I just confirm that's the situation?
Ryan McManus for the applicant. So we provided quite a bit of information in the
updated note
on migratory bat monitoring submitted at deadline 1. I think, before I get into that, the lack of evidence about migration across the sea is not that we don't believe that bats migrate across the sea. Clearly,
I'm sorry, I was a bit absolute with my
clearly
comment.
They
I appreciate
do.
that.
It's that there's no evidence of large-scale migrations between the UK and the Isle of Man. And what that technical note did was review what surveys had been done at other projects, so mainly looking at projects in Ireland where this has been required, and looking at the outputs of those surveys and how it was used in the assessment, and broadly come to the conclusion that the outputs of those surveys weren't particularly useful and weren't really able to be used in an EIA context, and therefore that, combined with the fact that there is limited evidence of bat activity over the sea in this area of the Irish Sea, that scoping that impact out in the EIA was appropriate, and that any monitoring that may arise from that would not change that, wouldn't contribute to that EIA conclusion and reducing that uncertainty.
Thank you. Okay, so I think if I ask DEFRA to respond and then the Manx back group, if that's all right.
Ken Milne, representing DEFRA. We agree there's a lack of data for full assessment of migratory bats. Although we do have some migratory bat species on the island being detected in recent years. So the fact that we've got some doesn't exclude that, we don't know the numbers but we're talking about here. And therefore, since it's not been assessed as part of the EIA for numbers, perhaps some monitoring as we go forward.
Okay, we can move on to monitoring.
Sure.
So, Manx back group.
Kevin Wells, Manx back group. We have no records for migratory bats travelling across the sea because we have no way of monitoring it ourselves.
Yeah.
You've mentioned that it is actually a regulation in Ireland under their Wildlife Act that offshore wind farms do monitor bats, and there are several reports that we can look at. The Oriole, I believe it is, wind farm has reference to detection of bats flying across the. And there is a recent document, March 2025, which we've just recently come across from Natural England on the Morecambe Wind Farm, where they discuss the findings from that, and it mentions in one of their conclusions, if I may be allowed to just find it again in here. I believe I've got to find it. That they did a record of several of the wind farm, of several of the various surveys across, and they have found that bats have travelled up to 12 miles offshore just foraging off of Ireland. So 12 kilometres, not 12 miles offshore. And in various places where they've put static detectors, in one of them I think it's the Rockwell, or I can't find the exact reference, Tipple, you know.
Okay, that's...
here we go. So this is from Natural England's response. The North Irish Sea Array Offshore Wind Farm Environment Impact Assessment, Chapter 35, specifically investigates offshore bat activities. Lysa's bat and all pipistrelle species, common, soprano and enthusiast, all of which we have on this island, were recorded in the near vicinity to Rockabill Lighthouse, approximately 6 kilometres offshore.
So, would you like to submit the document to the hearing so that we can use that?
Yeah,
that'd be helpful.
They talk about the Oriole. No bats were detected at that site. The Arklow Bank Wind Farm has a dedicated offshore bats environmental impact assessment chapter. This includes reporting from a fixed point survey of a monopile located approximately 8 kilometres offshore. Lysa's bats recorded in June, July, August, whereas common pipistrelles recorded in August and October.
So
there is
I understand.
evidence.
So if you submit the document, that would be incredibly helpful. So that would be some additional information for the panel. So I understand the principle that there's not enough information to suggest that it's worth assessing. I understand other wind farms have, some haven't. The paper you've produced was very helpful. I have a suggestion. So in the ornithology monitoring plan, the applicant says, 1215, it's acknowledged there may be greater value in undertaking monitoring collaboratively with other developers or SNCBs in the region, as this can enable resource pooling, collection of larger data sets and delivery of broader benefits. Therefore, potentially delivery of collaborative monitoring would also be considered by the applicant where practicable. And they make the same reference further down. Any monitoring undertaken would prioritise addressing evidence gaps or uncertainties most relevant to the proposed development, recognising it's not feasible, etc. So is it something the applicant might consider to work with other offshore wind farms in the Irish Sea? Because I know for yourselves it would be quite an expensive undertaking, but is it something you might consider discussing with the other offshore wind farms? I know they're all at the table currently. They're all at the table currently in this examination, so we have all their details. But is it something you would take away and think about? Because I think it would greatly benefit the Isle of Man, particularly for the next offshore wind farm. I think the Max Bank Group would recognise it. Dr. Caroline.
On behalf of the applicant, we'd be delighted to assist the next wind farm by doing some monitoring. We're open to it, and we're happy to have those discussions. We're aware that Morecambe, that was referred to, are doing some work. We'd be happy to speak with them. We'd be happy to speak with other SNCBs. We feel that doing it in isolation doesn't really add value, because if they're migrating, we need to be working with SNCBs and other developers in Ireland and on mainland UK, so that we can basically tie in to bring a coordinated, coherent picture to that.
Perfect.
So in isolation, we don't think we can add much value.
No, I understand
but we're happy
that.
to explore.
We discussed that at the last hearing.
Yeah.
I don't want to sound presumptive. I was just using the inference that it would benefit any other projects if this was to be carried out. So how do we progress this then? Is there something you might be able to lead and draw in DEFRA and the Manx Back Group, appropriate section?
We're happy to lead on it, yeah. And also happy to take any ideas from the Manx Back Group, Manx Wildlife Trust, or from DEFRA if they have.
So you're all talking to each other, you've got SOCGs in place, so can I leave you to progress this independent of the hearing and perhaps report back at the next hearings? Next deadline, deadline 4. Okay.
Sorry, just in relation to deadline 4, I don't think we'll make much progress by deadline 4.
No, I think because we're discussing, that's why I said that. So the Chair suggested that perhaps you could submit a plan by deadline 4 about what you might hope to achieve, who you might be able to talk to, so that then we'd understand what you'd be able to progress by the end of the examination. Is that realistic?
We can provide an update to it will be within the ornithological monitoring plan at present, I think, where we're going to make that inclusion, so we can put some update on that.
I think if you consider the best place to locate it, but give an update on what you're going to do in progress, that would be really excellent.
Okay, thanks.
If we can close this issue out, because I really would like to move on to marine mammals, if that's all right. Is everyone else comfortable? Oh, one more question. I'm so sorry.
David Bellamy from Manx Wildlife Trust. I do apologise, I'm very conscious of time, but I just believe in ornithology we missed a key element, which is the mitigation. And this point has been raised several times, but I think it needs to be raised again because it hasn't yet been addressed. But I just want to raise that MWT believe that there's a very clear need for ornithological mitigation under Isle of Man government policy, and that's specifically Biodiversity Strategy Action 21, which calls for no net loss, and its specific wording is DEFRA will continue to promote a policy of no net loss for semi-natural Manx habitats and species and ensure that all unavoidable loss is replaced or effectively compensated for. So there's no ifs, no buts with that. And just very briefly looking at Auster's figures, all species, in terms of the estimated annual mortality, we're looking at about 660 bird deaths per year. 4 key species, about 309 guillemots, 149 razorbills, 47 kittiwakes, and 16 red-throated diver, which is a Schedule 1 bird. But we're not yet seeing a mitigation plan in this regard.
If you could provide comments on what the mitigation proposed currently at the next deadline. So Manx Wildlife Trust to provide comments on the ornithological mitigation plan, monitoring plan. That would be great, and then we can progress it from there, if that's all right. And there was a hand in the audience. Does someone want to speak?
Thank you. Georgina O'Sullivan, resident of Garth. Actually, Mr. Bellamy stole my thunder a little bit. I've been asked by very many people, the average person that's looking at this and not really understanding the whole process, and it's a simple but rather distressing question, which has just been addressed, is what over the lifetime, if Mooir Vannin proceeds as a development, would the total fatalities on birds amount to? And I think we just heard that would be 23,100 based on that. Is that a correct assessment? 660 times 30 years?
I'm going to hand that over to the applicant.
Amy Sterling, on behalf of the applicant, we'd have to just check the figures. I think the figures that Manx Wildlife Trust read out are also not apportioned to the Isle of Man, for example, so they're just total figures which then have to be apportioned to different jurisdictions based on foraging ranges, etc. I'm straying here beyond my area of expertise, so I don't know if Mr. Leith has any comments online. Otherwise, yeah, we'll have to take it away. I don't know the figures off the top of my head.
Okay, thank you very much for raising the issue.
Thanks for letting me.
Mr. Leith's got his hand up now.
Freddie Leith for the applicant. I think it will be easiest if we can take it away and provide a more detailed written response, but it's also not just as simple as taking the impact and multiplying it by 35, because there are a lot more factors to go into that process as well.
So if you could do that by the next deadline, that would be excellent. And if all the organisations around the table could provide their comments on mitigation plans to do with birds, not mitigation plans, but that would be excellent as well. So then we can make some progress and perhaps we can see this next time around. I'm going to close down that topic, if that's all right, and move on to marine mammals. I feel we are going to overrun. I apologise for that, but I think we've done a lot of hard work today on a lot of issues, and I think marine mammals is something we really do need to work through. So apologies to the panel and everyone sitting around the table. Is everyone happy to start? Everyone got the right people in the room? Okay. So we're back to the scale of assessment for marine mammals. Working through the digital aerial survey, the scans 3 and 4, 3 during the time that the application was assessed, and 4 subsequently, and IMMA and what that means for conservation importance in an area. So I'm assuming that you've been working this through as part of the SOCG. Have you come to a conclusion? I think, do I turn to the DEFA or the applicant first? This is the scale of assessment.
Amy Sterling on behalf of the applicant. I'm pleased to say we have made some really positive movement in the scope of marine mammals, which may even keep us on time. Maybe I've been too optimistic. But I'll pass to Dr. Carolan, who can give an update on the appointment of the independent marine mammal advisor, the outcomes and the work in progress.
Okay, perfect.
Dr. Carolan, on behalf of the applicant, I'll just give a high-level overview, and then Ryan can speak in more detail to the technical outcomes. We had an initial meeting with DEFA to agree who we would appoint, and we appointed SMRU, who St Andrews University. We set out a scope of works for them. We had one meeting. We met individually, so we met SMRU to set out how we seen the issue.
Excellent.
And then DEFA had a meeting with them separately to set out how they seen the issue. Then we come together. We had 15 minutes to present how we seen the issue. DEFA took 15 minutes to present theirs. SMRU clarified that they understood the issue. Everybody agreed. They come back then with some advice. When we received the advice, our position as the applicant was that we accept all of the advice in its entirety. We're not challenging any of it. We're taking all of it and all of the implications associated with it. And that's how we entered into that. We then had a follow-up meeting to set out how we would address all of the recommendations coming through from that advice, and we had some clarification meetings with DEFA. We're now drafting up a methodology which is more detailed of how we're going to address all of those points. That methodology is going to be shared with SMRU and DEFA just to confirm that before any work begins, that all parties are agreed that the methodology is correct to address the issues, and that's where we are. The methodology is going to be finished this week. It'll be shared with all stakeholders, And my colleague Ryan can speak more to the technical detail of all of that in relation to marine mammals, but we're really positive that we're making good progress.
So when you say methodology, I'm trying to move things.
Yeah.
When you say methodology, is that something that could be completed within the course of the examination? Is it revisit? You're not
Yeah, we believe that we'll get agreement with DEFA on the methodology. Hopefully by the end of next week, the work will commence, and we think that we'll get everything submitted into examination by deadline 6.
Okay, excellent. Provided DEFRA are comfortable with that. Excellent, okay, nods around the table. I shall whiz through then. Okay, the Chair's asked for your observations on the workshop with the independent advisor and whether you're comfortable with them. The findings of the advisor.
Peter Duncan, DEFA. Yeah, it was a useful discussion. SMRU understood our position, but recognised that the applicant has undertaken a standard approach to it, and that there were limited options given the local data as well as the biological validity of the approach. However, they did come up with some options. I'll read it. An assessment of the scale of potential disturbance within Manx waters, which I think is approaching what we were seeking. So I think that's what the methodology is intended to do, and we will respond accordingly.
Okay.
Should the applicant's methodology meet whatever the recommendation the independent advisor suggests, do you think you'd be satisfied and generally matters will be agreed?
I think we would struggle to argue against that sort of expert advice. So,
excellent. Okay, thank you very much.
Yeah,
well, we're working hard to try and meet in the middle, so I think that this sounds like it's gone a good way towards it.
That sounds slightly ambiguous, but...
Sorry, Mr. Duncan, we missed that in the middle of our...
So, it sounded slightly ambiguous, but I think it's always best to reserve judgment until you see the...
What, if anything, are we expecting a deadline for on this matter?
Ryan McManus for the applicant. So a deadline for, we would anticipate submitting the method statement and the advice, the independent advice from SMRU Consulting.
Okay, all right.
And hopefully agreement with DEFA through the
oh, right, okay.
process.
So you're hoping to agree the method?
We're working through this like an update to the common ground, essentially.
Okay, excellent.
Is everyone comfortable before I move on, panel? You comfortable? No, let's do this. Okay, everyone happy? So the next issue that we've raised is, from reading all the responses, there appears to be confusion between the parties on magnitude and sensitivity and whether it applies to individuals or populations. And I think if we can get up... have I put the reference in here? I'm so sorry. I haven't put the reference in, so I think in Table 9, definition of terms relating to sensitivity of a receptor. Oh, there we go, thank you. This refers to individuals, but the subsequent text talks about the populations and the impacts on populations, so that's 84225, and I think this is about UXO. So I think there's been a bit of a mismatch between what the applicant's talking about and what DEFA interprets, because the comments coming back to us from DEFA think it's about population, individuals, but it's about populations. So I don't know if that's been resolved, or is that still under discussion? Applicant, sorry.
Ryan McManus for the applicant. I'm not sure if this has been resolved entirely through the statement of common ground. It did form part of the independent advice that SMRU Consulting provided. One of the recommendations was that the sensitivity criteria could be essentially fleshed out a little bit more, but overall they agreed that they were broadly appropriate and that it wouldn't result in any kind of change to the assessment conclusion. To clarify, all of the assessments in the EIA are made against the population level. That said, the sensitivity accounts for the sensitivity of the individual, particularly in regard to injurious effects, which are mitigated through the underwater noise mitigation. But
you can see the confusion with the table 9, which refers to the receptor rather than the population.
Yeah. In this case, the receptor is the relevant population of each species of marine mammal.
I understand, which is amplified by the text 84225 below. So I think, is DEFRA comfortable with that explanation? Would you like more explanation written into the methodology or a subsequent note?
Peter Duncan on behalf of DEFRA, I think it would be helpful to have it written down so we can understand it better.
Is that all right for the applicant to write a short note explaining that the assessment's about populations, even though Table 9 refers to a receptor, and how that works through in the application, particularly with UXO? I think it's specifically important, but could you do that for deadline 4?
Ryan, for the applicant, I think it's probably a relatively straightforward explanation.
I think it is, yeah.
So we propose covering that within the statement of common ground, perhaps.
Within it? Could you not provide a notice alongside it?
It would just be a single page document, probably.
I think, as DEFRA specifically asked for clarification, if you could write a short note after the hearing just to explain, because it's not a contested issue, but there's a mismatch of understanding. So if you could just, if it's 1 page. Sorry.
Sorry, Peter Duncan on behalf of DEFRA. I don't want to rake over old ground again, but I would be interested if that could include the idea or the reality that the Wildlife Act's protections, notwithstanding this application, etc., refers to disturbance and damage, etc., to individual animals. So the population versus individuals is important.
I understand. And the applicant does address that in their methodology, don't you, about individual animals as well. So I think if you could include that, what it means for the individual as opposed to the impact on the population.
Ryan, as for the applicant, it sounds like that's the purpose of this clarification, so
yes,
I'd be happy to include that explanation in the short note.
Is that all right? DEFRA comfortable? Okay. So if we move on, is the panel comfortable? Yeah. If we move on to the updated Level B harassment notes, so if you could put on screen figure 19 G3.6. So, yeah, and so if you could put first 19 from the application, figure 19, that's the new one, isn't it? That's 19G3.6. Oh, if you could put the application one on first, which is figure 19 from the application, marine mammals. That's okay. We'll talk about this one. So I think, don't worry, it's fine. So originally, the Level B harassment results were covered a much smaller area. So you've updated the Level B harassment results, and I think it was because you'd used 160 dBs LESS and not 160 SPL RMS. So you've taken on board that change. You've rerun the figures. If you find the other figure, then just let me know and you can put it up. But this is the new figures. So it shows that the boundary of impact has moved to the coastline, whereas before it didn't include the MNRs. It was just a small area around the array. So it does add a new dimension to the assessment, and you've correspondingly updated the figures and the reports and the results. And just to summarise, it means that those now impacted for disturbance from piling include Douglas Bay, Rhesus and Bottlenose, Laxley Bay, Bottlenose and Mink, Langness resource, Little Ness proposed MNR has also been added, Porpoise resource, and the new Bulgham Bay. So it is a different impact, and it's a worse impact. I think the applicants recognise that. So given these results, has DEFRA got anything to respond? I don't think it affects your outcomes, does it? You're still saying that the impacts are moderate but can be mitigated by the mitigation. Is that correct?
Ryan McManus for the applicant. So, yes, as you've set out, there's now essentially an additional impact to marine nature reserves, which wasn't included in the IA to these marine nature reserves. I think it's always worth bearing in mind the precaution that's in that model. The ranges are always unmitigated ranges based on maximum design scenario, etc.
Precaution noted.
So, and you're correct to state that the overall impact assessment conclusion remains non-significant, based on the fact that we do have mitigation in place to reduce noise through alternative piling scenarios, reduced hammer energies, etc. that will be confirmed in the detailed design phase. The other part to this is that this is quite a lot. This is also quite live to the updates we're making in response to the advice from SMRU Consulting, who actually advised that assessing the impacts to MNRs using this threshold was not necessarily the best way to do it, and to use a effective deterrent range approach instead would be more appropriate.
Right.
And so, while we've considered this within the marine mammal addendum that we've submitted at deadline 3, there is a further piece of work ongoing to basically update it again on the basis of the SMRU advice.
Okay, given that's in train, then we look at that advice when it comes, I think. But for now, this is what's in the examination, so this is what we need to play to, as it were. Has DEFRA got any comments on the Level B results and where we are at the moment?
Peter Duncan on behalf of DEFRA. I'd probably only add one clarification that marine mammal protection is no different within marine nature reserves than it is anywhere else in territorial sea. There's nothing particular about MNRs that makes them different in terms of marine mammals.
No, but they're one of the qualifying species.
Yeah, it kind of harks back to the discussion we had before.
It does, which is why it took a long time over the protected sites assessment, how it's constructed, objectives, the role of the Wildlife Act. That's why I went through all that this morning, to put that in play because of these results. Well, because it needed to happen anyway, but because of these results. I think one point, it's an observation. So Mona, for their UXO figures, were similar to Vannin, and they declared a significant effect. And so in their mitigation, they've got, I think, but don't quote me on this, additional mitigation for that effect. So I'm just raising this as an issue because it puts much more emphasis on the mitigation plans and proposals for this situation. Because I do feel the scenarios are almost similar. The plan's just gone up. You can see how the brown line was much smaller before. That's what that line's showing, that it didn't clip the coast for the 160. If you look at it, that's the pink line. Thank you. You can take it. Thank you very much. So I just come back to the importance of mitigation and for DEFRA to recognise how important the mitigation is. I know that you know that, but I'm just re-emphasising that because I think perhaps Mona were more, I don't know, they put more on the table at this stage. There's a couple of points of clarification that I want to raise. One is that there's a change in population size, which you probably know, and I'm not quite sure what that's about. So I can read it out, but perhaps you can just respond to it. The applicant has changed the population size of bottlenose dolphins, for which the impacts are being assessed, from 293 animals in Chapter 5 to is it to 8,326? Is that correct? Okay. This means the number of mammals impacted is 499 instead of 521, which is a significant change. I don't want to go through that now. Do you want to explain that now, or do you want to provide a note on it?
Happy to explain it
Okay.
now. So if I can just take the UXO point first, and then
thank you very much. I'm sorry I didn't get back to you on that. I do apologise.
Just to confirm that in the assessment of underwater noise, we have actually predicted a moderate adverse effect in relation to UXO, and also point to the further mitigation in the underwater noise management strategy, which includes a UXO specific marine mammal mitigation protocol.
So you've declared a significant effect for that. I'm so sorry, exactly. I missed that completely. I do apologise. That's mine. Okay, carry on.
And then in relation to the updated population size, this is quite a complicated thing, because it's essentially because of the timing of when these data sets become available. So at the time that the assessment was undertaken, which was in the latter half of 2024 and finalised in early 2025 before it was submitted, the density estimates from scans 4 were available, but the population for scans 4 were available, but the population estimate was not available. So we had a case where and this is acknowledged in the assessment chapter as well, it's described in there, that we were basing the impact in terms of the number of animals impacted on a relatively higher density from scans 4, but comparing that impact to a comparatively lower population from scans 3. Now that the population update has been made from scans 4, it's essentially the same number of animals impacted, but out of a larger population. So the population impact will reduce quite substantially when this is taken account in the updated assessment that's also going in with this SMRU consulting advice, because that was also an observation that they had that would be worth exploring.
I'd like you to provide a note to explain that, because it is quite complex and it is a big change. I understand the scans 3, scans 4 wasn't available when you did the assessment, so I understand that. Just
to confirm that will be in the SMRU consulting advice and our position paper that we're submitting at deadline 4.
You'll include that in that? Okay, right. Does DEFA have any comment on that? No, okay. But it'll be in the paper anyway, so you'll be able to explain it. So there's 2 items left. The next one's mitigation. And given the moderate impacts on marine mammals, which you've made evident in the assessment, and the updated level B harassment work, I think we're now looking to the confidence in the mitigation to mitigate the impacts. And I think this is probably one of the key, I wouldn't say the most important, because but I think it's one of the key issues across the EIA. I don't know if DEFA agree that the mitigation will actually mitigate the impacts. And you did say in your response to JNCC that you would look at this, you would look at testing the mitigation. I think you've also referred to it somewhere else in the assessment. I can't find the reference, I do apologise. But so if you haven't tested it already, which I don't think you've put in front of the examination, can you explain how you're going to test now, or whenever you get the right results in the right place, because you just explained that you're updating them, how we will test how the mitigation will work to reduce the moderate effects that you now have in quite a few areas for marine mammals down to not significant.
Brian McManus for the applicant. So the piece of ongoing work relates to updated noise modelling, considering noise abatement system scenarios.
Yes,
that modelling takes quite a bit of time. It is ongoing, and we did originally hope to submit it earlier, but it should be going in for deadline 4, and that will essentially compare the maximum design unmitigated ranges with reduced ranges from noise abated scenarios to demonstrate the efficacy of those noise abatement systems that are described within the underwater noise management strategy, and it's based on real world observations from where these systems have been deployed and where noise measurements have been taken from the construction of other offshore wind farms. In terms of Ørsted's and the industry's experience in the efficacy of these systems. Dr. Caron might be able to speak to the construction experience that Ørsted and the applicant has in delivering these, and why we have confidence that it can work.
Does Dr. Caroline want to expand on that?
Yeah, Dr. Caron on behalf of the applicant. Yeah, just to build slightly on that, it's Ørsted obviously is the world leader in building offshore wind farms. We've got 12 operational ones in the UK. 2 ones that are really pertinent to this development would be Hornsea 1 and Hornsea 2, which were within the Southern North Sea SSE. So we have experience of mitigating significant impacts within highly sensitive sites. All of our projects we've been able to build with no adverse effect on protected species. So we're quite confident that the mitigation measures that we have proposed in the underwater noise mitigation strategy will allow us to basically bring the project forth with no significant effect. And the noise efficacy paper will basically demonstrate the efficacy of all of those mitigation measures, which we will select the most appropriate one closer to the time of construction, the one that's most appropriate for each species.
So are you producing the results of your testing of this mitigation you're proposing, and when will that be available? Is that deadline 4?
Ryan McManus for the applicant. Yes, we're aiming for deadline 4.
Okay, yeah. So if you produce that, then we can move on to the monitoring. I will talk about the monitoring in a minute, but it seems like a reasonable flow of activity to finalise these plans. So if I hand to DEFRA, are they comfortable with us testing whether the mitigation will work and the methodology that's being used?
Peter Duncan, DEFRA. We're comfortable with that, recognising it's a theoretical exercise, which then gets on to the monitoring, which is, I'd be interested to know how you know that it has no effect until you take empirical data. So that would be our position.
Do you need to understand the work that's being done to test this? Or would you just...
It may be helpful to be briefed on it, certainly, because that may then inform appropriate monitoring.
Understood, yeah.
Development
so
of.
Is it possible to share the method that you're using to test the mitigation? Not the results, but just what you're doing, the process.
Dr. Caron on behalf of the applicant. The method is the noise model, so we can share the methodology from the noise model setup, its validation, all of the real world measurements that go into that model. So that goes in to establish what the baseline conditions are. And then we have real world monitoring of the efficacy of those technologies. So that's what feeds into the model, so we can share all of that. Typically what happens, we don't give real world evidence to DEFRA to satisfy them at this stage, but we can provide that information, what goes into the model. And typically what you would have as a condition to monitor, say the first be that 3 or 4 foundation installation to validate the findings of the model and the efficacy of the noise mitigation. And that's just a standard that would typically be a marine license condition. So similar, I think, we can have within.
So it tests decibel reductions based on activities like cameras?
Yeah.
Okay.
Yeah.
So could you just provide a one-page summary of what you're doing so DEFRA understand?
We will provide the noise model outputs, and we can provide a detailed methodology of basically the inputs to that model and how the model works.
Okay.
So that you can have some confidence in the model outputs, by all means.
That'd be really helpful. Could you submit that? Oh, I'm sorry, I'm talking over you. Can you submit that after the hearing as soon as you can, just so we can have a look? DEFRA can look.
I'll need a check with our noise consultant to see if it's something they can prepare quickly.
Thank you so much.
But yeah, we'll get it in as quickly as possible.
Thank you, because then DEFRA can have a look at that if the results are coming by deadline 4. Thank you so much. Is DEFRA comfortable with that, so you get sight of it?
Yep. Yeah,
okay.
That's fine.
Okay. So if you move on to mitigation then. So as I understand it, in basic sense, monitoring. You'll monitor the first 4 piles. Is that how it normally works?
Dr. Caron on behalf of that, that's how it normally works under a marine license condition in the DCO, but I don't know if that what we have within our consent. Ms. Sterling can speak to that.
Could I just, before you answer that question, Ms. Irving, and is there a mechanism so that you test for noisy piles, not just for really quiet small ones? that makes any kind of sense.
Hey, Dr. Kieran, on behalf of the applicant, they're all the same.
Okay.
So it's basically, it's typically the first 4 or the first 3 is the first number, but if in consultation with DEFA they felt that some were basically more noisy than others, then we could select on them.
I didn't know whether they were different sizes. Well, thank you so much. If you like, Ms. Irving.
Amy Sterling, on behalf of the applicant, yes, section 3.7 of the outline underwater noise management strategy makes a commitment to noise monitoring. It sets out that noise monitoring is typically undertaken on the first 4 piles of each pile type.
Okay.
So regardless of the pile type, it would be the first 4 of that.
Thank you. So beyond that, at the moment, there's no additional monitoring. Is that right? Okay. So
Ryan McManus for the applicant.
Go ahead.
So there's no additional monitoring proposed to essentially validate or address any uncertainty in the IA. There will be monitoring during the construction phase, during piling, in the form of marine mammal observers, which is in the underwater noise management strategy as well, and that's basically to confirm the efficacy of acoustic deterrent devices and any soft start that's going to confirm that there are confirm that there are no marine mammals within the mitigation zone.
Okay.
But then that's construction monitoring, but beyond that, no additional monitoring proposed.
So, as I understand it, and I'm prepared to be corrected on this, I think some wind farms do monitoring. I'm not suggesting you do that right now, but I'm just tabling this. So East Anglia 1 and 3, Moray, Firth of 4th, East Anglia 12, they did 12 I think, but Dr. Callan probably has more than me, 12 passive acoustics monitoring stations, 1 year baseline, full construction period, 1 year post. So I'm just putting that on the table, and I'm asking the applicant to comment on that. Is that something that you've done on your other wind farms, or is it always the 4 piles and the observers?
Dr. Kieran, on behalf of the applicant, that's not something that we have done as standard across our wind farms, but we are aware of some wind farms in sensitive locations then doing that, yeah. So but it's not something that we've had to do across the board.
When you say across the board, have you done it on any of your wind farms?
Not that I'm aware of, but I can ask some of my colleagues, not on the ones I've worked on, but
Understand.
that's quite, I've only worked on about 5, so...
Okay, I think it's one for DEFA to consider, given the location against the UK, is it SAC, I think, adjusting your boundary, given the MNRs, given the level B harassment new results. So I'm not going to discuss that further now. I've explained, we've understood what you are proposing. I've put on the table what I understand other wind farms do, and I'm quite happy to be corrected if I misunderstood the terms of the year before, the year after. Could DEFA take that away and think about it, please? And could you engage on that in your SOCG process and report back on where you get to? I think my colleague just wants to say something. I'm sorry, excuse me.
Can I just request that when you look at this monitoring that Ms. Pownell has just suggested from the East Anglia 1 and 3, also consider the adversity of the effect on marine mammals and see what that comparison was when you look at that marine mammal monitoring plan. So I think that comparison on both, on both accounts would be really helpful to be considered. Okay.
Dr. Kieran, on behalf of the applicant, just in relation to East Anglia projects, now I can understand why that one's being referred to, but it is within the Southern North Sea SSE, so it's a highly sensitive site, so it has different objectives and different criteria that don't apply to the Isle of Man across the board, and I think that's something to be very mindful of. So while we can do that comparison, would also be a comparison of another sort of equitable wind farm to what Mooir Vannin would be in terms of policy protection and stuff, would be beneficial to compare both of those to see what the monitoring requirements are for both.
That sounds reasonable.
Yeah.
I mentioned a couple of other ones, so if you could just do a broad spectrum search to see what ones do pile monitoring and do a comparative analysis, that would be helpful.
And I think you're absolutely right. I think that's a very valid point, that is within the SAC, so very sensitive, etc. But there is a certain, I think this is one end of the spectrum in terms of the monitoring plan. So you're absolutely right. If you look for one or two more, which are more comparable to more Vannin, but don't lose this one, just so that we have the other end of the spectrum as well, both in terms of the sensitivity of the space, the adversity of the effect, and therefore the monitoring proposed.
Happy to do that.
Thank you very much. I'm so sorry, Manx Wildlife Trust has something to say.
Laura Howe, Manx Wildlife Trust. Just further to what's been discussed, we've made reference to Southsea SAC in the North Sea there, and they have restrictions around temporal and spatial thresholds for harbour porpoise, which is quite interesting. And there are a couple of points here that although we don't have SACs in Manx waters, we still have harbour porpoise. We're also a really important area that was recently highlighted by IMMEA being an important marine mammal area. So why can't we take these kind of thresholds, these spatial and temporal thresholds, and apply them to the Isle of Man? Obviously, we've not been privy to the discussions that have been going on between SMRU and the applicant and DEFA, so I'm not sure what's been discussed. But why can't these kind of thresholds be applied to the Isle of Man and our harbour porpoise populations?
I think if you pick that up with DEFA, because they're anchoring the discussions on this monitoring issue, and feed that into the conversation between DEFA and the applicant, that would be really helpful. Is that all right with DEFA?
Ken will represent DEFA, that's okay, yeah.
Okay, that's perfect, then that will feed it into the process.
Amy Sterling on behalf of the applicant, if I may, Madam. I think it's just really important to note, it's of course not the role of this examination to set the law in the Isle of Man. The Isle of Man government, it would have been open to Isle of Man government to have a habitats regulations assessment legislation and to have SACs and SPAs in a functioning legal regime. They do not have that, and it wouldn't be appropriate to take UK law and just apply it to the Isle of Man in the context of this examination.
I agree, that's noted.
Could I make Peter Duncan, DEFA? I would note that those species are protected under the Wildlife Act, so the spatial protection for them doesn't particularly matter.
I think your point's noted. I think we're talking about monitoring here, and I think we've had a productive discussion on the monitoring, and we've worked out a way forwards. So Manx Wildlife Trust can feed in their information to DEFA, and DEFA can continue to discuss it with the applicant.
Dr. Kieran, on behalf of that, this is my last point, just in relation to the monitoring and the other projects that we're going to look at. We will when we do our noise efficacy work, we will apply across the board noise mitigation to reduce our impacts to non-significant levels. We don't know really what the other projects were, whether they had noise protocols the same, and hence they may have had other mitigation and monitoring requirements, and so it's just something to bear in mind that we will deploy a noise abatement system to reduce that noise to non-significant levels.
That's noted, thank you. That's the last issue on the agenda, unless anyone else has got anything to say. Applicant, hand in the audience. Audience sounds the wrong word, I do apologise. Do come forward, I think microphone's coming to you now.
Thanks very much. Georgina O'Sullivan, resident of Garth. Not an acoustic noise specialist in any shape or form, but something that's coming up more and more now across the world stage is the subject of infrasound and vibration. Levels of sound below 20 hertz, which up until recently has not been able to be monitored successfully, but is now proven to have some significant effects in terms of health issues for basically, it says all living organisms. I'm just wondering, is the infrasound and vibration from the construction operation of the wind farm taken into account in your noise mitigations? And is there any way to mitigate it?
Someone for the applicant?
Dr. Kieran, on behalf of the applicant, it's a new and emerging area and something that we have no agreed approach upon methodology, assessment or mitigation. That's something that we continue to watch, and as there's and agreed upon methodology and approach, then we're happy to partake in that. At the moment, we're not aware of any issue with offshore wind farms and generation of infrasound and the impacts on human health. It's not something that we're aware of, or it's not something that any other offshore wind farms that the industry has assessed. So it's a new and emerging area, and we watch with interest.
Okay. Is there something you'd like to submit to the hearing so we can look at the information?
Yes, indeed. But if I might just quickly mention
go ahead.
that this is new and emergent, as you say, as of October 2025, and as of March 24th, Professor Ken Matson of Uppsala University submitted a paper and scientifically peer-reviewed research at the European Commission at a conference, and the title of that was "Just because you can't hear it doesn't mean it doesn't harm you." And this was principally talking about human issues regarding wind turbines in general, but it covered both onshore and offshore. And we're working with Professor Matson and his group ProNumerics, and there were 4 or 5 topics that he suggested we cover. Now, I don't know whether you want to cover that today, or if you want me to issue something to you to discuss at a later time.
I think if you submit it to the panel as part of a hearing submission, we can go through it. We read all submissions that come to us, and then we can decide how to progress it.
Thank you. And I do understand that we're talking about marine mammals, but is there going to be a point in the examination where we're looking at human health and the future health of the Isle of Man people?
So all the issues are discussed as part of the examination process. The panel consider all information that's presented to them. Right. The hearings are chosen on the basis of key issues that we want to resolve between all parties. Right. So they're the table for all party discussions. You can see today we're working hard to move things forward between parties. Mm-hmm. So the issue is being examined. Right. It just hasn't been at a hearing yet, and we haven't decided the hearing agenda for the next hearings, so you'll see that when it's published.
Thank you. Obviously human health is a very big important.
I understand.
Value. Thank you.
There's another hand, sorry.
Hi, Carlton Freegard, also a resident of Garth. That previous comment sparked something from my memory when there was work going on in Douglas Bay in relation to the shipping lanes. Quite a number of the houses in Douglas experienced problems from the vibration. Is there likely to be anything that could damage any properties along the seafront? Not necessarily in Douglas, but along the whole of the where the turbines are supposed to be being drilled.
Okay, I understand. Yeah. I'll take your question to the applicant, and then I think we'll move and close the hearing because it's the end of the day and it's the last question. So, if the applicant would respond.
Dr. Carroll, on behalf of the applicant, as far as we're aware, we don't know of any of our offshore construction activities that could be detrimental to residential properties. The only thing that I'm aware of that can be an issue is the noise. Sometimes noise and vibration from an offshore wind farm, depending on the atmospheric conditions, it can be something that can be an issue. That's it. I'm not aware of any structural or vibrational thing, maybe from onshore construction traffic and things like that. But offshore construction it's over 12 kilometres away, so the vibration from piling activity and things would dissipate well before it had got there. So from an offshore construction perspective, we're not aware of anything, only noise. Yeah.
Okay, thank you. I think that's the last question of the day. I think we've been through the agenda, we've focused on a lot of issues and worked them through, so I want to thank everybody for coming. I think it's been a really productive day. I'll just ask my panel if there's any other questions they want to ask before we close. So I'll hand back to the chair to wrap up the day.
Thank you very much, and thanks from me as well and from the entire panel for your participation. I think we made great progress. Hearing actions, like for the other 3 hearings, will be issued by the end of the week, so look out for those. So unless anyone is looking for clarification on the actions, and I don't see any hands up going up, So it is 35 minutes past 5 p.m. and specific issue hearing 6 is now closed. Many thanks.